I got one back there. I want that.
All right, yes.
There. Third one, yes.
Okay, please be seated. All right, good morning, members of the jury. I was pleasantly surprised that we didn't have the icy roads that we thought we were going to. So, all right, does the state have any further witnesses?
Good morning. No, Your Honor, the state rests.
Okay, members of the jury, I need you to step out for a couple of minutes, about 10 minutes. All right, please be seated. Okay, Mr. Ng, you had a matter that you wanted to bring up.
Your Honor, the state has now rested. The defense moves for a judgment of acquittal. I realize that the facts are construed most favorably to a potential verdict and consistent with the guilt. On the other hand, the testimony is confusing at best. The theory advanced yesterday is that a taser was inappropriate to be used. That was an opinion of Mr. Stoughton. The testimony, though, has been that the taser was reasonable to be used. So the state has presented witness after witness, either on cross or direct. I'm speaking of Peterson Lucky, for example, who've indicated that the taser was quite reasonable to use, should have been used. I think they were pleased that it was used, or at least something was done. So we have a sort of this discordant presentation. I mean, if the theory of the government is that the taser is inappropriate, then they've presented conflicting evidence to that opinion. If the theory of the government is that the taser was appropriate, then the expert's opinion is inappropriate. And that also goes for the use of deadly force as well. I mean, we have Johnson's testimony and Fleshling's testimony. Then we have Stoughton's testimony. So it's a confusing mess, really. And I say that in all due respect to my colleagues on the other side. When you denied our motion for the judgment of acquittal on the manslaughter count, one, the opinion was, of course, thorough and well done, but it also commented how the probable cause standard is quite de minimis compared to the standard of proofs beyond a reasonable doubt. And so they still have to show that, at the moment, and it is a standard at the moment, she thought she was employing her taser, and everybody agrees to that she had a knowledge that she was about to commit a violent act, and with that knowledge, however obtained, disregarded that knowledge. That's really a high burden to meet under those cases we've been talking about. So while the probable cause was perhaps suitable to satisfy both charges, which are related to each other, really. I mean, the consciousness of guilt and the first degree standard are quite similar. The evidence in our view is insufficient. And we request that you dismiss both counts, but particularly the man one count, which the court had already discerned is quite weak. And nothing has happened here to make it stronger. I also want to make an offer of proof consistent with what we were talking about yesterday. I can do that now or wait on that. I defer to the court's discretion.
Okay,
on
why
that.
don't we let the state respond to the motion for judgment of acquittal first?
Thank you, Your Honor. My understanding,
Sorry.
habits, yeah. Your Honor, the standard for taking a case from the jury's hands is actually quite high. I think the court has to basically issue a summary judgment that there's no way under the set of facts presented to the jury they could arrive at a guilty verdict. That certainly has not been met here. I take it from counsel's argument that the real challenge is to the recklessness or carelessness elements of the statutes. I know there have been arguments made about causation, and I'm sure will be made, but pretty clear the testimony that the court heard was that the bullet that Ms. Potter fired into Mr. Wright's chest blew up his heart and killed him within minutes. That's causation. The elements of recklessness, Your Honor, as you know from the jury instructions you've crafted carefully, talks about a reckless handling or use of a firearm for the first-degree manslaughter charge. Here we have a 26-year veteran of the police department who was trained every year in how to handle her firearm and had to qualify every year to handle her firearm, carried it when she was on duty, and yet did not know she had her gun in her hand when she shot Mr. Wright. I think the facts bear that out on her statement alone, which the court and the jury has seen. That is raises the issue of the recklessness of her act. She committed a conscious or intentional act in drawing the firearm. There was evidence that she prepared to do that. She pulled it out of her holster, pointed it directly at Mr. Wright, and fired it without knowing it was her handgun can only be said to be reckless in and of itself, and certainly is something for the jury to consider. The second-degree manslaughter charge has culpable negligence, which is that the defendant did not intend the act to be harmful, but that an ordinary and reasonable person would have recognized the actions created a strong probability of injury to others. That is an awareness of the risk and a disregard of it. Again, speaking with respect to the decision to use a taser and instead using her firearm, which really applies also to both counts. She has been trained multiple times over her 26-year career, certified as a taser user since 2002, received trainings that the jury has seen, the court has seen regarding weapons confusion. It was an issue known to everybody in law enforcement. It was taught to her multiple times. She was aware of it, therefore, as the evidence, and by pulling her firearm instead, and acknowledging that she knew about weapons confusion in the sense that she had been trained on a taser. She knew enough to give a verbal warning for that taser. Shows intentional conduct that was done with an awareness of the risk and a complete disregard for the risk. Those are the basic, as I understand the motion, contested elements. There's certainly sufficient evidence. The state did not present conflicting evidence. I think what counsel is referring to is the evidence they led witnesses into saying, which I think where it was impeached. And if there are conflicting pieces of evidence, that's for juries to weigh. So the defense has not established a basis for their motion to be granted today because there is adequate evidence for the case to go to the jury. We would ask the court to deny the motion.
Okay. A judgment of acquittal can't be granted unless the trier of fact could not reasonably find the essential elements of the crime are established beyond a reasonable doubt. In ruling on that motion, all reasonable inferences and the evidence has to be viewed in the light most favorable to the state. That's the standard, and given that standard, I'm denying the motion for an acquittal. A couple matters from yesterday. I am going to allow the defense expert to testify about deadly force. Okay, that was a topic that was extensively covered by the state's expert. There's no prejudice to the state, obviously, to have the expert testify on deadly force, and there really are no surprises on what the expert's going to say. Then, Mr. Gray, I think you wanted to be heard on...
Should I go to the podium?
Yes, please.
Good morning again, Your Honor. Your Honor, I gave you exhibit, I can't remember the number of it. The exhibit is a certified copy of the conviction of Mrs. Wright, the first witness. You might recall, Judge, that before the trial, Your Honor ruled that we could bring up the fact that a felony conviction was, that she was convicted of a felony convictions, and the date of it was within the requirements of the law. Well, the state, in their presentation, said to the witness, well, you were convicted of a second-degree drug offense, weren't you? Something to that effect, which was not the judge's ruling. The judge ruled that you could just say felony conviction. And instead of embarrassing the witness more than need be, we refrained to get up, we restrained getting up and pointing out that the conviction was, I think, about a year ago, that she was convicted of this felony. Rather than do that, we decided to offer into evidence, since they now have presented the conviction, the court knows that they can do that, or we should be the ones that can do it within the time period required by law, that we would have a right to show the date of the conviction, because the jury has no idea when this conviction occurred. So we waited until we presented our case. We obtained, excuse me, Your Honor, we obtained a certified copy of the conviction, which is admissible under the rules of evidence, and it's self-authenticating, and we offer it as an exhibit. Thank you, Your Honor.
All right.
Excuse me, I'm sorry. For the purpose of showing that when she was convicted of the felony of drugs. If they're willing to stipulate to that, we don't need it. But if they're not willing to stipulate to the date that she was convicted of this, then we need it to prove it. Thank you.
Okay, you're not going to bring it up in your case in chief, obviously, are you?
No, I need that to show the date that she was convicted.
Okay. Does the state object?
Yes, Your Honor, the state objects. The court's prior ruling was that if Ms. Bryant was other than a spark of life witness, that she could potentially be impeached with an unspecified felony. That's how the court characterized it in the court's order. On direct, the state fronted the fact that there had been a conviction, which I believe was characterized as a felony conviction for second-degree controlled substance possession. That was fronted. Counsel had the opportunity to cross-examine on that point if it desired at that point, if the defense so desired. This issue was not raised at that time. Defense counsel essentially waived any right to cross-examine on that point. We fronted information that went beyond what was required under the court's ruling. That, however, does not supplant the court's direction, which was essentially that under the rules, the court has already decided that extrinsic evidence or other unrelated information about this conviction is clearly improper here. Had counsel wanted to inquire about the date of conviction at the time, I don't know that we would have taken issue with it. But at this point, with no foundation, with no witness, they now want to offer evidence, extrinsic evidence of a conviction that has absolutely nothing to do with the issues in this case, is completely collateral, is completely improper at this point. And we'd object, Your Honor.
Well, Your Honor, it's self-authenticating. We didn't cross-examine her on it because we followed the court's ruling. And what we're doing is attempting to show the date, and the date is shown on that without asking her a question. I was actually surprised when the state asked her, were you convicted of a second-degree drug conviction? I thought that was a violation of the court's rule, as they were convicted of a felony. But they did that. I would not know what she would say as far as a date because I didn't ask it because of the fact I didn't want to further embarrass her. But we have the certified copy of the conviction. If they're willing to stipulate to the date of the conviction, we don't need it. But if they're not, we have a right to present evidence of the date of the conviction. It's not impeachment. It's our case in chief.
Your Honor, counsel had an opportunity to raise this issue, to bring this issue to the court's attention, to address any questions about date. I have not. I believe that counsel walked in with a copy of the conviction, showed it to my colleague at counsel table, and handed it to the court. My understanding is that document, although I don't have a copy myself, includes a lot of information that clearly does not pertain to the date of conviction. I presume it has information about, plea and sentence and things that clearly are not within the purview of the rule that governs prior convictions. And I do want to point out for the court that the court's original ruling was that there was essentially very little room for defense counsel to even inquire about this. We fronted it because we wanted to do that out of an abundance of caution, the fact of conviction. But other than the fact of conviction, none of this is relevant, Your Honor. And we object strongly.
Oh,
Well, they brought it up, Judge. We have a right to show the date.
okay. You had the right to show the date at the time that you cross-examined.
Well,
That's
I
right.
could have asked her, but that would have been in violation of your rule about a felony. I wasn't going to violate your rule, even though they did.
I'm not going to let this in.
Could we have a stipulation that would be allowed to stipulate as to the date of the conviction?
Is the state willing to just acknowledge the date of the conviction?
No, Your Honor. There's absolutely no basis for us to do that at this point.
And of course, the state is interested in justice, like they're supposed to.
Okay. All right. All right. The admission of this exhibit will be denied. It's marked 1007. Okay, Mr. Frank?
I'm being presumptuous, Your Honor, that I may address the court.
Yes?
I think, as you know, as a trial judge of many years, the certified copy of the conviction is used to impeach the witness if they deny the conviction. It doesn't go in as a substantive exhibit itself, so even the process here is completely wrong. But I understand the court's ruling. I just want to point that out, that to me, it's somewhat disingenuous to say we didn't want to embarrass her then because they didn't want to ask her while she was on the stand and look a certain way. Now they want to do it. Anyway, I'm
Well,
sorry.
you guys, I think we spent way too much time arguing this point, which is totally collateral.
Thank you, Your Honor.
Okay.
I'm sorry. Your Honor, I indicated to the court yesterday that we would object to Mr. Imes testifying about deadly force opinion. I raised it so the court would be aware of it, that we would need time, but I do want to address it because I think it goes simply beyond what was raised yesterday about it. Your Honor, we received an order from the court. The court filed back in August, I believe. June 2nd of 2021 with an expert disclosure deadline.
Yeah, I already ruled on this.
But I haven't had an opportunity to be heard, Your Honor, and I think we have an opportunity to be heard. That's why I fronted it yesterday to say we need time this morning to address this. Because you will also recall, well, maybe you don't know this, but Mr. Eng and Mr. Gray were going to meet with Mr. Imes last night. We have an additional disclosure. And so I want to address this because what we have here is flouting of the rules in the court's order. And the prejudice comes from not knowing what this witness is going to say, not what we know our own witness is going to say. So I would like to address that, Your Honor.
I'll let you continue. I didn't let you argue this morning on that point, but go ahead.
Thank you, Your Honor. The court's order required and cited to the rules of criminal procedure that require it as well, that disclosures of experts would be made by October 15th of 2021, and any rebuttal to those disclosures would be made within 30 days. The disclosure required all findings, opinions, or conclusions to which each expert is expected to testify and the basis for their findings, opinions, and testimony. Purposes for that are obvious, so that there is notice to be prepared for trial so the opponent can fairly meet the evidence that is going to be presented. As we recall yesterday, Mr. Gray objected because the witness had used one word, subjectivity, or subjective, that he couldn't find in the report. And at that
Actually,
point,
that is what I brought up, not Mr. Gray. Okay.
he brought the objection up and the court asked that. And what the court had said at that time, if it's not in the report, you're not going to allow it for testimony. Your Honor, here is our expert's report. It's 52 pages long, single-spaced. It's very thorough. It has captions, headings, opinions, explanations, the basis, all set forth in these 52 pages. The report that was disclosed to us from Mr. Imes is a little over 2 pages long, Your Honor. The opinions in it really encompass less than 1 page. Most of them, in fact all of them, are very conclusory and simply state in one sentence an opinion. No basis for that, no discussion of what they will testify to support that opinion. I believe you have a copy of this. You're familiar with it. It is, to say the least, conclusory. The disclosure that the defense provided, Mr. Eng signed and filed, says simply that Mr. Imes will testify that Officer Potter's decision to use a taser was appropriate and consistent with standard training and police procedure. Nothing about deadly force or the use of a firearm. Your Honor, before trial, when we met with our expert witness, this is a copy of what we disclosed to the defense. It's thorough, and according to Mr. Eng, painfully thorough, 4 pages long, single-spaced, with a complete description of our conversation with the expert at that time, or complying with disclosure requirements about what our witness will testify to. Last night, I received an email from Mr. Eng. He sent it at 7:24 p.m., but I didn't see it until about 9:30 p.m. because I have a home life, right? Get to go home and have a home life, so I didn't see it till 9:30 last night. It contains 6 sentences, 6 numbered sentences. I'm sorry, one is actually 2 sentences, but in 6 numbered lines that are single, conclusory statements about what Mr. Imes apparently is going to testify about. No explanation of the bases for that or what else he will testify about. So what we have, Your Honor, and yesterday, and I have a copy for this if the court would like it, and so we have been given no knowledge, no information about what Mr. Imes is going to rely on to support his opinions. We just have these conclusory statements. There's nothing in the reports or this follow-up about his basis for the deadly force opinion. We disclosed our expert's report that has 3 or 4 pages on deadly force back in October as we were supposed to, And they were clearly on notice then that deadly force was an issue. They requested a jury instruction on deadly force, and yet we're getting disclosures about a deadly force opinion on the night before this witness is supposed to testify in the morning. Your Honor, this relatedly, the defense intends to call Tim Gannon today. The disclosure we got from Tim Gannon, November 8th, is provided by defense counsel when they met with him. It's a page and a half, and it is woefully inadequate. And just sort of interestingly, like the very first paragraph says, we talked with him about his education, his law enforcement career, working relationship with Officer Potter, mentions that she was the union representative, and then just says, were summarized. So rather than telling us what information they got, it just says that it was summarized. We didn't get the summary. It goes on, Your Honor, to present very conclusory statements. The close proximity of her taser to Mr. Wright was not concerning under the circumstances presented, period. No basis for that opinion, no foundation for that opinion. Goes on to say her assumed use of the taser was reasonable and appropriate. No explanation as to the basis for that opinion or why he would offer that opinion. Then, Your Honor, we got a disclosure from an interview with Mr. Gannon on December 6th of 2000, so after trial had technically started, where he now, Mr. Gannon will offer an opinion about deadly force. Little to no explanation of the basis for that opinion, his foundation for that opinion, and so, again, what we're getting is they didn't have an expert talk about deadly force. Now they're trying to turn a former police officer who worked with Ms. Potter into an unnoticed expert witness who's going to offer an opinion in violation of the court's disclosure order and without what is required by the rule in the court's order as to disclosures for such opinions, even setting aside whether it's appropriate for a lay witness to offer a legal opinion as an expert. We followed the rule in the court's order to disclose our expert. Now they're trying to slip in somebody because they didn't. What we're seeing, Your Honor, is a pattern of flouting the court's orders and the rules and trying to litigate by surprise, not doing proper disclosures, not doing full disclosures, and just putting up a witness without letting us know, being able to fairly meet that testimony. That's not what the rules provide. Your Honor, and this is not, Your Honor, ineffective assistance of counsel. I am not concerned about that because this is strategic, this is tactical, this is effective assistance of counsel. They are trying to represent their client in a way that the rules don't provide, but which gives them an advantage. We are asking, Your Honor, to not allow Mr. Imes to testify at all because the proper disclosures were never made about the substance of his opinion, the support for his opinion, including the disclosure made last night that I, again, saw at 9:30 p.m. At a minimum, he should not be allowed to testify to anything, as the court said, that is not in his report. We don't expect that every word a witness says on the stand is going to be in the disclosures, but we expect the substance of it to be. I think the court recognized that yesterday in first raising the concern and then recognizing that the substance was there. And so what we're being required to do today is litigate without proper notice provided by the rules in the court's order. So we are asking you to prohibit his testimony, Mr. Imes, at a minimum to limit it to exactly what is the conclusions in his the only disclosures we got. And with respect to Mr. Gannon, first of all, to not allow an expert opinion. We have objected in the past to allowing lay witnesses who are fact witnesses to come in and testify to opinions. I think the court's ruling was that they could testify that what Officer Potter did was consistent with their training. We still object to that, but we more strenuously object to allowing them to offer an expert opinion about whether it was reasonable. It's a legal conclusion. it's subject for an expert opinion, as we have done, not for sneaking a witness in to do it. And we would ask the court to not allow former Officer Gannon to testify to his opinion about deadly force. So that is our motion, Your Honor, this morning. And unless the court has questions, I'll leave it at that.
Mr. Rain, did you want to respond?
Well, we had a discussion about this yesterday in terms of Chief Gannon, former Chief Gannon. He's a lay witness. He's not an expert witness. He has more training at 25 years than Mr. Stoughton at 5 years. And, we met with him, and the state finally gave us their voluminous jury exhibits. We showed him a couple more exhibits than he had. And we asked him, what his view of it was, and you've already ruled that he's qualified. And if they have a problem with Mr. Gannon, they could have called him. I mean, he certainly would have interviewed with him. They didn't make any attempt. In terms of the Iams testimony, we believe in brevity rather than a 50-page report. Mr. Iams is not charging us anything. I gave a detailed summary. There was no objection to it. They never complained about it until today. We did meet with him last night to go over the Stoughton testimony on the points he would disagree with. And as I mentioned yesterday, an expert's entitled to listen to the whole trial, and he has listened to the critical evidence, namely Lucky, Johnson, the trainers, and Stoughton. The rest of it's kind of fluff, really. DNA, really? Firearms evaluation, really? And so he has, 98% of what I was going to ask him was about the taser, but, they've opened the door here. The Stoughton testimony, and particularly the Johnson testimony, is critical. He was unaware of it, and so he's going to answer it. And it's not going to be extensive. But I find, there's no prejudice to them whatsoever. We just got 3 hours of Stoughton. I'm going to get a little bit of time on Iams. And again, if they had a problem with it, they should have told us about it beforehand, or at least called him. I mean, he's quite accessible, as you'll see. So, it's much ado about nothing, and we appreciate your ruling. It should stand. I mean, this is the pattern that the state repeats over and over again. They don't get a ruling. They spend 20 minutes lecturing you on why your ruling's wrong. And then here we are at 9:40 when we're ready to go. So, we're ready to go.
All right. Let's deal with the expert first. I am going to allow the defense expert to testify about deadly force. Mainly because there's really no prejudice here. The basis of his opinion are the facts in the case. And generally speaking, the facts in the case are really not in dispute. So, absent prejudice to the state, and I think it's legitimate to have a defense expert respond to claims that were made during the trial, I'm going to let him testify as to deadly force. With respect to former Chief of Police Gannon, I previously ruled that police officers could testify that conduct was in accordance with their training. I also believe that the chief of police in this situation should be able to testify whether or not, under the facts presented, this was improper, inconsistent with Officer Potter's training, and unreasonable force. He's the chief of police. I mean, I'm assuming he got that position because of his training and his knowledge of what is or is not proper to do as a police officer. Okay, let's get the jury in. Thank you, Deputy. Oh, excuse me. Can you tell the deputy hold up one moment? Oh, okay, just one moment. I just wanted to cover one thing. Ms. Potter, do you still want to testify, or have you changed your mind?
Yes, Your Honor, I'll testify.
Okay. And you don't need any more time to think about that?
No, Your Honor.
Okay. All
Your
right,
Honor,
Deputy.
Excuse me, for the record, we have talked at length about that.
Okay.
He wants to testify.
All right. Okay. Yes, yes, please. Okay, please be seated. Members of the jury, I apologize for the delay in getting started this morning. I had to deal with some legal issues. And I want to also explain to you that yesterday there were some times that we had headsets on. We were discussing legal matters. We're not trying to hide anything from you, so I hope you understand that. But it's very important that you only consider evidence that is properly before you in rendering your verdict. So I know it can be frustrating, but I want to be careful, and I want you to consider the right evidence. Okay? The state or the defense may call its first witness.
Call Steve Imes.
Yes. Come forward, please. And would you stand behind the witness chair? And raise your right hand. Do you swear under penalty of perjury that you will truthfully testify in the witness?
Yes, ma'am.
Please take the witness chair and please remove your mask. State your full name and spell it.
Stephen Bradford Imes, Stephen. Bradford is Bradford, and the last name is James, Ijames.
All right. There's a court reporter taking down everything that's being said, so you have to follow certain rules. You have to answer yes or no instead of shaking your head. No, uh-huh, or uh-uh. If you don't understand a question, let the lawyer know. Only one person can speak at a time. So wait until the question's finished before you answer. And most importantly, if an objection is made, stop talking immediately. Do not answer the question unless I tell you to.
Yes, ma'am.
Counsel?
Thank you, Your Honor. Mr. Imes, how old a man are you?
I'm 64, sir.
Where are you from?
Springfield, Missouri.
Did you drive up here yesterday?
Yes, sir.
Tell us about your education, your undergraduate degree and a master's degree.
I have a bachelor's degree in criminal justice and a master's degree in public administration.
And do you remember when you got those?
80s and 90s.
Okay. You've had a career in law enforcement, have you not?
I continue to be commissioned as a Class A peace officer in Missouri today, yes, sir.
How many years have you been a police officer?
I'm in my 44th right now.
Have you attended, in the course of your career, certain law enforcement academies?
Yes, sir.
Could you tell us what those are?
Initially, the Missouri State Highway Patrol Academy, and then the Springfield, Missouri Police Academy, which is an internal 1,000-hour academy. As for basic police training, that's the two initial academies I went to.
Did you attend the FBI Academy?
I'm a graduate of the 186th FBI National Academy, yes, sir.
Could you tell us a little bit more about that? Where did that take place?
It's in Quantico, Virginia, and it's the considered the premier training for law enforcement managers and commanders in American policing. We also do foreign countries. I think there's been 117 countries that have sent senior police commanders, but it's primarily an American police finishing school for commanders.
Have you been to the DEA Academy as well?
Yes, we're a graduate of the DEA Academy also.
And what was involved in that?
That was a 2-week commander's academy simply for running drug schools, drug programs, basically a focused command effort to teach you to do a better job of doing safe and effective policing in a pretty complicated area, the drug world, and that's what their
I suppose we
program
ought to say what the DEA means in terms of those initials. What,
Sure,
what
Drug
is
Enforcement
DEA?
Administration.
Let me ask you what your specific experience is in law enforcement and a number of your other qualifications before we get to this case. Tell us about your law enforcement career. How did it start and what did you initially do?
As with almost every police officer, I started as a basic patrolman, driving a patrol car, answering calls, just your general call for service. Promoted from there to a narcotics drug investigator, and then from there to just a general crimes investigator, your basic TV detective. I left a smaller department after 3.5 years, primarily to get my 4-year degree. I moved to Springfield, Missouri from Poplar Bluff, Missouri, and went back through the academy. Policing is unique, in some ways good, some ways bad, but it's not a profession by many standards. For example, when I moved from one department to another, I went right back to school. It wasn't like since I had been a police officer, I just come to work. So in Springfield, regardless of my detective experience, I went right back to the academy for 1,000 hours and then 13 weeks of riding with a training officer.
So
And
let me
then-
back up. Did you start out with the Poplar Bluff Police Department?
Yes, sir.
And then after that certain amount of time, you went to Springfield, the Springfield Police Department. Is that
I was
correct?
in Poplar Bluff for about 3.5 years, and then to Springfield, was there for 25. I retired there as the assistant chief. But the beginning is right back to the street. So I did several years as a patrol officer after the academy. I rotated in to work the jail for 9 months. We had a 14,000 prisoner a year jail booking process that if we were short on civilians, they would grab the low senior people. So I did 9 months in the jail. I dispatched for a while, worked the front desk. You just do whatever they tell you to do in the early days especially.
Did you advance through the department?
Yes, sir.
Tell us what your advancements were.
After several years in those assignments I just mentioned, I was transferred to an undercover narcotics role, where I basically bought hand-to-hand drug buys off about 300 suspects. Ultimately promoted to a detective corporal, which is a plainclothes investigator, kind of what you see on TV, doing every type of post-event investigation, robbery, homicide, theft, that sort of thing. Ultimately promoted to sergeant in the detective division. And then in 1989, a catalyst event, a pretty catastrophic hostage-taking scenario, resulted in us creating a full-time SWAT team versus a part-time team that would not be as practiced and experienced.
What's a SWAT team for our own?
Special Weapons and Tactics is what the terminology references, but it's basically a group of officers. It varies by department, but for most it's an elevated skill proficiency group that focuses on really critical incidents, day in, day out, your drug search warrants, barricaded suspects, hostage takings. And we had an event that finished well, but it wasn't because we did well. We had a hostage taking that finished successfully, but because the suspect allowed the victim to be released. And the chief recognized after that that we simply didn't have the capability as a part-time team to solve it. And so he created a full-time team. I was asked to lead that team. And when I say full-time, just to be clear, most SWAT teams in America, about 98%, have collateral duties. They work in patrol, they work as a detective. In our environment, it was the only job we had, 10-hour training day a week, and nothing but search warrants, barricades, and the rare hostage taking. So I had that team for many years.
About how many, do you remember?
As the direct supervisor, first line person, 89 to about 94. I kept it in my division as command almost to the last day I was there, but functionally, once you make captain, you're not an operator anymore. You need to allow line people to work. So once you're at that level, I stopped doing the day-to-day work with them.
And what other responsibilities did you have after that with the department?
When I promoted to lieutenant from that division, I kept supervision of SWAT, but I also had narcotics. So you had all drug investigations, all special operations, K-9, bicycle unit, just odd things that police departments lumped together. Ultimately promoting to captain and took over the uniform patrol division, which would be everything you see in a uniform from a DARE program, drug abuse resistance education, to uniform patrol, to school crossing guards, just everything you think uniform policing. About 3 years later, I think I was promoted to major and took over all investigations, which would take you out of uniform, but then anything, plainclothes, narcotics, robbery, homicide, anything that would be your perspective of a plainclothes detective, and I had that role until I retired as the assistant chief.
Along the way, while you were at the Springfield Police Department, did you work with the United States Marshal's Office?
I was a commissioned marshal on a number of task forces at various times in my career. There's reasons why agencies do that, to give you a different level of authority. And there's also some funding reasons why you do that. You can get money funneled to a department to help with overtime and things like that. But on a number of occasions, yes, sir.
Did you also work on a DEA task force while you were at Springfield?
On a number of them, yes, sir.
You indicated that you were a licensed police officer for 43 years. Have you considered now retiring from active duty, so to speak?
As recent as 2 months ago, I was driving a marked patrol car for the State Park Police, the Park Rangers. I'd done that for the last 3 years. Had some medical hiccups that have caused me to resign that commission, but I'm not sure what will happen after the first of the year, but I'm leaning more towards family stuff. But
Well,
we'll see.
you've come up here in a car. Did you recently have heart surgery in Chicago?
Open heart surgery last week.
Which is one of the factors you're considering in retiring.
My wife's certainly considering that, yes, sir.
Okay. Do you know what a critical incident is?
Definition varies from agencies. There's no national standard definition, but for most agencies, it's an incident that involves an enhanced potential for death or serious physical injury over your ordinary day-to-day call.
In your 43-year career, how many critical incidences have you been involved with?
I couldn't begin to answer that. I mean, it'd be many, many, many.
Can you give us an estimate?
Hundreds.
And were some of those critical incidents involving guns and shots fired?
I would say the vast majority, not that you can't be in immediate deadly jeopardy with something besides a gun, but normally, because the gun issue involves distance and capability, you can usually stay away from a knife person to some degree, but most of them involve guns because they're harder to control.
Do you have any teaching experience?
Beginning in the late 80s, I became a generalist and specialist instructor for the Missouri Department of Public Safety and began just teaching in Missouri, primarily drug-related investigations, and then as our SWAT team evolved, began doing SWAT training. Not because, we were the best, but we were busy and we had good outcomes. We were able to get the job done without anyone getting hurt. And in policing, you quite often look to others who are doing something that seems to be where you want to be, and you learn from that. So we began doing a lot. I began doing a lot of tactical training. There's an international organization called the NTOA. It's the National Tactical Officers Association, but it has 40 countries represented. Began teaching for them. In the late 80s, early 90s, we began videotaping virtually everything we did, which in American policing, that was just stunning, that you would videotape what you were doing, and many, many people question the logic in that. For us, it was primarily a critiquing, learn from training perspective, but because we had video, of operations, of things going well, things going bad, it greatly enhanced the teaching capability. So I could show videos of actual operations. One thing led to another, and I was asked by the director of the NTOA to be one of their 4 national board members. So once I became on the board, a key part of that was teaching for the National SWAT Association.
Well, let me interrupt you then. Let me list a couple organizations you've taught for, if I may. Have
Yes,
you presented for the United States Department of State?
In 33 countries, yes, sir.
Have you presented for the International Association of Chiefs of Police?
Many, many times.
And you've made presentations in many states in the United States, have you not?
Yes, sir. I think pretty much everywhere.
You have made presentations on the international arena in Somalia,
Yes, sir.
Haiti.
Many, many times in Haiti.
You've made presentations to SWAT officers in London, Amsterdam, Brussels, Dusseldorf, Nuremberg, Belfast, among other places.
33 countries, yes, sir.
You've made presentations for the United States Department of Justice in Bosnia.
Yes, sir.
You've also worked as an evaluator for various countries and how they operate their police forces and their SWAT teams. Have you not?
Yeah, not unique to foreign countries. I've actually done more evaluations here in the United States. That's actually a key part of what I've done, especially in the last 10 or 15 years, is do evaluations for agencies that would just like an outside external perspective. In some cases after a tragedy, a critical incident, but in some they'll invite you in and say, hey, I've just taken over this department and it looks good to me, but I would just like an outside look, someone who doesn't have a dog in the fight. So I do a lot of that, more in the United States, but I have done a lot overseas, but more here.
Well, let me ask you whether overseas you've worked with various countries, including Jamaica,
Yes, sir.
Canada,
Yes, sir.
countries in Southeast Asia,
Yes, sir.
Tanzania,
Yes, sir.
Greece,
Yes, sir.
Yemen,
Yes, sir.
Kenya,
Yes, sir.
Indonesia,
Yes, sir.
and that's just the start. I could.
Been to a lot of them, yes, sir.
Okay. And you've also trained officers in terrorism and counterterrorism, have you not?
A key focus of the international training, not surprising when you consider the last 20 years or so, post 9/11 for sure, a critical focus of our U.S. government effort overseas that involves local police. A lot of individuals don't understand that much of the American policing effort overseas that the U.S. government funds is done by police officers, not the military. Nothing wrong with the military, simply that our government, I believe, thinks that it's best for police to train the police. And so post 9/11 especially, a key focus of what I've done is under what's called a anti-terror assistance training program, which is through Department of Justice or state, geared towards teaching concepts that just make our embassies safer and make our citizens safer in countries that might have a potential for enhanced risk for terrorism. Yes, sir.
Okay. Have you made presentations and worked with the United States Army, the United States Air Force, the New York City Police Department, and police departments in California, Wisconsin, Oregon, Utah, Colorado, Illinois, among other places?
Been here a lot of times.
You are an instructor for tasers, are you not?
Not for Taser. I've never worked for the company.
How does that work when you say you didn't ever work for the company? Tell us how one becomes an instructor on tasers.
So Taser was invented in 1965. A man named Jack Cover, and it went through a number of different patents and owners, but ultimately the Smith brothers, Rick and Tom Smith, took over the Taser patents in the mid-90s, slightly varied to get around some technical issues, but in the mid-90s, the Smith brothers created the current process that became the Taser today. And in 1999, they did their first instructor-trainer program where they would create training to teach teachers. And that first program was done in my police department by Rick Smith, the owner of the company. And I was in that class. And I always felt like that I had been training for a number of years up to that point, that if you ended up appearing to be in bed with a company, if you worked for a company, that your ability to speak truthfully without people wondering what your motivation was would be an issue. So I just made a decision in the mid-90s to, though I was very involved in technical training, whether it was pepper spray, whether it was a plastic bullet, tear gas, I would never work for a company, because I just felt like you kind of have to carry the party line. And so Mr. Smith allowed me to go through that class with the understanding that I would not be a TASER instructor. In the early 2000s, there was a lot of controversy with police departments being accused of being too tightly aligned with manufacturers, getting free things, basically using tools on citizens in scenarios that might be questionable. And so you began to have training crop up where individual agencies wanted teaching from outside of a company. They basically didn't want the party line. And so the International Association of Chiefs of Police, who I've been involved with for years, largest and oldest police organization in the world since 1897, had me develop a TASER program. We actually couldn't use the term. It was Conducted Energy Weapon, CEW training program, to where we could teach agencies TASER process, but not be under the TASER banner.
And you have taught TASER courses.
Many.
Okay, you're familiar with the protocols for the current TASER, TASER 7.
Both the teaching and then what we would call your best practices policies that are out there. There's different groups that give models, examples of how they think the device should be used. Not all in lockstep, but I'm very familiar with those as well.
Well, we're almost done with your qualifications, but I want to ask you just a couple more questions. Have you had any academic affiliations where you're taught policing and criminal justice matters at a college level?
Yes, sir. I've taught seated classes at different universities. 3-day-a-week classes, and then I've done just adjunct faculty, things like that. I don't do anything like that now, and I don't anticipate it again.
How many officers over the course of your 43 years do you estimate that you've trained in the reasonable use of force, including tasers and guns? Give a sense of how many people you've trained.
It'd be thousands. I don't want to just guess. It would be thousands.
Have you received any awards during the course of your career?
Some, yes, sir.
Well, are you a member of the American Police Hall of Fame, for example?
Yes, sir.
And what is that?
That's just a national police organization that recognizes certain acts in police service.
Are you the recipient of the Silver Star for Bravery?
Yes, sir.
What is that?
It's an award given for actions that meet their standards to acknowledge, I guess, above and beyond the normal duty.
And what did you get the award for?
Rescuing a hostage in a liquor store holdup that had been shot, and engaging the suspect in that case and shooting and killing him.
Have you had any publications during the course of your career?
Around 100 articles, chapters for books, peer-reviewed articles, some not, but I would estimate around 100.
Mr. Imes, I could spend quite a bit more time with your qualifications, but is the history of your career set forth in your CV, which is Exhibit 1001?
Yes, sir.
We offer 1001 for the defense.
Is there any objection?
We do, Your Honor. It's hearsay.
It's his resume, correct? The objection is overruled and the exhibit will be admitted.
Did I contact you or the defense contact you for the purposes of your initial review of this case?
I don't remember.
Well, you were contacted. It doesn't matter who, but
Yes,
you were
sir.
contacted
I don't
to see if
recall.
you would review this case, were you not?
Yes, sir.
Okay, all right. How many cases have you reviewed for reasonable use of force, excessive force, that sort of thing in the course of your career?
A fair number would be between 2,000 and 3,000.
How many criminal cases do you have right now under your review?
4.
Of the 4 cases that you have, how many of those are you testifying for or on behalf of the police officer or against the police officer?
This is the only one that would be considered, if that's the perspective, for an officer. The other three, my opinions, would be against the officer.
Are we paying you to be here?
No, sir.
And why is that?
I've decided in the mid-'90s, when this process began, I began asked to review cases that I would never take a fee in a criminal case, regardless of the side that was calling me. I'm not Mr. Benevolent. I like to get paid like anyone else. But I just felt that something as significant as someone's freedom suggested I should give an opinion without any question about motivation. I may say things you don't agree with, but I don't think the issue of money coming into it should be a consideration. So I just decided in the 90s I would never take a fee for a criminal review of any kind, regardless of the initiation, but I've stood by that, and if I continue to do this, I'll continue to take that perspective.
Well, we asked you to review this case. Do you remember initially what you did review?
Yes, sir. It was a voluminous file. As I recall, our initial discussion focused around the deployment of a taser. That was the primary focus. This case, and in no way am I diminishing, it's not a complicated case, the facts itself, but the focus initially was the issue of a decision to deploy and manner of deployment of the taser.
So you looked at the videos,
statements, various reports. I didn't review everything in it. I reviewed those things I felt were necessary to give me the information to render reasonable opinions concerning the decision to deploy and the manner of deployment of the taser. Yes, sir.
Which really centered on the officers on the scene, Mr. Wright's conduct, and the
And
training.
then some foundational stuff, issues concerning what an officer would have been taught, what would have caused them to think certain things, but almost exclusively it's the officers on the scene. Yes, sir.
Now, since the trial began, have you reviewed actual testimony that the jury has heard?
In the last week, within some limits of my ability in the last week, I was able to follow some things that were online that involved testimony. Yes, sir.
Did you, for example, follow the testimony of Officer Lucky,
Yes, sir.
Sergeant Johnson,
Yes, sir.
Sergeant Peterson in training,
The training sergeant. Yes, sir.
and also Mr. Stoughton yesterday?
Yes, sir.
Well, let's start your review by your understanding of what happened here. Would you discuss the nature of the stop and what you saw, and then I'll get you some more specific questions on the use of the taser. What did you initially see in your review?
Yes, sir. You've got an officer in field training and a recruit, for lack of a better term, and there's an initial assessment of a vehicle in front that has something hanging from the mirror. Your state, as with other states, has a statute that says you can't have anything between the driver and the windshield. And so I think that was the initial reference. Field training is a process of work. You want recruits to do things and test them and figure out that they understand the basic practices and protocols. So the license was checked. There determined to be some difficulty with, I believe, the registration tabs. So you had basically your statutory issue about something hanging between your eyes and the windshield, and then a license violation, and the stop was initiated from there.
Was the matter of a warrant for a gun of significance to you in any way? The fact that the officer on the scene found out that there was a warrant outstanding for the driver of the car.
Oh, yes, sir.
What was that? Was that significant for you in any way?
Yes, sir.
And how so?
Police officers aren't clairvoyant. The best way to indicate what might happen tomorrow is what happened yesterday. So we teach officers to act on reasonable appearance. And so if I find a person on a stop that has a weapons charge or a gun warrant, it doesn't mean they have a gun. It means they very likely could have a gun because they've had one in the past. So an officer would immediately take a different perspective, not that they would act necessarily differently, but they would begin to address this call for service differently because we have reasonable, objective information that a gun could be in play.
How about the existence of a harassment order? Did that have any import in your evaluation of the case?
Same basic thought process. We teach officers to look at the totality of circumstance, everything involved in this case. So if we have, in this case, a female in the car, and we have a harassment reference as well, is that the person? What's the nature of the harassment? It just continues to elevate an officer's vigilance. And I want to be clear, it's not that we then use weapons or use force, but we absolutely look reasonably on appearance of the facts we learn as we move forward about potential danger, potential resistance, and then act accordingly.
Well, does the harassment order increase or decrease an officer's possible perception of dangerousness?
It would increase. I mean, it's certainly different than a felony assault, but it's also different than a shoplifting charge. So a harassment would indicate a personal interaction in a negative way, and it would just cause an officer to be more vigilant concerning that type of interaction.
How about the existence of the female passenger in the car? What significance was that to you?
The third party present, officers basically look at calls for service from a safety priority perspective. So that third citizen in there, not the focus of the event, increases your concern for her safety, but also what role, if any, she plays in that harassment charge. Is that the person named in that particular event? Have they made up? People do. It would be very relevant to continuing that investigation.
With a bench warrant outstanding for the driver, was there, in your view, an obligation to arrest him, meaning Mr. Wright?
Absolutely a mandate.
We have an opinion yesterday that the officers could have let him go because he could have been arrested later. And your response to that?
I'm going to object, Your Honor, as a misstatement of evidence.
The objection is overruled.
Police officers enforce the law. The order from a judge, in my experience, is literally the highest order we operate under. And if a court order, a warrant from a judge says that person is subject to arrest, they will be arrested, and there's consequences if you don't. Some states, including mine, criminalize it. If you don't serve an arrest warrant, it's a crime. Not every state, but that emphasizes the seriousness of it. It's not a request. It's not a suggestion. An arrest warrant is an order to arrest, and that's what police officers do.
So in your view, Lucky, former Officer Potter, and Johnson had to arrest him?
Dereliction of duty not to.
As a supervisor, in Missouri, one of the leaders of the department, would you have disciplined an officer for not executing it or not arresting on a warrant from the court?
Beyond question.
Now, turning to the Lucky's behavior and his actions, you remember that he goes up to the car and asks Mr. Wright to step out. Is that correct?
Yes, sir.
Was that a correct police procedure in your view?
Yes, sir, it is.
Was it a correct police procedure in your view to tell him that he was, once out of the car, under arrest?
Beyond question.
And why is that important to tell someone like Mr. Wright that he's under arrest?
It may seem obvious that we would tell people they're under arrest, but in my experience, it quite often doesn't happen. An officer knows there's a warrant for you, and they stand the person up and say, turn around and put your hands behind your back. But it is a critical aspect of that officer-citizen encounter at the time of the arrest to look right at them and say, you are under arrest. And so in this case, we had two officers that actually said it. I just want to make it clear that the assumption that that always happens, it really doesn't. And so it's critical because it basically removes all confusion. When we say you're under arrest, that's exactly what that means, and you're required to comply with that order.
But what does Mr. Wright do instead of complying?
He initially just stood there and fidgeted a bit, and then there was the attempt to cuff him, and then he ultimately tried to get back in the vehicle.
In your 43 years, when someone wants to not be arrested and are about to be cuffed, what usually happens?
First handcuff's where it happens. When you take a hold of that first hand and are applying the first handcuff, in my experience, and that's taught universally, but it's like at that moment when they make the decision is when the hand goes on their hand, and that appeared to be what I saw in the video. It's the norm, but he began resisting at that point.
And what impact did that decision that Mr. Wright made have on the police officers at the scene?
The objection is overruled. He may answer.
It changes everything.
How so?
In policing, our primary focus is to react to what others do. There are certain areas we're proactive, but as in this scenario, we are reacting to what the arrested individual does as it relates to submitting to our lawful authority. If he complies, as almost every prisoner does, the handcuffs go on and the process works itself out. If they resist, then we will have to use that level of control to overcome the resistance and continue to work towards that lawful objective, which is effecting the arrest warrant.
Could they, could the officers, in your view, just kind of let him go when he started to escape from the cuffing?
Objection asked and answered.
The objection is overruled.
You may answer.
No, sir. Police officers are under authority. We're not military, but in many ways, police officers are structurally in a system where they do what they're told, and they are told to serve arrest warrants. And now, is there room for variation? Do some agencies do other things? Sure. But the legal obligation to serve an arrest warrant is unquestionable, and at the time he resists, their default is to overcome the resistance in a reasonable, safe way and get back to working on accomplishing that mission objective, which is to serve the arrest warrant.
Did you see from your review of the videotapes and the testimony that you've heard and watched that there were efforts after Mr. Wright initially refused to be cuffed to secure him?
Yes, there was an initial scuffle there at the driver's side. Yes, sir.
Was that a legitimate law enforcement technique?
Certainly. Grappling, soft empty hand control is the formal term, is the force used in about 90% of all resistance. I try to put a cuff on you, you begin to scuffle. I don't punch you, you don't punch me. We're just in a little bit of a grapple. And if I and my friends are able to overcome your resistance, the handcuffs go on, and that's that. Almost every time, that's what we do.
We've talked in the trial about control over a motor vehicle. Are you familiar with that phrase?
I am.
Control? Was at this point in time, or was this at this point in time, was Mr. Wright in control of his vehicle as he struggled to get back in it?
He was not.
Was he ever in control of the vehicle before the taser was shouted and a gunshot took off?
Not that I could tell from the video, no, sir.
What do you mean by control in police work?
Control literally means the ability to put it in drive and go. That's it. There's actually a Minnesota statute that references control in relation to DWI, and it talks about mechanisms of movement. That's not unique to Minnesota. Literally, control is just that. I'm in control, and I can go do what I want, which in this case was likely to go forward.
We've seen a lot of body cameras in this case, and then we've seen still shots of what happens. When an officer is in a situation like they were here, do they see in still shot framing what has happened?
No, sir.
Well, why is showing a still shot of what occurs different from what an officer sees?
The format for body cameras is called QuickTime Player. It's 29.5 frames per second. And you and I can just envision how well we could take a 1 second sliced 29.5 times and accurately or effectively see and assess that slice. So the slice is helpful in some cases, for example, to show whose hands are on a gear shift mechanism, but to suggest that anyone, officer or citizen, sees and perceives something you see in a 1/29.5 second frame is just completely unrealistic.
Well, compare what the body camera sees with what an officer sees when there is a struggle.
Sure. Officers, like all human beings, have varying processes physiologically, metabolically that apply to survival, stress, fear. And so, for example, you'd asked earlier, sir, about critical incidents. I've reviewed hundreds, in which officers and citizens are talked with after a life and death scenario. And very common themes occur where vision is focused, very tunneled. Not always the same, but that's a very common theme, where loud sounds are silent or not heard, where a quiet sound is actually magnified. So the video records exactly what's happening without any of the processes human beings go through. In my experience in critical incidents, almost no one, officer or citizen, can ever accurately speak to what happened in all areas because their body just can't record, like a video, exactly what's going on.
I would object to that question. The answer is beyond the scope of this expert's foundation.
Okay, no speaking
Objections. You may put your headset on. The objection remains overruled.
As he got back in the car, Mr. Wright got back in the car and struggled. In your view, did he have control of that motor vehicle at that point in time?
He didn't, because he didn't leave.
The gears were not engaged.
Correct.
We've heard testimony yesterday about the differences of shooting into a car that's moving and shooting into a car that's stationary or in control.
Yes,
Is
sir.
that a distinction you make in your work?
It just depends on the circumstances. The key issue is balancing the need to use that extreme level of force with the potential consequences. You may need to do it if the vehicle's moving, if someone's about to die. And then you acknowledge there's potential consequences as it rolls. So it's not a black or white yes or no. It depends on the totality of the circumstances in each case.
You were asked to evaluate the decision to use a taser in this case and whether it was reasonable and appropriate. Is that correct?
Correct.
What is the standard that you're using to make that determination?
Quite often there's terms thrown around in American policing about standards, and to be candid, there are few actual standards as compared to other professions. By standard, I mean if you don't do it, there's action. There's something that follows. We have the Supreme Court, we have federal circuits, we have state statutes that provide standards that if you don't follow, there's consequences. But most of other policing is the result of organizational culture, training. There's 18,800 agencies in America that do many things to a degree of autonomy that is stunning to many people. So, from a standards perspective, what I prefer to teach is what I call contemporary police practices. And by that I mean it's what most people do. It's not that they have to do it. There's not a Supreme Court ruling or a statute. There's not a standard that they're in trouble if they don't. It's what most professional, smart police agencies do. And so to talk contemporary police practice, you have to look for where that body of knowledge would likely be. For me, and for most agencies, organizations like the International Association of Chiefs of Police, every chief in America is a member. I've been around since 1897. In 1987, they partnered with the Department of Justice to create the National Policy Center. And the National Policy Center was created to put together, their words at that time, models of policy on contemporary issues that agencies could use some help on. And so I've served on the National Policy Center board for over 20 years and authored many of their policies. So if you were a chief in the mid-90s when TASER first became common, what do we do with this thing? How do we use it? Well, the manufacturer says this, and many smart chiefs would say, I appreciate that, but I'd like to talk to some people who worry about what I worry about, not selling devices. And so the IACP has a model policy on the use of the TASER.
And what would that be?
Well, I wrote that policy. I created it for them, and it specifically speaks to basis or justification to use. And the general justification or basis is grounds to arrest or detain and a reasonable belief that physical force or resistance to that arrest will follow. That's not a mandate to use, but that's a general authorization.
Is that standard dependent on a proportionality of risk, or is there any concept like a proportionality? Sorry about that. In the standard that you've mentioned.
No, sir. The issue of proportionality in policing and force is a very lofty, worthwhile goal, but it's not a standard like objectively reasonable from the Supreme Court to that degree. We want proportionality. We want to do things that are balanced and that make sense. But specifically, officers are instructed that their force has to be reasonable, which in some cases would not be the least amount of force possible. It may in fact be more than something else that you could have done, but that doesn't make it unreasonable.
So is the standard that we use for the reasonable use of force objective reasonableness?
That's the standard I've always been instructed on, yes, sir.
So you've reviewed the TASER manuals in this case, the PowerPoints.
Yes, sir. Very familiar with
You're
them.
familiar with everything that was taught here.
Yes, sir.
So let me ask you the questions that you're here for. Okay?
Yes, sir.
Was the warning given by former Officer Potter, I'll tase you, reasonable?
Yes, sir. That's the standard warning. You just communicate in plain English.
It's a that is what they're taught to do.
Yes, sir. I'll taser you. You just tell the person, and in many cases, someone submits. They'll raise their hands and say, I quit, and that's the goal.
Was the warning taser reasonable under the circumstances in this case?
That is specifically taught in the lesson plan. Number of reasons for that. It's really not for the suspect. It's more for the officers and others around the event to understand that a taser is just about to be deployed.
We heard testimony yesterday that the taser in this case was, or the assumed use of the taser was too close to Mr. Wright to be effective in its impact. Do you agree or disagree with that?
That's completely untrue.
Well, tell us why Mr. Stoughton's opinion is completely untrue.
Two key reasons. The first is the Taser 7 specifically is designed to have a very wide arc with the close range deployed probe. The standard arc deploys about a foot every 7 feet. And one of their corrective measures with the 7 was to figure out that many police confrontations with suspects were at close range, and that degree of spread was insufficient to get neuromuscular incapacitation. So, number one, the 7 spreads wide at close range by design with the close cartridge. Independent of that, the physical positioning of a seated suspect changes everything.
How so?
Literally, as you or I sit here, if you envision a shot just below the chest or sternum area, which is a key aiming point for the upper probe, from that probe to the probe into a thigh is about 12 inches, which is marginal for neuromuscular incapacitation, as they say, as the crow flies. But on the body, it's about 36 inches. Because as you stand, the electricity takes the path of least resistance. It doesn't go through the air. It follows the body. And to connect one probe to the other, it goes down the side, down the leg. And so a seated suspect changes everything as it relates to probe spread because their body's bent and you end up hitting low and hitting high, not because you're at a distance correct for that, but because of the angle of their body.
What would have happened had the taser, an actual taser, hit Mr. Wright vis-a-vis his ability to drive that car?
The actual taser device, when it performs as designed and intended, is the most effective incapacitation tool I've ever experienced, independent of a central nervous system disruption. And I apologize for being graphic, a gunshot to the head, something that basically turns off the lights. The taser is the second best thing out there when it performs as designed and intended. In actual operation, it's a relatively fragile system. Things can happen. Clothing can be lofty. A probe maybe won't stick. The very best studies out there, the most recent, January 2021 with LAPD, is all excuses aside, the taser actually accomplishes overcoming resistance about 67% of the time. So to answer your question, if it had performed as designed and intended, he would have had a neuromuscular incapacitation, which is a very significant physical lockup. In my experience, some people can do a little better than others, but most, it's not a matter of toughness. It's a matter of electronics, physiology. They're pretty much locked up. To get to a shift or a drive would be very, very unlikely in my experience.
And to drive thereafter would be unlikely too.
Objection made.
Well, I'll let you answer. The objection is overruled.
As long as continuity exists, as long as the trigger is pressed or the cycle is energized, and both probes have continuity, it will in theory do what it's supposed to do. But the second that breaks, whether they're driving away and the cord breaks, it pulls free, many suspects literally leap back into the game because it's electricity. And when it stops, now some people, oh gosh, that really hurt, and they kind of pause and seem stunned. But the idea that this is like pepper spray that carries after, it is either you're getting the electricity or you're not. And so the answer, sir, is if the cord broke, if it pulled free, in my experience, most human beings no longer have NMI because the electricity is simply not there, and their ability to recover and continue controlling their body would exponentially be pretty high.
Yesterday, we also heard an opinion that given the location, the close location of the officers at the scene, that shooting a taser would be inappropriate in light of where they were. Agree or disagree?
I disagree with that.
And why is that?
Police officers have to deal with the circumstances presented to them. And in actuality, we fight in close proximity with citizens, suspects all the time. And so you have to work around those as safely and practically as you can. And there is a risk. You can make a mistake. One of the very last arrests I made before I retired, I had a fellow officer spray me with pepper spray in a fight directly in the face on the ground. It can happen, but it's a balance between the need to use that tool, the potential benefit of the taser, with the risk of what would happen if you'd hit the wrong person. So we shoot close all the time. You can make a mistake, but it does not prevent you from doing what you need to do in most scenarios.
Was one of the considerations, at least in your review, of the potential danger that would result if Mr. Wright were not detained by the taser?
Just what comes with a fleeing suspect.
Tell us more about that.
No one has a crystal ball, again, to predict what a person would do, but the very nature of flight and resistance brings with it danger to people in the path of the runway. Theoretically, danger to a person in the vehicle if they are subject to that harassment warrant, which you don't know. Many unknowns. But again, the reason we serve arrest warrants is to put that process in front of a judge and stop it right there, because few good things follow when a person flees arrest and gets away.
And one of the dangers here, according to the testimony you heard, was the possibility of one of the officers being dragged.
I did learn of that last week, yes, sir.
And do you have experience with officers being dragged?
We recently retired this year an officer from my department who was permanently disabled, having been drugged in a very similar scenario, and was medically disabled. He's done.
Object, Your Honor. Relevance and notice.
I'll move on.
Yes, please.
Well, I object to that.
Well, I am going to advise the jury you should disregard that last statement.
In light of your review and the review of all the testimony that you've seen, was Officer Potter's perceived use of a taser consistent with contemporary and professional police training and practice?
Yes, sir.
And why?
The basic model policy definition of when the device would be used is completely relevant here. Grounds to arrest or detain, and a reasonable belief that physical force and resistance would follow. That was happening right before your eyes. And secondarily, when the physical control effort began and the dynamic nature of how he's trying to get away clearly needs to be stopped. Just getting in the vehicle is significant, but officers would be aware of that weapons component and the concern, could there be a gun in the car? Could there be a gun on him? This isn't just about might this person drive away. So the need to stop it as quickly as possible is the key aspect. Nothing but the taser in that scenario had a likelihood of doing that without a risk of serious injury or death. The continued grapple, if you don't get that done and that car gets in drive, it's going to get bad. And the taser is that unique device that when performing as designed and intended would have put a stop to it, very, very likely in most cases.
Did you change your opinion as to whether her perceived use was consistent with the standards you've described after watching the videos of Lucky and Johnson et al.?
No, sir.
What you didn't see in your initial review of the case was Johnson's testimony. Is that correct?
That's correct, sir. I saw that last week, I believe.
And he was the fellow who was reaching in to stop the car from getting into gear. Is that
On the
right?
passenger side, yes, sir.
Was he at risk of great bodily harm or death if he had not gotten out of that car as quickly as he did?
Had the vehicle been put into drive, beyond question.
If, let me assume a hypothetical, if we have the facts as we have them here, and the officer sees Johnson in the car,
Yes, sir.
sees him struggling in the car, and has a view of him, and further that the individual is about to drive away, or at least attempt to drive away with an officer who's in and out of the car, would that officer who sees him be reasonable in the use of deadly force in the face of Mr. Johnson's apparent risk of great bodily harm or death?
I'll object, Your Honor, as calling for speculation and improper standard.
The objection is overruled. You may answer.
The question, sir, would be answered first by just understanding the basic decision-making process involving deadly force, and that is, can I reasonably articulate a belief that myself or another is in immediate danger of risk of death or great bodily harm? So if that's the standard, as an officer assessing the appropriateness of deadly force, an officer half in and half out of a vehicle that is about to be put into drive with the door open would certainly meet that standard of being in immediate danger of death or serious physical injury.
So an officer seeing that could shoot.
It would meet that standard, and an officer could shoot, yes, sir.
May I have a moment?
Yes.
Thank you very much. No further questions.
Thank you,
Right.
sir.
Members of the jury, we're going to take our morning break, okay? So it will be 20 minutes. Okay, you may step down.
Uh, 42,
And what city do you live in?
Minneapolis,
How far did you go in school?
12th grade.
And are you working now?
Currently not.
And are you married?
Yes.
Who are you married to?
Katie Wright?
And does Katie Wright also go by her legal name, Katie Bryant?
Yes.
Do you and Katie have any children together?
We have 3.
And could you tell the jury their names, please?
Dante Wright, Destiny Wright, and Diamond Wright.
And is Dante, your son Dante, is he no longer with us?
No.
Was Dante the oldest of the 3 children?
Yes, he was our firstborn.
What was Dante's role as the older brother to 2 younger girls?
His role to the younger girls was the big brother, to look after them, watch after them.
And what was his relationship like with his younger sisters growing up?
The relationship with the younger sisters was like a big brother. Joked a lot, always constantly following behind them, making sure they were okay.
And did you and your wife, Katie, and your children, Dante and Diamond and Destiny, all live together up until Dante's death?
Yes, we did.
Do you also have some other children from a previous relationship?
I do.
And how many other children do you have?
I have 2 other kids prior to our relationship, Marcus Wright and Monica Wright.
And where do Marcus and Monica live?
They live in North Carolina.
So between you and your wife, Katie, how many children do you have altogether?
She had 2 kids prior to our relationship, so we had 7 altogether.
So getting back to your life with Dante growing up and his younger sisters, what kinds of things did you and your family do together for fun to pass the time?
Well, we got together every Sunday we would have cookouts and stuff like that. Family days, we would do movies and stuff like that. We did a lot of things as a family, as a group, because we're like all we have, so.
Cookouts, he said?
cookouts constantly every Sunday, every weekend, pretty much.
Did Dante have any favorite foods?
Well, yeah, he did. He liked chicken, I guess. We all did. So,
Was that a family favorite at the cookouts?
excuse me?
Was chicken a family favorite at the cookouts?
Oh, yeah. Yes.
Did he like sports?
He loved basketball. He played pretty well. He was a left-hander, so he was pretty good.
And as he grew older, into his teenage years and beyond, did he have a variety of different jobs that he worked?
Had a lot of different jobs. I even got him a job with me before.
And when you say you got him a job, was there a time where you and Dante worked together?
Yeah, it was the time we worked together. I was his boss, and I was happy, to have my son coming on to work with me.
Where was it that you two were working together?
I was a manager at Famous Footwear.
And about how long did you two work together at Famous Footwear?
About a year. About a year. He worked there about a year with me.
About how long was that before he died that you two worked together?
Well, it was his last day was when the COVID hit. So his last day working with me was right in the beginning of the COVID.
So about a year ago is when you guys
Yeah.
stopped working together? How was it for you working with your son, Dante?
It was great. It was challenging, to work with my son. I tried to let him understand the difference between where at work I'm your boss and at home I'm your dad. It's a difference. So, but it was funny. Like it was this one time where I had sent him home. Because he was on his phone at work and he wasn't supposed to be on the phone at work. I was like, yo, we gotta go home. And so he went and asked my boss, is it okay if my dad sends me home? And I'm like, my boss like, yeah, he's your boss. And I'm like, well, you need to go home and come out in the hallway. And he's still there. And I'm like, well, why are you still here? And he's like, well, Dad, I rode with you. I couldn't go home because you're my ride. I think it's funny, but yeah, that was a funny thing that happened at work.
So not only were you working together, but you were driving to and from
Yeah,
work
every
together?
day, yeah.
You got to spend some quality time together.
Yeah, spend a lot of time together.
Your Honor, at this time I'd offer Exhibit 240.
Any objection to 240?
Okay, I previously ruled on it over defense objection, and 240 will be admitted into evidence.
Thank you. If we could publish it, please, and put it on the screen. All right, there's a picture on the screen now. It's Exhibit 240. Could you just explain to the jury what's shown in this picture? Take a minute if you need one.
Picture of me and Dante. You see how, I was holding him. See how his arm, we had a close relationship. He was me and my wife's first child.
And was this picture at your home?
Yes.
Was this not long before he passed
This
away?
was right before he passed away.
And if we could put on the screen Exhibit 3, please. That's already been admitted. Did your son Dante also have a son of his own?
Yes.
And
First and only child. That's my grandson, Dante Jr.
And your grandson's name you said is Dante Jr.?
Yes.
How was it seeing your son Dante as a father?
Excuse me.
How was it to see your son as a father?
Man, to see him as a father, it was like I was so happy for him because he was so happy. He was so happy about Junior. And this was my chance to be a grandfather.
Did Did they have a close relationship?
Yes.
And did Dante Jr. spend a lot of time with your family as well?
Yeah. Dante Jr., Dante lived with us. Junior was pretty much there every day. And he loved his son.
And did you love your son, Dante, a lot as well?
A lot. I loved Dante. He was loved.
Do you miss him?
I miss him a lot every day.
Thank you, Your Honor. Nothing further.
Is there any cross? All right. Thank you, Mr. Wright. You may step down.
Right. What your last piece of testimony was that when the officers attempted to handcuff Mr. Wright because they had his address and name, and it was a minor violation, that they should have just let him go. Is that what you're saying?
No, that mischaracterizes my
Okay,
testimony
what are
and
you
opinions.
What are you saying about it? I thought you said that they should let him go because they had his name and address. Is that what you said?
No, that's not what I said.
Okay, well then I misheard you. What did you say they should let him go?
No, I did not say they should
What
let
did
him
you
go.
say?
I said that the fact they had identified him and had his address is a relevant consideration in balancing the threat of escape or evasion.
Of what? I'm sorry.
The threat of escape or evasion.
Okay, and if he attempted to escape, what should the officers have done?
Use reasonable force to prevent the escape.
And did they do that when they were trying to stop him from escaping?
Are you asking me
Yeah.
in this case? No.
They didn't. And
At an early point, I would say yes, although we didn't talk about that. But at the point of using deadly force, no. As I testified, that was excessive and unreasonable,
Right.
inappropriate, and inconsistent with generally accepted police practices.
yes, but I was not talking about deadly force. I was talking about your first opinion in your report about using the taser. And your report seemed to reflect that because they would find him some other time or somebody else would get him, that they should not have tried to stop him. Is that what your report says?
It's not, no.
Okay. Well, let's go back. You started working as a police officer in what year, 2001?
Yes, sir.
Is that right? And you worked as a police officer for 4 years and 7 months after that? Is that right?
Something like that, full-time, an additional 6 months as a reservist. The plaque on my wall says 5 years, but I'd have to calculate the exact number of months.
All right, well, let's assume it's 5 years, and it doesn't matter.
Sure.
That was 15 years ago, I believe, right? About that?
Yes. I left
And have
about...
you worked as a patrol officer since 15 years ago?
No.
And during the time you were a patrol officer, and we did some history here, how many first of all, do you know what a critical incident is?
Yes.
How many critical incidents did you have in the 5 years that you were a law enforcement officer?
Oh, I was involved in maybe a dozen.
Okay, name one. I'm talking about a critical incident where a gun was used.
Sure. So my first one was in field training. I was not a shooting officer. My field training officer.
Maybe you misunderstood me. I'm not talking field training. I'm talking out in the area, being a patrol officer and having a real life incident. Did you have any of those?
Your Honor, I hate to be the third person talking at a time, but Could the court please remind Mr. Gray that only one person can talk at a time? They should let the witness.
Right, and if he could answer my question, Your Honor.
All right, okay. You may continue, but yet for the benefit of the court reporter, please remember not to talk over each other.
Okay.
All right.
So what I'm talking about is when real life, when you're out on a patrol alone and you have a critical incident situation, how many of those did you have?
I was involved in, although not the shooting officer, I was involved in perhaps a dozen or so.
Of an officer shooting?
Either an officer shooting, an officer potentially being shot at, a significant use of force that we would classify as a critical incident.
Were you ever the one that shot the gun?
No.
Were you ever the one that was shot at?
No.
Were you ever in a situation such as the one that you saw in this video, the chaotic incident of this sort?
Someone attempting to flee an arrest and traffic stop? Sure, a number of times.
Okay, well, did they have a bench warrant for a weapons violation?
I don't remember specifically. I know certainly there were people who fled who had outstanding warrants of different types.
Well, I'm talking about an incident. Did you ever chase somebody that had a weapons warrant?
I'm sorry, that had a weapons.
Well, okay. I'm talking about a critical incident where you were involved yourself personally, and a man broke away from you, didn't want to be handcuffed, and either drove off or ran off. Did you have any incidents like that?
I had a number of incidents where people who did not want to be arrested either drove off or ran off. They did not result in an officer-involved shooting, if that's what you're asking.
Okay, so the person that drove off, if you can remember one specifically, did you have a person that drove off or that fought the handcuffs and jumped in the vehicle? That person had a warrant for a weapons violation, had no driver's license, no insurance, and a temporary restraining order against him against a female, and the officers did not know who the female was in the vehicle. Did you ever have an incident like that?
I can't say that I had that particular collection of facts as an officer, no.
Did your heart ever race, and did you ever get real excited when somebody left your custody and ran off?
Of course.
Okay. So you're aware that's what happens. Your adrenaline starts pumping. Is that right?
Colloquially, sure.
Okay. And you had that police officers patrol for about 5 years, give or take. And during the 5 years, you never was a trainer. You were a trainee except in computer training, correct?
I taught report writing to officers, the policies that we used. I got a number of different training.
You answered the question. And just answer my question, okay?
I'm sorry, I guess I don't understand your question.
I guess you don't. Okay, so during the time you were a police officer, you never was a trainer for use of force, for shooting a gun, or any kind of conflict with a citizen, correct? You weren't a trainer.
No, I earned a number of instructor certifications, including several in use of force disciplines.
You were a trainer for the officers back there in 2001, 2005. You trained other officers on the use of force. Are you testifying to that today?
No, I'm testifying that I earned several instructor certifications.
Did you hear my question? Did you ever train any officers back there when you were a patrol officer? Did you ever train any officers on use of force at the police department you were in?
At the police department, no. I was not what we consider to be a defensive tactics instructor.
And you were actually a trainee, correct?
At the beginning of my career, sure.
Yes. And as far as, do you remember what a spear drill is?
A spear, as in Tony Blauer's spear system?
I don't know, but in your records you didn't choose to participate in a spear drill. You remember that?
No, I don't. If that's the spear system drill, no,
Do you remember not participating in it?
I remember.
I can refresh your memory if you want.
Sure. I remember at one point getting a fever in the middle of defensive tactics training
Yeah, that's right.
and getting pulled out.
Thank you.
And I'm going to object, Your Honor, on relevance grounds.
The objection is overruled.
Read it to yourself.
Sure.
Sure what?
I've read it.
Okay. And what, does it refresh your memory?
Looks like my entire squad at the time is listed.
I asked you if it refreshes your memory or not. That's a yes or no, sir.
Not of this particular. I suppose it refreshes my memory as to what.
As to whether or not you wouldn't participate in the spear drill.
No, not
You
particularly.
don't remember? It did happen though, didn't it?
I don't know. I don't remember.
Okay. Too long ago? Is that right? Is it too long ago to remember?
Perhaps some combination of too long ago and simply not memorable.
Then you probably don't remember a lot of things that you did as a patrol officer, is that right?
Oh, I'm sure there are all kinds of things that I've forgotten.
15 years ago?
Sure.
And when you were approached to work in this case, you signed the contract, correct?
Yes.
And the contract calls for, what was the hourly rate?
I believe it was $2.90 an hour with 10 hours on days of expected testimony.
Okay, and up till now, you've billed them about $10,000, would that be fair?
Something in that range, about 35 hours worth.
And since November, strike that, the cap on your contract is $50,000, correct?
I don't remember.
Oh, I'll show it to you.
You mean approach.
Yes, thank you. I'm sorry. Actually, totally, I believe it might be 95,000. Take a read on that paragraph and see what you can figure out.
Oh, I'm sorry. I've misstated my rate. It's $2.95, not $2.90.
What else does that say?
It says quite a bit on what are you referring to?
The cap. How much is the cap?
The cap, I suppose if that's the total obligation clause, it will not exceed $95,000.
Thank you.
Yes. Mr. Taylor, did you remember to ask your questions at the podium for the benefit of the court reporter?
Now,
Was that spear drill late June?
I'm sorry, I didn't ask you a question. The stop on this case last April 11th, you looked at that. That was legal, wasn't it?
The traffic stop itself? Yes.
And the arrest was legal, correct?
Yes, officers had probable cause to arrest for the bench warrant.
Well, besides the bench warrant, you knew that Wright did not have a license, correct? You learned that from this case, did you not?
Yes.
You learned that he didn't have car insurance, correct?
Yes, that's correct.
And you learned that the registration of the tabs on the car were old, outdated. You remember?
Expired, yes.
Yes. And you learned that there was a lady in the car also, and when they pulled up his record, he had a temporary restraining order in order for protection for some lady, correct?
Yes.
And the officers did not know at that time who the lady was in the car, correct?
Yes, that's correct.
And then when they went up to arrest Mr. Wright, they had a special awareness, did they not, based on what you read, about a firearm being in that car, correct?
No, there were no specific and articulable facts that there was a firearm in the car.
Okay. But you as a patrol officer 15 years now, from 15 years ago, you would agree with me that there are many more weapons and firearms and cars and on person than there were 15 years ago. Do you agree with that?
I don't think there's any valid statistical evidence to support that.
And you as a patrol officer,
Okay, you can come forward and take a seat. Okay, Deputy. Okay, please be seated. Mr. Frank, you may cross.
Thank you, Your Honor. Good morning yet, Mr. Imes.
Good morning, sir.
Thank you for being here. Talk to you a little bit about your CV.
Yes, sir.
Probably doesn't come as a surprise to you, right? You have been an expert witness before.
Yes, sir.
And if well, it really seems like you've really dedicated your life to law enforcement
That's my only job I've ever had. Yes, sir.
and really immersed yourself in it, right?
I'd say it's been more than just a career. Yes, sir.
What has it been? More than a career, it's been a calling for you,
It has been.
something you are completely dedicated to.
I am,
More than a 40-hour-a-week job.
for certain.
In fact, we know from, for instance, in your CV, your resume, there's a section where you talk about, I think the title is Operational Experience. You recall that section?
Yes, sir.
And you're talking there, I think that's about while you were working for the Springfield Police Department?
It may include some other times, but mostly SPD. Yes, sir.
Okay. And there was, you talk in there a lot about the work you did during that time period, and all of the different things you were able to do as a police officer while working in that capacity, correct?
Correct, yes, sir.
But even during that time, you were not just working for the Springfield Police Department, you were going out and doing other speeches, conferences, working in law enforcement for other agencies, consulting, correct?
For the U.S. government, yes, sir. For other entities, correct.
Yeah. In fact, during 2001 to 2007, which is the time when you were a major and a commander at the Springfield Police Department, right?
Yes, sir, I was.
During that time, with all those responsibilities, you also traveled really kind of all over the world to do other events for law enforcement agencies.
Yeah, yes, the city of Springfield, not unique to the city, but they decided in the early 90s to partner with the Department of State. We sent 27 officers to Haiti in 94 to assist in creating their national police force. So our department and city were committed to allowing us to participate in things that seemed to be in the interest of the government. So yes, sir, I had that support. If you hadn't had it, you couldn't have done it.
Thanks for offering that extra bit. I just simply asked you if you'd done a lot of that, correct? I didn't ask you about the other officers, right?
That's true, you didn't.
Okay, so what you did during that time period, for instance, 2001 to 2007, in 2001 you went to Canada to speak at a Chiefs of Police conference.
Probably more than one, but there may be one reference there if it was significant, yes, sir.
In March of 2002 you went to Asia to speak for the Department of Justice.
You said Asia?
Yep.
Okay, Indonesia? Is that what it says? I just don't recall the Asia. I mean, I don't think I would have been that general on my CV. It probably was Indonesia or East Timor.
East Timor.
East Timor. That sounds more like what I would have written, yes, sir.
And that is followed by the word Asia.
Okay.
No geography expert. I can't tell you where East
Yeah,
Timor is.
continent versus country, but yeah, thank you.
Okay. No. Okay. In 2002, you also went to Canada for the Chiefs of Police.
I'm sure I did, sir.
In 2002, you also went to England for a weapons conference.
Yes,
Yeah.
sir.
In November and December of 2002, you went to Africa for the Department of Justice.
Correct.
In March and April of 2003, you were in Africa for the Department of Justice.
I agree.
In October of 2003, Scotland for a weapons conference.
Yes, sir.
November of 2003 in Jamaica for a conference from the Police Executive Research Forum,
Correct.
law enforcement agency, correct?
It is like the IACP, but for bigger agencies, yes, sir.
England in 2004, February of 2004.
Correct.
In 2004, in June and August, you were in Greece for the Olympics.
I was.
And in March of 2005, in Yemen.
Correct.
June of 2005, back in Canada.
Agree.
July of 2005, back in Yemen.
Yes, sir.
May and June of 2006, in Uganda.
Correct.
June of 2006, Tanzania. October of 2006, England. October of 2006, Ireland.
Sounds correct.
Those are all for law enforcement purposes.
Exclusively, yes, sir.
And that was just what you did in those years while you were a commander at Springfield.
Correct.
Of all the entries that you told us about in your CV, you have, whether they were appointments or speeches, would you agree that the great majority of them are law enforcement groups,
I think they're exclusively law enforcement groups, sir.
such as the National Tactical Officers Association,
Yes, sir.
International Chiefs of Police,
Yes, sir.
Department of Justice,
Yes, sir.
the Police Executive Research Forum,
Correct.
Association of Chiefs of Police, right?
Yes, sir.
The Armed Police Officers National Training Conference,
Yes, sir.
the Law Enforcement Television Network.
Yes, sir.
And that's just exactly what it sounds like, is a
It's a training process that gives televised training versus in-person for law enforcement. Yes, sir.
International Association of Law Enforcement Firearms Instructors,
Yes, sir.
the American Association of Law Enforcement Trainers,
Correct.
Illinois Tactical Officers Association.
That would have been their annual conference. Yes, sir. I would have taught at that.
I'm sorry, I didn't hear you.
At their annual yearly conference. Yes, sir.
Institute for Law Enforcement Administration.
Yes, sir.
Let me just run through some of these, and I'll ask you a question then. The Indiana State Tactical Officers Association, the Ohio State Tactical Officers Association, the Massachusetts State Police, the FBI, Wisconsin State SWAT Association, the Oregon State Sheriff's Conference, the the Utah State Sheriff's Conference, the Colorado State SWAT Association, and the LAPD.
Yes, sir.
All groups that you have done things for frequently.
Yes, sir.
And in fact, there's only a couple of things on your CV that are questionable whether law enforcement. You've done some things for the Convoy of Hope.
Sure. I think that might be under a different heading. But yes, sir. Worked for Convoy of Hope doing overseas relief stuff in Haiti and Nicaragua, places like that.
And even with that, you're still providing security and law enforcement function, correct?
It just depends. With Project Hope, no. That's exclusively leading teams to orphanages and things like that. With Convoy, I've done security assessments for them. But the majority of the work overseas in that context is a group called Project Hope, and that's not been security.
Okay. You did some things for the Penn State University Applied Research Lab a couple of times, right?
That's law enforcement, though. I mean, the Penn State Research Lab is less lethal weapons technology.
What you describe as your professional accomplishments are all from law enforcement groups.
Beyond question.
As Mr. Eng asked, the Hall of Fame for American police officers.
Yes, sir.
I'm sure that was quite fulfilling to be elected to the Hall of Fame, right?
Not in the context for what I got it, but understandable.
Okay. What could you mean by that?
It involved using deadly force against a person, and I didn't ask for that award.
Then, the Board of Directors of the National Tactical Officers Association.
Yes, sir.
Police Chief Magazine.
Is that reference to being on their policy, or I'm not sure when you say Police Chief Magazine. I've written for them, but I've also done editorial review for them, so I'm not sure what your statement there references, sir.
It's in your professional accomplishments section. So
Okay.
Those are all law enforcement organizations.
Yes, sir.
Any writing that you have done has been for law enforcement trade magazines,
Exclusively. Yes, sir.
including the International Association of Chiefs of Police. It's tough to say. The magazine for that group.
Yes, sir.
And the National Tactical Officers Association's publications.
Correct.
So this is something you've really committed yourself to, 110% probably, law enforcement.
I would agree with that.
Career police officer.
It's all I've ever done.
You have also been retained before to offer expert opinions on law enforcement conduct.
Correct.
And I want to just clarify one point, if I could. You indicated on your direct testimony that you have 4 current cases, and this is the only one where you're testifying on behalf of an officer. Is that right?
I've got 4 current criminal cases under review. I probably have 20 civil cases, but only 4 that are criminal.
And this is the only one where you've been retained by the officer.
Correct. In the other 3, it's either an attorney general or a prosecutor would be. I don't know how to characterize it other than to say my testimony would not be supportive of the officer's use of force. That would be the best way to say it.
All right. So I really want to clarify that, because it's true you have been retained in this jurisdiction by another police officer on their behalf, correct?
From my perspective, this particular case from day one was to take a look at the issues, initially focusing on the taser, and just give my,
When you say this case, what are you talking about?
the case we're sitting in right now.
Okay, well, I didn't ask you about that. You have been retained on behalf of an officer in another case in this jurisdiction, correct?
You mean, do I have another one right now?
Yes. You told the jurors you have 4 open criminal cases, right? You said this
I
case.
think I'm following you. I've actually got 5. I apologize if if I think where you're leading to. I am involved in another case that I just realized that would be more supportive of the officer. So I actually have 5 right now. I've not done an expert report. I've not testified. I may be on the wrong case, but I do have another one I just thought of that I've not done anything on as far as a formal report or anything. So it would be 5.
And I'm not interested in having you talk about the name of that case or anything about
Okay.
that case, but I just want to make sure that it's being represented correctly to the jurors, okay?
Right. I would have a second case in this jurisdiction that would be, as you're characterizing it, in support of an officer. That's true. I would guess I was trying to focus on those I'd either done reports on or done something formal on, but I currently am involved in a 5th case, so it would be a 2 to 3, not a 1 to 3.
You did a report in that case,
In this current case,
in the other case here,
yes, sir, I have.
and a lengthy report.
Well, a report, yes, sir. I mean, longer than this one, yes, sir.
You have testified in court on a number of occasions as an expert witness.
Yes, sir.
These facts of being retained and having testified really not described in your CV, are they?
I couldn't hear the last part of what you said, sir.
They're not described in your CV, your resume, are they?
In my report?
In your resume, your CV, your curriculum vitae that Mr. Eng asked you about.
I don't understand the question, sir. I'm not hearing something, apparently.
I've been asking you questions about your CV, which is for the Latin term curriculum vitae.
Yes, sir.
I assume it's Latin. It's a fancy word for resume.
Yes, sir.
In that resume, you've listed a lot of your experience and your accomplishments and your awards and your trainings, right?
Yes, sir.
But you don't list in there how many times you've been retained as an expert.
I don't think in my CV, no, sir, at all.
And so you do not recall who sought you out or whether you approached the defense in this case or they approached you.
No, I don't think I approached anybody that I can recall ever that I can recall. I had a prior case with Mr. Eng, and I'm thinking the two overlapped. I just don't have a perfect recall of how we got together.
Okay. And you are doing this for free because somebody's liberty is at stake.
As I do in every criminal case, yes, sir.
And that's pretty important.
It is to me.
You indicated in your direct testimony you like to get paid, but you're doing this for free, correct?
I think like most people, you like to get paid for your labor, but some things are more important than money, so that's the decision I made, right or wrong, a long time ago.
You have indicated you have 43 years of experience in law enforcement, correct?
Continuous commission, yes, sir.
You have been doing at least 25 years of evaluating police officers' use of force.
I think that would be fair. It didn't really begin till I was a supervisor, so late 80s, yes, sir.
And you have testified as an expert, been retained to offer opinions.
Many times, yes, sir.
You are familiar with the constitutional cases on police use of force.
I am. I mean, I'm not an attorney, but I'm familiar from a police perspective, yes, sir.
And you try to teach those concepts to others.
From a police perspective, yes, sir. Not a legal perspective, but a police perspective.
And you indicate you have worked on several thousand police use of force cases over the past 25 years, right?
I think 2,000 to 3,000 would just be a fair estimate of applications of force involving law enforcement I've reviewed, yes, sir.
And in this case, this present case involving somebody's liberty, you were asked by the attorneys to review the materials and offer expert opinions concerning the police practices involved, right?
Yes, sir. Not all of them, but yes, police
What
practices.
were you asked to offer an opinion on?
As best I can recall, sir, the initial focus was on the taser itself. Of course, to use the taser, you have to have a lawful basis to have your feet where they were, so that involves stopping the vehicle, and then whether you would do things once you got there. But it was primarily focused on the stop and then the taser application.
And with all of that, you wrote a report, correct?
I did.
Your report is just over 2 pages long, is that right?
It's 2 or 3. Yes, sir, that's correct.
The opinions that you have, to me, seem to start about halfway down the second page.
I'll have to look. Yes, sir.
So the sum total of paragraphs in which you have opinions would really be 3. Is that right?
What was the number you said? I didn't hear it.
3.
Sure, that'd be about right.
You express your opinions as you have today on the stand in terms of contemporary police practices. Correct?
In response to questions concerning that, yes, sir.
None of your opinions today or in your report have utilized the phrase an objective officer in light of all the facts and circumstances known, an objectively reasonable officer in light of all the circumstances known at the time, correct?
I'm not certain, but that could be.
Well, I'm just saying, the way you have written your opinions, you did not use those terms.
Okay.
Is that true?
What term specifically, sir, am I looking for?
Whether an objectively reasonable officer in light of all the facts and circumstances known to the officer at the time.
I don't think I used those words in my written report, sir.
During your testimony today, you never used those terms to express your opinions, did you?
I don't recall.
Well, I recall, and I don't believe you ever used those terms for your opinions. The only time you used it was in reference to a Supreme Court case, correct?
I don't recall exactly what you're talking about, but I'm reasonably certain you're probably right.
In fact, when you were taking issue with the proportionality concept, you said it's a lofty goal to have proportional force.
Yes, sir.
You don't think that's something of a legal requirement?
I think there are cases that suggest that, but not to the standard of objectively reasonable behavior, which we have in Graham, which is the big focus.
And that was when you said objectively reasonable in referring to a Supreme Court case, which Graham is, correct?
It is, yes, sir.
Mr. Imes, do you have a copy of your report with you?
I do.
Did you actually write this report?
I did.
Okay. Did you write it before reviewing all of the materials?
I would have written it long before I reviewed anything last week. So I wrote it after I looked at the case that was supplied to me on flash drives.
Okay.
But certainly I learned things last week that would not apply to that report.
All right. And you have a copy with you?
I do, yes, sir.
Your Honor, may I approach the witness to take a look at that? May I look at your copy?
Sure.
At the bottom of your report, below your signature, there are a few lines written there. One of the lines is, I need all of the records mentioned and easy access to the video, correct?
Correct.
So if you needed all access to the records, how did you write this report if you hadn't had them yet?
I don't even know what that is. I had Mr. Ing print this for me yesterday, so that would not have been on the report that I submitted back in September. I just I didn't bring a copy with me.
The report that was disclosed to us from Ms. Potter's counsel is exactly the same as the one you're looking at. It has that
Okay.
line on there.
I'm just not remembering what that was in reference to. I certainly need all the records mentioned, et cetera. I don't,
Well, why would that be on your report below your signature if you had reviewed all of the records before you wrote your report?
I would have reviewed everything sent to me up to September. I just have no recollection of what else might have been mentioned. To be candid, I don't understand what that suspended question mark, engine status question mark. I don't really know what that is. So I'm at a loss to tell you.
Yep, so it also says they're suspended question mark, correct?
Suspended with a question mark, yes, sir. I really don't know what that is.
All right. In your review of the case, are you concerned about or curious about something being suspended or someone?
I have no idea. Engine status, I mean, I really don't have any recollection of what
Well,
that references to.
I do want to ask you about that one, engine status question mark, correct?
Yes, sir.
You told the jurors today that the whole issue of shooting occupants of a vehicle was not black and white, but it is a concern of shooting somebody who is operating a vehicle, right?
Or behind the seat in any capacity, yes, sir.
Okay. So whether the engine was on in that vehicle would be a pertinent consideration, wouldn't it?
It'd be one step closer to movement, yes, sir.
So at the time you wrote your report, you were still questioning about the engine status?
I just don't remember what that means.
Did you ever find out if the engine was running?
I believe that it was, yes, sir. Keys in the ignition.
In your review of the body-worn camera videos, all Mr. Wright had to do was put it in gear to drive off, correct?
I'm not sure exactly how that vehicle works with brake and gear, but pretty close to that. That would be it.
Well, I think all vehicles require a foot on the brake to put it in gear, right?
I don't know.
Okay, fair enough. At the time of the shot, Mr. Wright's feet were on the driver's side floorboards, correct?
From my understanding of the video, yes, sir.
Now, it's your opinion here today that, and in fact, when you wrote your report, that Ms. Potter only meant to use her taser, correct?
That's my understanding. I've not seen anything to suggest otherwise.
And one of the reasons you believe that is she only pulled the trigger once.
That's a factor. I mean, it's not a significant factor compared to other things, but that's a factor.
Well, probably the largest paragraph in your report is just about that very fact, that she only pulled the trigger once.
I'm just saying there's other factors such as verbalization and
Sure.
things like that that are more reflective.
Okay, but you told the jurors it's not a significant factor, but it took up a lot of space in your just over two-page report.
May have required a few more words to explain that, yes, sir.
And what you're explaining there is officers are trained, if you're going to pull the trigger on a gun to use deadly force, you pull it multiple times, correct?
That's not necessarily true. It's just operationally they do. They rarely pull one time only. In some scenarios, they're taught to shoot more than once double tap. We don't teach to shoot in every case multiple times, but that's more common, of course, than just a single shot.
So when you were asked to provide a report for the attorneys who had retained you in this matter, you pointed out here that the number of times she pulled the trigger was a factor to consider, right?
Yes, sir, that's correct.
And what you said, what you wrote is, police firearms training nationwide generally involves rapidly pulling the trigger multiple times, and discharging rounds is necessary to stop a suspect's threatening behavior.
Generally, as I said, yes, sir. Not in every case, but generally.
Taser training, in contrast, involves a single pull of trigger.
Press and release, yes, sir.
So that was a fact that you put right up front in your report in your analysis of your
Yes, sir.
conclusions. And, I mean, as you sit here today, as an expert, do you agree that an officer's use of force is evaluated by the reasonable officer standard?
That's a segment of it, yes, sir, in the Graham case, the reasonable officer standard, correct.
But really, for you, it's police practices and training. That's been the focus of your entire career, is training police officers.
Well, the reasonable officer standard is not some magical component of a police officer. It is the fruit of their training, their organizational culture, policy. They just don't raise their hand and get commissioned and become reasonable. We teach them. We try to prepare that. So,
But your perspective, your entire career has been devoted to training officers in their practices and conduct.
to be reasonable, yes, sir.
All right. So you must agree then, by pointing out the number of trigger pulls, that an officer's actual conduct can indicate what a reasonable officer knew at the time.
It would be one indicator, not necessarily everything, but certainly.
So you would have to agree then that because Ms. Potter only pulled the trigger one time, as with a taser, there's no reason to believe that a reasonable officer in her position at the time believed that shooting her gun was a necessary use of force.
I think I understand you're asking whether at the moment she fired that. I don't think I should try to interpret that. Could you just say it again, please?
Sure. You would agree that because, I mean, you pointed out the number of trigger pulls,
I did.
and you did that to support your opinion that she did not mean to shoot her firearm, she meant to use her taser,
It indicated less likely, yes, sir.
and indicated the use of less lethal force.
Correct, yes, sir.
And so you would have to agree then, since you're relying on it, that because she only pulled the trigger, she did not, a reasonable officer in her position would not have perceived a reasonable basis to shoot their gun, to use lethal force.
Well, I guess I don't know. I've not read any testimony from her what her perspective was, but from what I've seen in the video, and the assessment would be that an officer in her position was not perceiving the need to use deadly force, and so the use of the taser would have been the appropriate tool, and that's what she was trying to do. But I've not heard directly from her, so I just don't know that.
You agree, I mean, it sounds like you're kind of saying that this Mr. Smith gave you the opportunity to be the first taser instructor. Was that what you were telling us today?
I was in the first class
Okay.
of the master instructors. There were about 20 of us in 1999.
And proper targeting is a very common topic taught in taser training, correct?
That's a target that's, or a topic that's common and important, yes, sir.
And you agree that good probe spread is important to a taser achieving neuromuscular incapacitation.
That's the primary factor, is probe spread.
It sounded like what you're saying is sort of in the same way as having to shoot somebody in the head to immediately stop them, correct?
That would be more likely than the body, yes, sir.
Okay. But a taser deployment is not always effective at achieving neuromuscular incapacitation.
The best studies are about 67% of the time. From a practical, no excuses, did it work, did it not, about 67%.
So that's a lengthy way of saying no, it's not always effective, right?
I couldn't hear you, sir.
That's a long way of saying no, it's not always effective.
I guess, sure.
And I think your testimony was when a person is sitting down, you might be able to achieve a good probe spread just because they're sitting.
Because of the bend in the body, yes, sir.
But if the taser is only a foot or two away and pointed at the area of the chest involving the heart, that's not really going to, that may not achieve good probe spread.
It just depends on how far the heart is from the thigh. I don't know, but it may or it may not. If they're sitting up high enough that it doesn't get to the thigh and split the belt line, then the answer would be no.
But if an officer is trying to achieve that total neuromuscular incapacitation immediately, that's an important consideration, isn't it?
It's the key consideration for the taser to work, yes, sir.
And you agree that one of the purposes of the taser verbal warning is to alert other officers
It is.
and to let go of the suspect, subject, whatever term you want to use.
I can tell you from a training, do you want me to just answer yes or no or to explain stuff?
Go ahead, tell me.
From a training perspective, the answer could be yes or no. The warning is designed for a number of things. One significant factor is there's been a concern about officers perceiving the pop as a gunshot and somehow reacting inappropriately. So that's one issue. The second is to make sure you're generally out of the path of the probes. If the officer saying that is there and I'm between you and that suspect, I would want to move. Generally, keeping a hold of a suspect may in fact be valuable during a taser deployment. Taser specifically instructs controlling under power, which means handcuffing while they are energized. And so having a hold of them when they're hit, if it occurs safely, is really the best place for you to be, because then you then move to handcuffing and don't have to reach to re-engage. You just put them in cuffs while they're being energized.
But it wouldn't be unreasonable for an officer to let go of somebody who's about to be tased from a foot or two away.
It would not at all.
You testified a little bit about this distinction between operating and driving a motor vehicle, so I want to talk to you about that.
Okay.
You're familiar with, I guess, training or practice on shooting occupants of a motor vehicle.
I want to be responsive to your questions. I don't recall any specific training on shooting occupants of a motor vehicle ever in my career. We have training that involves concerns about that, but there's no block that says today we're going to do shooting occupants of a vehicle. So that's the best way I can answer that. I'm not familiar with that particular block of instruction. I'm familiar with many blocks of instruction that include unintended secondary consequences, like a person in a tree who gets tased and they fall. So I am familiar with training that speaks to what might happen if you shoot a driver.
Okay, so let me back up a little bit. It sounds like you're still talking about tasers, correct?
No, either way, I just gave you an
Okay.
example of secondary consequences of the shot itself.
An officer has to consider secondary consequences, collateral injuries, correct?
Not just with a taser or a firearm, really with everything we do.
Exactly. The example you gave, tasing somebody in a tree, they may fall out of the tree.
Yes, sir.
And you have tried to explain to the jury today, I think, about tasing somebody who's operating a vehicle.
Yes, sir.
So, but this general notion about using force on an occupant of a vehicle, right?
Right.
Comes from the very common sense and understandable concern that if somebody's driving a vehicle and you do something to them, the vehicle could become an unguided hazard, could become dangerous to others.
No question about it.
So is there training that police officers get, and you teach, about the dangers of shooting or incapacitating people who are driving motor vehicles?
I'm not familiar with any block that is specific to that, but I'm familiar with many blocks that reference it.
All right, maybe we're splitting hairs. It is a concern, isn't it, that it could cause collateral injury.
Any application of force when a person's involved with a mechanical conveyance, for an example, raises with it the collateral concern of the conveyance itself. It's different than standing in the street if you're on a bicycle. So all training, force application, involves collateral concerns such as an accidental fall down and they hit their head. I've never had a block unique to that, but all, in my experience, involves that.
Does the average officer in the street know this?
You said, does the average officer on
Yeah,
the
I mean, you
street?
talk about contemporary police practices and training, and this has been your career. Does the average officer know about this danger?
Which specific danger are you asking me, sir?
Well, let me just rephrase the question.
Okay.
Did you review Brooklet Center Police Department policy about shooting into motor vehicles?
I don't recall.
So you're not familiar with the policy that Ms. Potter would have been subject to as a Brooklyn Center police officer.
I'm just saying I don't recall it, sir.
In that policy, it talks about discouraging, I'll be kind with my words, shooting at occupants of motor vehicles.
Okay.
Now, would you agree with me that the reason for that is the potential for collateral injury when you disable the person driving the motor vehicle?
I just have to have you hand me the policy and let me read it to get the context. I don't remember it, so I just can't tell you.
But that general concept, do you agree with the general concept that that's the concern, is the risk that causes?
The greater risk that comes to my mind in the question you're asking would be concern about people close by, not the person driving off. So in the absence of reading the policy that apparently expresses the concern you're saying, I'd be guessing to tell you what they're trying to communicate to her in that policy.
Your concern is about others, right? I mean,
I'm saying you're asking me if it's the vehicle driving off. I'm saying my primary concern would be if there's passengers, someone close by would be more of a concern than the person driving forward.
if a vehicle that's being driven, if the driver is shot, it's not going to make them a safe driver, is it?
No, sir.
So that's the danger presented, right? They not only are you shooting that person, but you're putting others at risk because you've got a vehicle that's moving that could harm somebody.
It would depend completely, sir, on the circumstance if we're in a downtown street compared to in the middle of a cornfield. So it depends on the circumstance which one of those would be a greater risk.
I guess I think we're just arguing in circles here. Right?
I'm just trying to answer your question, sir.
And I think we're spending far too much time on this. But what I'm simply asking you is that a concern for collateral injury if you incapacitate a person driving a motor vehicle?
If you ask it that way, the answer is certainly and quickly yes.
All right. We were kind of going in circles. So you draw the line then at a vehicle that's moving and a vehicle that's not moving.
Well, moving clearly is in a condition to go forward. If the vehicle's in park and the shot is effective, then the vehicle's very unlikely to go forward. So I would draw that distinction, yes, sir.
So if a vehicle has a person in the driver's seat and all they have to do is shift it into drive, that situation doesn't present the same dangers at that moment as the vehicle that's already moving?
It does not.
Doesn't present any dangers at all?
That's a different question. There's still danger. If they're immediately incapacitated and the vehicle's in park, it's going nowhere. If they're not, then it certainly presents a danger if they have the capability to put it in drive.
You expressed some familiarity with Minnesota law about being in control of a motor vehicle.
I'd read actually, I was curious, and I actually searched the statute, and there was a reference to operating. And it talked about feet, positions, conveyances, just I don't have it verbatim, but it specifically talked about what operating was.
What statute was that?
I can't tell you from memory. I just went to Minnesota statutes and literally Googled the word operating. And it was a statute in reference, I believe it was either car crashes or intoxicated driving. They were just a reference to conveyances or parts of the motor vehicle that allowed its movement.
Could a person under Minnesota's DWI laws be charged with the DWI for sitting in the driver's seat with the keys in the ignition and their feet in the floorboards?
It calls for a legal conclusion.
The objection is sustained.
Well, you told the jurors that you read some statute. I think it might have been, well, was it the DWI statute?
I just don't recall. It was just a reference to operating, and I just mentioned that in the fact that Minnesota statute even talked about operating a vehicle, so that was the sum total of that.
All right. In your report, you used the term operating/driving, correct?
Yes, sir.
Then you went on to use, in the next sentence, operational / driving condition, correct?
Yes, sir.
If you're drawing the line only at a vehicle that's moving, why did you feel a need to, in your just over 2-page report, add the term operational to that? Why didn't you just say moving or driving?
I don't recall.
Well, could it be that you actually did realize a person who is in a position to drive a vehicle, just simply all they have to do is put it in drive, presents the same kind of concern an officer must consider when they're going to use force on that person?
That would not be true because it's not the same concern driving versus in a status ready to drive. It's not.
Not the same concern, but a concern.
I've not disputed that, sir. That is significantly concerning, but not the same.
And not a sufficient concern in this case when Mr. Wright is sitting in the driver's seat.
I'm having trouble hearing the question, sir.
Not a significant enough concern for you when Mr. Wright was sitting in the driver's seat with the engine running.
I don't understand the question.
All right.
What are you asking me?
I will ask you. If a subject is sitting in the driver's seat, their feet on the driver's side floor, hands by the steering wheel, the engine running, should an officer take those facts into consideration when deciding to deploy a taser on that individual?
Agree.
Isn't this particularly true if giving the verbal taser command could cause officers to let go of that individual?
It would certainly give that individual a little more time. Yes, sir.
Now, it's your opinion that if Mr. Wright had been in a position to operate that vehicle, it was not unreasonable for Officer Potter to consider a taser deployment.
Agreed.
You used specifically the word consider.
Agreed.
It's your opinion, though, that Mr. Wright was not in a position to operate that vehicle.
It's not my opinion, sir. He could have and proved that he could drive the vehicle. He did it.
In your report, you state, in the immediate case, Mr. Wright was not operating or driving the vehicle when the taser attempt was appropriately initiated.
Correct.
So is it your opinion that he was not in a position to operate or drive that vehicle?
He was in a position to operate it. He wasn't operating it at the time. That's my opinion.
Now, again, you have all this law enforcement experience, 43 years, correct?
I do.
Several thousand police use of force cases over the past 25 years.
Correct.
Right. You have been retained as an expert in civil and criminal matters
I have, sir.
and testified. Right?
I have, sir.
You understood immediately upon being contacted about this case that an officer had shot and killed a man, correct?
I was aware of it, yes, sir.
And her attorneys asked you to offer an opinion regarding the police practices involved, correct?
With the primary focus on the taser. That was our discussion, but the police practices involved with a focus on the taser.
Did they limit you to just the taser question?
Objection.
With product, the objection is sustained.
Your Honor, may I be heard on that?
Yes.
The objection remains sustained.
So, with all of this experience and in your initial report, you did not at all address the use of deadly force.
I did not, sir.
Did you review Professor Stoughton's report before today?
I did, sir.
And when did you review that?
I don't recall. It would have been in the last month or so.
There was a discussion in that report about deadly force, correct?
There was, sir.
You still did not notify Ms. Potter's attorneys that you had some position on deadly force.
The objection is overruled.
I didn't feel compelled to go opinion for opinion with him. My opinions were focused primarily on the taser, and I read that, and I just didn't feel I had any compulsion to go back and say, he has this, I have that. It wasn't that kind of report. I wasn't in an argumentative process with him.
So
I
it
just had to
wasn't-
focus on the taser.
I'm sorry. So it wasn't until the testimony of Sergeant Johnson was pointed out to you that you suddenly had an opinion about deadly force.
When I was asked specifically about it, yes, sir, after I watched that testimony, that was it.
And so it was counsel that approached you about providing a deadly force opinion based on that testimony.
After the testimony last week, yes, sir.
Yeah, excuse me, just a moment, please. And you met with counsel before testifying today, correct?
Last night, he came to the hotel, yes, sir.
And you indicated that you then had an opinion about the use of deadly force, correct?
No, it's not last night. It was whenever the testimony occurred last week. I didn't see it live. I don't recall whether it was an email or a call, but he then said, hey, I want you to watch this testimony and give an opinion concerning the use of deadly force. This sergeant has introduced this. And, I mean, we talked about it last night, but that wasn't the first time.
All right. And is it true that all you said last night was, given Sergeant Johnson's testimony, deadly force was appropriate? Is that all you told them about your opinion?
Are you talking specifically last night in lieu of any other conversation?
Correct.
Objection privilege, what he told us.
All right. I'm going to let you go a little further.
Okay.
All right. You may answer. You may re-ask your question.
Is all you told them last night, given Sergeant Johnson's testimony, deadly force was appropriate?
I just don't really recall exactly. I think I would have said a lot more than that.
Your Honor, may I approach the witness?
Yes.
Ask you to review the last line of that, please.
Right. It looks like Mr. Ing writes, given Sergeant Johnson's testimony, deadly force was appropriate. I think he was taking notes during a couple-hour conversation. I can't speak for why he reduced it down to one sentence, but I said more than those words.
Now, Sergeant Johnson did not testify about a reasonable officer in Officer Potter's position, did he?
No, sir.
So the subtotal, and we have to assume, because I don't know what happened in that couple-hour conversation, it sounds like what you're saying today is that based on Sergeant Johnson's description of where he was at the time, that's what allowed you to then now formulate this opinion about deadly force, correct?
It wasn't just that, but that was a part of it.
Even at, well, when you were asked to do the review you did, you had full access to Sergeant Johnson's body-worn camera.
I did, yes, sir.
And you had access to the dash camera from Officer Lucky's squad car.
I did, sir.
And you had access to Officer Potter's body camera.
Correct.
And Officer Lucky's body camera.
Correct.
And you also had the written reports from those, from Lucky and Johnson.
I did, sir.
And the opinion you formed after reviewing that, based on your training and experience, was that Sergeant Johnson was leaning into the car from the passenger side.
Correct.
And today, Mr. Eng asked you to agree that Sergeant Johnson was half in and half out of the car.
I don't recall him asking me to agree to that. I mean, I've seen the sergeant's testimony. I can't tell you exactly where he was. He was probably more out than in, but he didn't ask me to agree to that.
And so this fact that you claim from Sergeant Johnson's testimony, that was the first time you thought deadly force was appropriate?
Which fact are you saying I'm claiming?
Well, when Sergeant Johnson testified about his position,
Correct?
and that only happened here during trial. It never occurred to you before trial.
I didn't assess this from a deadly force perspective in Sergeant Johnson. As I've said, I looked at this case initially and almost exclusively from the key factor from my perspective in my initial assessment, which was the issue of taser, a decision to use, and manner of use. I wasn't looking at it from a deadly force perspective, and so I wasn't trying to opine on every facet of this entire case. The crux of the case is the issue of the taser. And that changed when I was asked. I didn't just decide to do it. I was asked, based on apparently testimony that Sergeant Johnson did, to look at that particular issue, and then I did it.
Your Honor, I would like to show the witness exhibit 63. This is the body camera from Officer Johnson. And I would ask that we put that or go to the moment at 2:01:59.
Permission granted.
You can put it on. I don't know if we need to fire up the thing here. At this time, you would agree that this is the time, from your review, this is the time when Officer Potter is saying she will tase him. You would agree here that Sergeant Johnson has his hands on Mr. Wright's right arm, correct?
Yes, sir.
And this was part of Sergeant Johnson's testimony the other day, correct?
It was.
This exhibit was shown and he narrated what was going on here? You saw that happening?
I recall that, yes, sir.
Then if we can run this for another second, please. You agree that at 2:02, 00 here, we can hear Officer Potter saying taser, one of the three commands taser in the background, correct?
I think so.
And here we see Sergeant Johnson's feet on the ground and his hands holding Mr. Wright's hand
Yes, sir.
over to the right side of the passenger side of the car.
Correct.
Clearly not half in or half out, is he? Sergeant Johnson, I mean.
Well, I don't know how you would classify exactly half, but as I think I just testified to, probably more out than in is what I said a moment ago.
All right, so bear with me, please. You testified on direct that when there is a warrant, an officer has to make an arrest.
That may vary by state statute, but in my opinion, yes, sir, that's an order from the court.
Well, you told us about a Missouri statute, right? Making
I
it.
did reference my state. I'm just saying it may vary some by state, but I think that is an order from the court, yes, sir.
I'm not disputing you that a warrant authorizes an arrest. I'm not disputing that at all. But you said it was a mandate.
It is in my opinion, yes, sir. I don't see anywhere on there as a suggestion. It says an officer is to arrest.
And but in making that arrest, officers still have to use reasonable force, correct?
Certainly.
Can't just shoot somebody because they decide not to cooperate with being arrested.
And I didn't hear the question.
If an officer is trying to arrest somebody on a warrant and the person pulls away, the officer can't just shoot him.
Of course not.
You were asked about how many critical incidents in your career you identified. You tried to define that term. Basically, it's a very risky situation for police officers.
I think that's fair, sir.
And others probably as well, right?
In many cases, yes, sir.
And you've been in a lot of those situations.
I have been.
And you've been with other officers involved in those situations.
I have been.
And those are life-threatening situations for you and other officers.
Many are.
Officers were there to help you in those incidents, correct?
They were.
You testified on direct that you got some material, but you didn't review all of it before writing your report. Is that what you
Correct.
testified? Just decided what you'd seen enough, or how did you decide what to review and what to not review?
The file had voluminous medical information, which was not relevant at all to my opinions. Not that I decide I have enough. I just try to commit time and energy to things that make sense for my opinion.
And so then you also testified that a warrant for a gun violation could make an officer more alert about potential danger, correct?
It should, for certain, yes, sir.
Certainly don't dispute that with you, but could that include something like when approaching that person, unsnapping your firearm holster to make it more accessible to you quickly?
It may for some officers, based on their training and experience. For most, the answer is no, but it may.
And that warrant, you're saying, is just one thing for an officer to take into consideration, right?
Yes, sir, just one of many.
Still have to use reasonable force in making that arrest, correct?
Yes, sir.
An officer in making that arrest could also be derelict in duty if they use unreasonable force.
Yes, sir.
You testified about, I think the terms you used were initial scuffle. Do you recall using those terms?
Yes, sir.
But it's true that nowhere in the body cam videos does it appear that Mr. Wright has assaulted any of the officers.
I didn't say he assaulted anyone, sir. I said there was a physical scuffle and he got back in the vehicle. He struggled to control.
My question for you was, did you see in anywhere of the body camera videos that Mr. Wright assaulted any of the officers at the scene?
Okay, I didn't hear that question presented that way. The answer is no.
You talked about body cam videos and the perspective of those, and you said that a slice is helpful to show whose hand is on something, but you said that a slice of that video would be helpful to show whose hand is on the shift knob, for instance, right?
That's one example of where a freeze frame is helpful, yes, sir.
But it may not be what an officer would perceive
Correct.
or would have difficulty perceiving.
Beyond question.
But the officer whose hand it is would already know their hand is on the shift knob.
Independent of the video, they would know that, yes, sir.
And that officer, if they are preventing that shift knob from moving, would know that that vehicle can't be moved.
At that moment, if they're effective, yes, sir.
Now, you told the jury that the model TASER policy is one that you wrote up, correct?
I authored the 2007 iteration up to about 2018 for IACP, yes, sir.
And did you review Brooklyn Center's TASER policy for this
I did.
case? It's not your policy. It's not the one you wrote.
No, it's not the IACP model policy. It's their own policy.
So the standards that you applied for your definition, there were two of them, are not in the Brooklyn Center policy, correct?
They're not that exact policy, correct.
And in fact, what the Brooklyn Center TASER policy is that Ms. Potter acknowledged receiving and was trained on every year, right? You know that, right?
Yes, sir.
She's certified every year. She had to go over the policy as part of that training. You saw that in the records.
Yes, sir.
And that TASER policy plainly says that the TASER can be used when the subject is violent or is physically resisting,
Correct.
where the subject has demonstrated by words or action an intention to be violent or physically resist, and presents potential harm to officers, him or herself or others.
That's the language I recall, sir.
Different than the policy you wrote up.
It has different language, and most agencies are more restrictive or add more information than a national policy. Yes, sir.
And you would agree that it is more restrictive in the use of a TASER than your policy.
Then the national best practices policy. Yes, sir.
Why is it the National Best Practices Policy? Why do you call it that?
Because it's from the International Association of Chiefs of Police National Policy Center, created by the largest professional police organization in America that every chief's a member of, in partnership with the U.S. government.
In which you have been a member of for how long?
I've been a member of the organization since probably the mid-'80s and served on that policy board for probably 20 years in one capacity or another.
You took issue with Professor Stoughton's explanation about probe spread, right?
I just disagreed with it.
I'm sorry, I didn't hear
I
you.
just disagreed with it based on what I know about how tasers work.
Okay. You talked about the TASER 7. And it's it's true that the TASER 7 you can order with close quarters cartridges.
You can if you choose to.
And you were telling the jurors that this Taser 7 now has a close quarters cartridge that makes it more effective close up.
It spreads further if you have that cartridge, yes, sir.
But at, of course, 1 to 2 feet, it's still not going to spread much, is it?
I think it's a 12-degree arc compared to the standard 3.5-degree arc.
Did you investigate at all whether the Brooklyn Center Police Department and the Taser 7 that Ms. Potter was using had a close quarters cartridge?
I did not.
And I'm sorry, a little bit out of order, but we were talking earlier about the testimony of Sergeant Johnson. It was suddenly very
Yes, sir.
important to you during the trial, caused you to have this new opinion about deadly force, correct?
No, sir. I was directed to look at it and asked to consider that. It didn't cause me to do anything different.
Have you, well, let me say it this way. You have not in any way tried to assess whether a reasonable officer in Officer Potter's position would have been aware of Sergeant Johnson's position at the time she fired her handgun into Mr. Wright.
I have not.
Your Honor, may I have just a moment, please?
Yes.
That's all I have, Your Honor. Thank you.
Okay. Mr. Amy, you may proceed with redirect.
At the conclusion of your direct testimony, I gave you a hypothetical where the individual in a case like this actually sees Sergeant Johnson inside the car.
Yes, sir.
Does that change your opinion as to whether or not deadly force could have been used by that individual?
My understanding in our discussion last night and today, I was just caught off guard by reading what was handed to me, was that was what we talked about was a hypothetical.
Right.
If it's assumed an officer in this position was aware of that set of circumstances, and that was the basis for my opinion. Yes,
The
sir.
opinion was that
If that officer perceived that that fellow officer was in immediate deadly jeopardy of being drugged, then the answer would be correct. Deadly force would be justified.
and that would be in accordance with the objective reasonable officer standard that we've talked about earlier today.
In my opinion, it would be, yes, sir.
What would have happened to Sergeant Johnson or Sergeant Lucky if Mr. Wright had put his car in reverse?
Objection, Your Honor. School. Speculation.
The objection is sustained.
And we met last night at the hotel where you were staying, is that correct?
Yes, sir. We
And I
did.
asked you to review Mr. Stoughton's testimony too, is that correct?
Yes, sir.
And we've gone over what the areas were that you disagreed with today, is that correct?
I believe we did, sir.
The word retained was used a couple times for you. You were not retained in this case, is that correct?
Not by my definition of retention, no, sir.
Is it a violent felony to flee a police officer by accelerating a car away from them with a passenger in it?
No objection?
Objection. School.
The objection is sustained.
No further questions.
Any recross?
Just want to make sure I understand what you're saying. What was discussed last night, first of all, is not included in that memo, that email I showed you, correct?
That 7 or 8 words reduced down, apparently, that Mr. Ring said did not capture what was talked about in the entirety. No, sir.
But what you're saying here today, telling the juries, is if there was a hypothetical where the person knew that Sergeant Johnson was in the car.
That's exactly how I characterize it back to Mr. Ing. If it is assumed this set of facts, then my opinion would be that deadly force was justified.
So you're not offering an opinion about the actual facts of this case, you're just offering a hypothetical.
I don't know the actual facts in this case. I've not heard Officer Potter testify concerning that, so that's correct.
Have you examined other facts in the case to determine that without regard to Officer Potter's testimony?
No, sir. I don't think I understand exactly what you're asking, but the answer is no.
So, for example, you use the number of trigger pulls to reach some conclusions about whether she meant to shoot a taser or a firearm.
It is. The objection is sustained. And it's been asked and answered as well.
So you are telling the jury here only that it's a hypothetical, force could have been used.
I didn't hear the last part, sir.
Force could have been used, deadly force could have been used.
If that set of hypothetical facts were assumed, yes, sir, that's my opinion.
But really the question regards whether a reasonable officer in the position that Officer Potter was in, correct?
Correct.
And so then I'm going to ask you my own hypothetical. You would agree that if an officer in Officer Potter's position was not aware that Sergeant Johnson could not have exited that vehicle, deadly force would not have been reasonable.
That would not be consistent with my hypothetical, so I agree with you, sir.
And I don't want to get into a battle of words, but you said retained. That would be not be your definition of the word retained. You have not accepted payment for your work, correct?
Correct.
And that's what you mean by you wouldn't use the word retained because you're not paid?
Retention to me is contracts. When people give you a contract and say we're paying you to do this, this, and this, I get many of those in civil cases, but for me personally, retention is a retention letter and a contract, and that doesn't exist in this case.
But what you did here was at the direction of the defense, correct?
It wasn't at their direction. It was at a specific request to assess the facts in the case specifically about the taser, and I gave them the facts from my perspective, and that was that.
Sure, and what I meant by direction was simply they told you what they wanted you to address. But I'm not saying they told you what to say, but they told you what they wanted you to evaluate. I'm trying to define retained, Your Honor.
All right, I'll let you answer that question.
My best recollection is from the initial conversation. It concerned the focus of the case was the validity of the stop and the decision to use the manner of use of the taser. That was going to be the focus of my opinions.
That's the direction you took from them.
Yes, sir.
So whether they're paying you or not, you're doing that for them. You're providing that service for them.
Correct.
That's all I have, Your Honor.
Any redirect? Okay. All right. Members of the jury, I'm going to let you go to lunch, and we'll start up again at 1:30. Okay, you may step down. Thank you.
And so now we have an expert who's articulated that this really shouldn't have been a lethal force matter. You know, no taser should have been shot because eventually we'll find this kid. I mean, that's his opinion. And it's false. We'll find him, he'll be easily arrested, no big deal. And so they've got an articulated opinion they put forth to these jurors. They're writing it down like crazy on their notes. A few of them are anyway. And we need to rebut the falsehood of that opinion. And, you know, I realize your ruling was that since you didn't know about certain things about Dante Wright, you know, we're limited. But I briefed the 703 issue, and you didn't rule on that yet. Mm-hmm. And I was waiting for this issue to either not be brought up or to be introduced into evidence. And now they've introduced a false predicate into the trial. And a false inference and false facts denies us due process. NAPU versus Illinois. We either have to correct it, or if your ruling is that we can't ask about it, I have to move for mistrial, and we will come in after the break with a thick packet, and I'll make an offer of proof of every time this kid has run away and not been found.
Okay. All right. Mr. Frank, I'll let you just briefly.
Yes, Karen, please, thank you. And I will not pound on the table because I don't think I need to. You can see clearly what the real purpose of trying to offer this evidence is 404B, it's character evidence. But nonetheless, there has been no false impression given to the jury because the witness's entire testimony was couched in terms of what a reasonable officer would have done or known, or what would have been, what they would have done based on what that officer knew at the time. That's been the entire context of his testimony. He never misrepresented that to the jury. He never said, you know, that he was guaranteeing they would have caught him later. That's not his opinion. So his opinion was carefully stated, appropriately stated, and did not open the door to any of this stuff, whether it's an inch thick or not. None of it was known to Officer Potter, and it's not relevant to the issues in the case.
Okay. I'm going to take a break and think about that. So I'll be back in 5 minutes, and I'm just going to read his expert opinions again. And I am concerned about this because I do think that the jury has gotten the impression that he could have easily been apprehended later. And there is a basis for believing that he wouldn't have. So I'll take a break. I'll be back in 5.
Right. What your last piece of testimony was that when the officers attempted to handcuff Mr. Wright because they had his address and name, and it was a minor violation, that they should have just let him go. Is that what you're saying?
No, that mischaracterizes my
Okay,
testimony and opinions.
What are you saying about it? I thought you said that they should let him go because they had his name and address. Is that what you said?
No, that's not what I said.
Okay, well then I misheard you. What did you say they should let him go?
No, I did not say they should
What
let him
did
go.
you say?
I said that the fact they had identified him and had his address is a relevant consideration in balancing the threat of escape or evasion.
Of what? I'm sorry.
The threat of escape or evasion.
Okay, and if he attempted to escape, what should the officers have done?
Use reasonable force to prevent the escape.
And they do that when they were trying to stop him from escaping?
Are you asking me
Yes.
in this case? No.
They didn't. And
At an early point, I would say yes, although we didn't talk about that. But at the point of using deadly force, no. As I testified, that was excessive and unreasonable, inappropriate, and inconsistent with generally accepted police practices.
Yes, but I was not talking about deadly force. I was talking about your first opinion in your report about using the taser. And your report seemed to reflect that because they would find him some other time or somebody else would get him, that they should not have tried to stop him. Is that what your report says?
It's not, no.
Okay. Well, let's go back. You started working as a police officer in what year, 2001?
Yes, sir.
Is that right? And you worked as a police officer for 4 years and 7 months after that? Is that right?
Something like that, full-time, an additional 6 months as a reservist. The plaque on my wall says 5 years, but I'd have to calculate the exact number of months.
All right, well, let's assume it's 5 years, and it doesn't matter.
Sure.
That was 15 years ago, I believe, right? About that?
Yes. I left
And
about...
have you worked as a patrol officer since 15 years ago?
No.
And during the time you were a patrol officer, and we did some history here, how many first of all, do you know what a critical incident is?
Yes.
How many critical incidents did you have in the 5 years that you were a law enforcement officer?
Oh, I was involved in maybe a dozen.
Okay, name one. I'm talking about a critical incident where a gun was used.
Sure. So my first one was in field training. I was not a shooting officer. My field training officer.
Maybe you misunderstood me. I'm not talking field training. I'm talking out in the area, being a patrol officer and having a real life incident. Did you have any of those?
Your Honor, I hate to be the third person talking at a time, but could the court please remind Mr. Gray that only one person can talk at a time? They should let the witness.
Right, and if he could answer my question, Your Honor.
All right, okay. You may continue, but yet for the benefit of the court reporter, please remember not to talk over each other.
Okay.
All right.
So what I'm talking about is when real life, when you're out on a patrol alone and you have a critical incident situation, how many of those did you have?
I was involved in, although not the shooting officer, I was involved in perhaps a dozen or so.
Of an officer shooting?
Either an officer shooting, an officer potentially being shot at, a significant use of force that we would classify as a critical incident.
Were you ever the one that shot the gun?
No.
Were you ever the one that was shot at?
No.
Were you ever in a situation such as the one that you saw in this video, the chaotic incident of this sort?
Someone attempting to flee an arrest and traffic stop? Sure, a number of times.
Okay, well, did they have a bench warrant for a weapons violation?
I don't remember specifically. I know certainly there were people who fled who had outstanding warrants of different types.
Well, I'm talking about an incident. Did you ever chase somebody that had a weapons warrant?
I'm sorry, that had a weapons...
Well, okay. I'm talking about a critical incident where you were involved yourself personally and a man broke away from you, didn't want to be handcuffed, and either drove off or ran off. Did you have any incidents like that?
I had a number of incidents where people who did not want to be arrested either drove off or ran off. They did not result in an officer-involved shooting, if that's what you're asking.
Okay, so the person that drove off, if you can remember one specifically, did you have a person that drove off or that fought the handcuffs and jumped in the vehicle? That person had a warrant for a weapons violation, had a no driver's license, no insurance, and a temporary restraining order against him against a female, and the officers did not know who the female was in the vehicle. Did you ever have an incident like that?
I can't say that I had that particular collection of facts as an officer, no.
Did your heart ever race, and did you ever get real excited when somebody left your custody and ran off?
Of course.
Okay. So you're aware that's what happens. Your adrenaline starts pumping. Is that right?
Colloquially, sure.
Okay. And you had that police officers patrol for about 5 years, give or take. And during the 5 years, you never was a trainer. You were a trainee except in computer training, correct?
I taught report writing to officers, the policies that we used. I got a number of different training.
You answered the question. Just answer my question, okay?
I'm sorry, I guess I don't understand your
I
question.
guess you don't. Okay, so during the time you were a police officer, you never was a trainer for use of force, for shooting a gun, or any kind of conflict with a citizen, correct? You weren't a trainer.
No, I earned a number of instructor certifications, including several in use of force disciplines.
You were a trainer for the officers back there in 2001, 2005. You trained other officers on the use of force. Are you testifying to that today?
No, I'm testifying that I earned several instructor certifications.
Did you hear my question? Did you ever train any officers back there when you were a patrol officer? Did you ever train any officers on the use of force at the police department you were in?
At the police department, no, I was not what we considered to be a defensive tactics instructor.
And you were actually a trainee, correct?
At the beginning of my career, sure.
And as far as, do you remember what a spear drill is?
A spear, as in Tony Blauer's spear system?
I don't know, but in your records you didn't choose to participate in a spear drill. You remember that?
No, I don't. If that's the spear system drill, no,
Do you remember not participating in it?
I remember.
I can refresh your memory if you want.
Sure. I remember at one point getting a fever in the middle of defensive tactics training and getting pulled out.
And I'm going to check your honor on relevance grounds.
The objection is overruled.
Read it to yourself.
Sure.
Sure what?
I've read it.
Okay. And what, does it refresh your memory?
Looks like my entire squad at the time is listed.
I asked you if it refreshes your memory or not. That's a yes or no, sir.
Not of this particular. I suppose it refreshes my memory as to what?
As to whether or not you wouldn't participate in the spear drill.
No, not particularly.
You don't remember? It did happen though, didn't it?
I don't know. I don't remember.
Okay. Too long ago? Is that right? Is it too long ago to remember?
Perhaps some combination of too long ago and simply not memorable.
Then you probably don't remember a lot of things that you did as a patrol officer, is that right?
Oh, I'm sure there are all kinds of things that I've forgotten.
15 years ago?
Sure.
And when you were approached to work in this case, you signed the contract, correct?
Yes.
And the contract calls for What was the hourly rate?
I believe it was $2.90 an hour with 10 hours on days of expected testimony.
Okay, and up till now, you've billed them about $10,000, would that be fair?
Something in that range, about 35 hours worth.
And since November, let's strike that. The cap on your contract is $50,000, correct?
I don't remember.
Oh, I'll show it to you.
Union approach.
Yes, thank you. I'm sorry. Actually, totally, I believe it might be 95,000. Take a read on that paragraph and see what you can figure out.
Oh, I'm sorry, I've misstated my rate. It's $2.95, not $2.90.
What else does that say?
It says quite a bit. What are you referring to?
The cap. How much is the cap?
The cap, I suppose if that's the total obligation clause, it will not exceed $95,000.
Thank you.
Mr. Taylor, did you remember to ask your questions at the podium for the benefit of the court reporter?
Now,
Was that Speardrill late June?
I'm sorry, I didn't ask you a question. The stop on this case last April 11th, you looked at that. That was legal, wasn't it?
The traffic stop itself? Yes.
And the arrest was legal, correct?
Yes, officers had probable cause to arrest for the bench warrant.
Well, besides the bench warrant, you knew that Wright did not have a license, correct? You learned that from this case, did you not?
Yes.
You learned that he didn't have car insurance, correct?
Yes, that's correct.
And you learned that the registration of the tabs on the car were old, outdated. You remember?
Expired, yes.
Yes. And you learned that there was a lady in the car also, and when they pulled up his record, he had a temporary restraining order in order for protection for some lady, correct?
Yes.
And the officers did not know at that time who the lady was in the car, correct?
Yes, that's correct.
And then when they went up to arrest Mr. Wright, they had a special awareness, did they not, based on what you read, about a firearm being in that car, correct?
No, there were no specific and articulable facts that there was a firearm in the car.
Okay. But you as a patrol officer 15 years now, from 15 years ago, you would agree with me that there are many more weapons and firearms and cars and on person than there were 15 years ago. Do you agree with that?
I don't think there's any valid statistical evidence to support that.
And you as a patrol officer, now, 15 years later, it would not bother you a bit about a weapon and being in that car or being on his person, knowing that he had a weapons warrant against him. That wouldn't raise your suspicions or concern at all when you went back up to that car. Is that right?
That's not my testimony.
Well, would it raise your concern when you went back up to the car to arrest Mr. Wright that he had a weapons warrant outstanding, a bench warrant? He didn't show up. A judge ordered it. Would that raise your concerns about a weapon being in the car?
There is always...
That calls for a yes or no, by the way. Yes, it would raise my concerns, or no, it wouldn't.
I can't fairly answer the question with a yes or no.
Okay, well then don't answer it. So you can't answer that question because you don't know?
No, sir. I can't fairly answer the question with a yes or no.
All right. And the arrest of Mr. Wright at the car, when they got him out of the car, they said, "You're under arrest." All three said it, correct?
I know at least two of them said it.
Two said it, and Officer Lucky was trying to handcuff him, correct?
Yes.
And before Mr. Wright broke away from Officer Lucky, everything was according to protocol. They did everything correct, the officers. Am I right on that?
I would not describe it as the best tactical approach, no.
Okay. But there wasn't any unreasonable force involved, was there?
No, not at that point.
And you wouldn't describe it that way, but you haven't been a police officer for 15 years, have you?
That's about correct, yes.
Yes. So the arrest, the handcuffing of him was legal, correct? The attempt to handcuff him?
Yes.
Okay. And Wright's break away from that handcuffing, trying to get back in his car and actually getting back in it, that would be illegal, correct?
Yes.
The objection is overruled. The answer will stand.
And only as a result of what Mr. Wright did by doing that was what happened, and was chaos after that, correct? Would you agree chaos as far as the video that you saw?
I don't think it was only because of that, but certainly that was a predicate factor.
Well, Mr. Wright, he's the one that started it, correct? Nothing would have happened except for the fact that he broke away once he learned there was a warrant. Is that a fair statement?
Sure.
Okay. And do you agree that the video of the incident showed chaos? That it was very fast acting? I think it lasted, I can't remember here. Let's see, 5:19. About 30 seconds total from when he got out of the car. Is that correct?
The objection is overruled. You may answer.
So, do you remember that? Or I'll ask you specifically. When Wright stepped out of the vehicle, it was 5 seconds between that time and the time he was told he was under arrest. Do you remember that?
That sounds about right.
And once he was told under arrest, 14 seconds later, and you remember in the video, that's when Officer Lucky was attempting to handcuff him. 14 seconds later, Wright pulled away and gets back in the driver's seat. Is that accurate about?
That sounds about right, yes.
And then 3 seconds after that, and if he tried to get back in the driver's seat, was trying to, 3 seconds after that, if you remember the video, Mrs. Potter went around to the left side and said, "I'll tase you." Remember that?
Yes.
And let me ask you a question. When somebody says, "I'll tase you," that's a warning to the person being arrested to stop or you'll get tased. Is that a fair statement?
Yes, the purpose of the warning is to generate compliance.
Yes. And in addition to that, when two officers, Johnson and Lucky, are wrestling with the guy, that's telling Mr. Wright that, hey, we don't want you to leave, we want you to be arrested. Is that a fair statement?
Yes, I think it would have been abundantly clear to someone in Mr. Wright's position that the officers were attempting to arrest him.
And would that raise your suspicion at all as to why in the world would this man, Mr. Wright, attempt to get away from 3 law enforcement officers?
As to the reasons for it?
Yes, besides the warrant. He's an expert, Judge.
The objection is overruled. You may answer.
Would that go in your mind at all that this guy with 3 officers there, the one officer say, "I'll tase you," the other officer, Lucky, at first is wrestling with him and he doesn't stop? Would that cause you to be concerned that maybe he's wanted for something else?
Not unless
Wouldn't that be good
warrant
police
would...
work? I'm sorry.
Without the warrant showing up on a system, I would not be concerned that he was wanted for something else, no.
That wouldn't concern you, that a young guy is trying to get away from 3 officers, 2 officers, or at least one, Officer Lucky, who you might remember if you saw the video, is a rather tall fellow, and Officer Potter are trying to stop him. He's wrestling with him, and Potter's saying, "I'll tase you." and nothing would enter your mind, I suppose because you haven't been a police officer in 15 years,
Object, Your Honor.
but would it enter your mind at all? Pardon?
Mr. Gray, if an objection is made, can you stop talking, please,
I'm
so I can
sorry.
rule on it? All right. The objection is overruled.
Thank you. So you've heard my description, and you're the use of force expert, the police procedure expert, correct?
Yes.
And would that raise any suspicion in your mind that maybe this kid's got some other issues? No?
The question you had asked originally was, would it raise a suspicion that he was wanted on something else? And without another outstanding warrant for him to be wanted on would appear in the system, the answer is no. Would it raise some speculative risk that there might be other things going on? Without specific and articulable facts, you have at best a risk. You have some speculation of possibility, but you don't have the sufficient basis for legal action. There's no threat, if you will.
I understand that, but it also causes the officers to have that suspicion. We got to stop this fellow. Maybe there's something else there that we don't know about. Another investigation, not a warrant, but he's being investigated for another serious felony.
Your Honor, I object. Can we be heard, please?
I'm going to sustain the objection, and the jury is to disregard that last question, and you are not permitted to answer.
Now, when you wrote your report, you assumed that Officer Johnson was not in the car at the time of the gunshot, correct?
I would say I concluded that rather than assumed it.
Okay, and you concluded it because you said that you couldn't see him in the car?
That on synchronized versions of the video, it was pretty clear that he was no longer in the car at the time of the gunshot.
Okay, so the car, the reason he got out of the car was because when Miss Potter said taser, 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 that would be a warning to the other two officers to release him, correct?
I can't speculate as to his motivation, but it's possible.
Well, is that the signal? If you're the taser man here, the expert, isn't that the signal? Taser, 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 to tell the officers to back off? We're going to shoot this electricity at them?
The warning of tasers has a couple of meanings, a couple of purposes.
Well, one of the
which-
purposes is taser, taser, taser tells the officers to get away from him because I'm going to tase him, correct?
I would say it tells officers to remove themselves from
Thank you.
the taser target area.
Okay.
To
And,
office-
Your Honor, again, clerk, please instruct.
well, Your Honor, if you would answer the questions yes or no, which I'm asking them like that, instead of giving me a statement afterwards, I would appreciate that he be instructed not to do that.
Still, again, one person at a time, okay? You're going to have a really messy record if you don't comply with it.
Judge, I can't hear what you're saying.
I said one person talking at a time, okay? So don't talk over him, and wait until the question's finished before you answer.
Yes, sir.
All right.
Thank you, Judge.
Yes.
Okay, so after Wright's told he's under arrest, my watching and reading of the reports and watching the video, 14 seconds later, Wright pulls away and gets back in the driver's side. Do you agree with that?
I apologize. Did you want me to answer the previous question about the taser, taser, taser?
I thought you did. I thought you agreed that it was a warning to the other officers to back off. You didn't say that?
No, not exactly.
Okay, well, what did you say? Go ahead.
It's a warning for officers to remove themselves from the target area. Officers are trained to apprehend someone who's under the influence of a taser. You can grab, for example, someone's arms even while they're being tased in the torso. So it's not a warning to absent themselves and move 5 feet away or something like that. It is a warning that the taser is going to be used. The other significant reason for that taser warning is so that officers don't confuse the pop of the compressed nitrogen for gunfire, so they don't mistake the taser discharge for gunfire.
Okay. And one of the reasons is that to back off the individual, if they've got their arms on him when he's tased, to take their hands off of him because they might get a shock too, correct? Is that one of the reasons?
No, I would not say to take their hands off of someone, because you often want to apprehend someone while they're being tased.
Okay.
So it's to warn them that a taser is about to be used. If their hands are on someone's torso, which is the typical target area, you certainly don't want to be in that area of effect, but it's not to back off of them entirely now.
All right. 3 seconds after Potter says, "I'll tase you," Kimberly Potter, first 5 seconds, Wright pulls away and Potter says, "I'll tase you," after 5 seconds. Now, on the video, after she said that at 2:01:55, did you see Mr. Wright at all say, "I give up," or "I won't fight anymore," or anything of that nature?
No, he was never compliant.
And that would be a warning that she was going to tase him, correct? If he didn't stop.
Her statement, "I'll tase you," is certainly a warning of an impending taser discharge, yes.
And if he would have stopped, you're assuming that the police officer wouldn't have tased him, correct?
Yes, that is a fair assumption.
And then at 3 seconds later, Mr. Wright, according to the video, is still fighting with the officers, and Potter says again, "I'll tase you." And did that affect Mr. Wright at all? Did he stop fighting at all when Miss Potter said for the second time, "I'll tase you"?
No, he was never fully compliant.
He wasn't
after
compliant at
pulling-
all, was he? What do you mean fully compliant? He was fighting, wasn't he?
After pulling away from Officer Lucky, he was never compliant.
Before that? Okay.
Before that, he was compliant. Yes,
Yeah.
he was not fully compliant throughout the interaction. He was not compliant after the pulling away.
I'm asking you about during the time he wasn't compliant, sir. Can you understand that? You know what I'm talking about?
He was, I think so. He was not compliant in the time where he was not compliant.
And the warning, "I'll tase you," the second warning, for 4 seconds he continued to fight with the officers, and the taser was pointed at him, according to the video, correct?
No,
No?
no taser was pointed at him.
You're right. The gun was pointed at him.
Yes.
Thank you. And by the way, the new taser, the 7, did you know that that taser and the one that Miss Potter got a month before, a month before this, she got the new taser, Taser 7. Prior to that, she had a different taser. And the different taser had a yellow handle and a yellow top, where the new taser, the 7, had a black handle and a black top. Did you know that?
I believe there was...
Did you know that? That calls for a yes or no. Answer the question, yes or no, please.
I don't think that's an accurate description of the taser.
The taser that she had?
The X7.
I'm talking about, okay, the Taser 7, the top was black and the handle was black, correct? The rest of it was yellow. Fair statement?
There was... can you clarify what you mean by the top of the
Well,
taser?
where you put you got your handle here, and right here was black from where the handle is over here.
Yeah, there's yellow on the sides of the part that protrudes from the thumb side of the hand in a grip, yes.
Yes, but the handle is black and the top is black, correct?
I believe that's correct.
Yeah. And, well, you're the taser expert, wouldn't you know that?
There are a number of different models of tasers still in use.
Did you know that the taser that she had before this, 3 weeks before this, was all yellow? Did you know that?
That was the X26P, as I recall, and I believe the model, I don't remember the coloration of the model she had.
Okay, so you didn't know that. That's your answer, right?
I don't recall offhand. I can see if it's in my report if you'd like.
You also had in your report that Potter was not aware of Johnson being in the car. You remember that, writing that in the report?
That's a slightly inaccurate description of my report.
Well, you said that you couldn't. Well, what did you say?
I said the available evidence indicates that she was not aware of that.
Okay. And now the available evidence is that he was in the car. He testified he was in the car, and he was fighting with Mr. Wright before the shot. Did you read that testimony, or did you hear about it?
I heard the testimony, and that is consistent with the body camera video. He was in the car and struggling with Mr. Wright prior to the gunshot.
Okay. And it was a second prior to the gunshot, correct? The taser, and then Potter fires a gun? 1 second or less.
Between
taser, and the gun being fired.
yes, by the end of that warning, it was a relatively short period of time, within
The
a
answer
second.
is yes. Would you answer my questions if you can with a yes or no? It'd be a lot easier.
Well, taser takes some time to say. By the time of the end of that warning, I agree, it was less than a second before the gunshot.
And that's when the officers took their hands off him, correct?
I'm sorry? No, the officers had their hands on him well before the gunshot.
Yes, but when did they take their hands off him? It was before the gunshot, wasn't it?
Sergeant Johnson took his hands off of Mr. Wright and backed out of the vehicle prior to the gunshot. Officer Lucky had hands at least in the direction of Mr. Wright. I don't remember offhand if they were making contact at the time of the gunshot.
Okay.
It was immediately after the gunshot that Officer Lucky backed away.
Is your testimony that Mr. Johnson's part of his body was not still in the car?
I testified earlier that his hands were still in the car. He had backed his torso out of the vehicle. His hands were still in contact with either the passenger or perhaps Mr. Wright's right hand.
So he was in the passenger's doorway, and he's leaning over with his hands on Mr. Wright. Is that what you're saying?
No, I'm saying he was backed out of the open front passenger door. His hands were either on the passenger or on Mr. Wright's right hand that was in front of the passenger.
Okay. Oh, that's what I thought he said. That's all right.
Members of the jury, I think we're overdue for a break, so we're going to take our afternoon break right now, and it'll be 20 minutes, okay?
Uh, 42,
And what city do you live in?
Minneapolis,
How far did you go in school?
12th grade.
And are you working now?
Currently not.
And are you married?
Yes.
Who are you married to?
Katie Wright?
And does Katie Wright also go by her legal name, Katie Bryant?
Yes.
Do you and Katie have any children together?
We have 3.
And could you tell the jury their names, please?
Dante Wright, Destiny Wright, and Diamond Wright.
And is Dante, your son Dante, is he no longer with us?
No.
Was Dante the oldest of the 3 children?
Yes, he was our firstborn.
What was Dante's role as the older brother to 2 younger girls?
His role to the younger girls was the big brother, to look after them, watch after them.
And what was his relationship like with his younger sisters growing up?
The relationship with the younger sisters was like a big brother. Joked a lot, always constantly following behind them, making sure they were okay.
And did you and your wife, Katie, and your children, Dante and Diamond and Destiny, all live together up until Dante's death?
Yes, we did.
Do you also have some other children from a previous relationship?
I do.
And how many other children do you have?
I have 2 other kids prior to our relationship, Marcus Wright and Monica Wright.
And where do Marcus and Monica live?
They live in North Carolina.
So between you and your wife, Katie, how many children do you have altogether?
She had 2 kids prior to our relationship, so we had 7 altogether.
So getting back to your life with Dante growing up and his younger sisters, what kinds of things did you and your family do together for fun to pass the time?
Well, we got together every Sunday we would have cookouts and stuff like that. Family days, I mean, we would do movies and stuff like that. We did a lot of things as a family, as a group, because we're like all we have, so.
Cookouts, you said?
Cookouts constantly every Sunday, every weekend, pretty much.
Did Dante have any favorite foods?
Well, yeah, he did. He liked chicken, I guess. We all did. So,
Was that a family favorite at the cookouts?
pizza. Excuse me?
Was chicken a family favorite at the cookouts?
Oh, yeah. Yes.
Did he like sports?
He loved basketball. He played pretty well. He was a left-hander, so he was pretty good.
And as he grew older, into his teenage years and beyond, did he have a variety of different jobs that he worked?
Had a lot of different jobs. I even got him a job with me before.
And when you say you got him a job, was there a time where you and Dante worked together?
Yeah, it was the time we worked together. I was his boss, and I was happy, to have my son coming on to work with me.
Where was it that you two were working together?
I was a manager at Famous Footwear.
And about how long did you two work together at Famous Footwear?
About a year. He worked there about a year with me.
About how long was that before he died that you two worked together?
Well, it was his last day was when the COVID hit. So his last day working with me was right in the beginning of the COVID.
So about a year ago is when you guys
Yeah.
stopped working together? How was it for you working with your son, Dante?
It was great. It was challenging, to work with my son. I tried to let him understand the difference between where at work I'm your boss and at home I'm your dad. It's a difference. So, but it was funny. Like it was this one time where I had sent him home. Because he was on his phone at work and he wasn't supposed to be on the phone at work. I was like, yo, we gotta go home. And so he went and asked my boss, is it okay if my dad sends me home? And I'm like, my boss like, yeah, he's your boss. And I'm like, well, you need to go home and come out in the hallway. And he's still there. And I'm like, well, why are you still here? And he's like, well, Dad, I rode with you. I couldn't go home because you're my ride. I think it's funny, but yeah, that was a funny thing that happened at work.
So not only were you working together, but you were driving to and from
Yeah,
work
every
together?
day, yeah.
You got to spend some quality time together.
Yeah, spend a lot of time together.
Your Honor, at this time I'd offer Exhibit 240.
Okay, I previously ruled on it over defense objection, and 240 will be admitted into evidence.
Thank you. If we could publish it, please, and put it on the screen. All right, there's a picture on the screen now. It's Exhibit 240. Could you just explain to the jury what's shown in this picture? Take a minute if you need one.
Picture of me and Dante. You see how, I was holding him. See how his arm, we had a close relationship. He was me and my wife's first child.
And was this picture at your home?
Yes.
Was this not long before he passed
This
away?
was right before he passed away.
And if we could put on the screen Exhibit 3, please. That's already been admitted. Did your son Dante also have a son of his own?
Yes.
And
First and only child. That's my grandson, Dante Jr.
And your grandson's name you said is Dante Jr.?
Yes.
How was it seeing your son Dante as a father?
Excuse me.
How was it to see your son as a father?
Man, to see him as a father, it was like I was so happy for him because he was so happy. He was so happy about Junior. And this was my chance to be a grandfather.
Did they have a close relationship?
Yes.
And did Dante Jr. spend a lot of time with your family as well?
Yeah. Dante Jr., Dante lived with us. Junior was pretty much there every day. And he loved his son.
And did you love your son Dante a lot as well?
A lot. I loved Dante. He was loved.
Do you miss him?
I miss him a lot every day.
Thank you, Your Honor. Nothing further.
Is there any cross? All right. Thank you, Mr. Wright. You may step down.
Right. What your last piece of testimony was that when the officers attempted to handcuff Mr. Wright because they had his address and name, and it was a minor violation, that they should have just let him go. Is that what you're saying?
No, that mischaracterizes my
Okay,
testimony
what are
and
you saying?
opinions.
What are you saying about it? I thought you said that they should let him go because they had his name and address. Is that what you said?
No, that's not what I said.
Okay, well then I misheard you. What did you say they should let him go?
No, I did not say they should
What
let
did
him
you
go.
say?
I said that the fact that they had identified him and had his address is a relevant consideration in balancing the threat of escape or evasion.
Of what? I'm sorry.
The threat of escape or evasion.
Okay, and if he attempted to escape, what should the officers have done?
Use reasonable force to prevent the escape.
And they do that when they were trying to stop him from escaping?
Are you asking me
Yes.
in this case? No.
They didn't. And
At an early point, I would say yes, although we didn't talk about that. But at the point of using deadly force, no. As I testified, that was excessive and unreasonable,
Right.
inappropriate, and inconsistent with generally accepted police practices.
yes, but I was not talking about deadly force. I was talking about your first opinion in your report about using the taser. And your report seemed to reflect that because they would find him some other time or somebody else would get him, that they should not have tried to stop him. Is that what your report says?
It's not, no.
Okay. Well, let's go back. You started working as a police officer in what year, 2001?
Yes, sir.
Is that right? And you worked as a police officer for 4 years and 7 months after that? Is that right?
Something like that, full-time, an additional 6 months as a reservist. The plaque on my wall says 5 years, but I'd have to calculate the exact number of months.
All right, well, let's assume it's 5 years, and it doesn't matter.
Sure.
That was 15 years ago, I believe, right? About that?
Yes. I left
And
about...
have you worked as a patrol officer since 15 years ago?
No.
And during the time you were a patrol officer, and we did some history here, how many first of all, do you know what a critical incident is?
Yes.
How many critical incidents did you have in the 5 years that you were a law enforcement officer?
Oh, I was involved in maybe a dozen.
Okay, name one. I'm talking about a critical incident where a gun was used.
Sure. So my first one was in field training. I was not the shooting officer. My field training officer.
Maybe you misunderstood me. I'm not talking field training. I'm talking out in the area, being a patrol officer and having a real life incident. Did you have any of those?
Your Honor, I hate to be the third person talking at a time, but could the court please remind Mr. Gray that only one person can talk at a time? They should let the witness.
Right, and if he could answer my question, Your Honor.
All right, okay. You may continue, but yet, for the benefit of the court reporter, please remember not to talk over each other.
Okay.
All right.
So what I'm talking about is when real life, when you're out on a patrol alone and you have a critical incident situation, how many of those did you have?
I was involved in, although not the shooting officer, I was involved in perhaps a dozen or so.
Of an officer shooting?
Either an officer shooting, an officer potentially being shot at, a significant use of force that we would classify as a critical incident.
Were you ever the one that shot the gun?
No.
Were you ever the one that was shot at?
No.
Were you ever in a situation such as the one that you saw in this video, the chaotic incident of this sort?
Someone attempting to flee an arrest and traffic stop? Sure, a number of times.
Okay, well, did they have a bench warrant for a weapons violation?
I don't remember specifically. I know certainly there were people who fled who had outstanding warrants of different types.
Well, I'm talking about an incident. Did you ever chase somebody that had a weapons warrant?
I'm sorry, that had a weapons.
Well, okay. I'm talking about a critical incident where you were involved yourself personally, and a man broke away from you, didn't want to be handcuffed, and either drove off or ran off. Did you have any incidents like that?
I had a number of incidents where people who did not want to be arrested either drove off or ran off. They did not result in an officer-involved shooting, if that's what you're asking.
Okay, so the person that drove off, if you can remember one specifically, did you have a person that drove off or that fought the handcuffs and jumped in the vehicle? That person had a warrant for a weapons violation, had a no driver's license, no insurance, and a temporary restraining order against him against a female, and the officers did not know who the female was in the vehicle. Did you ever have an incident like that?
I can't say that I had that particular collection of facts as an officer, no.
Did your heart ever race, and did you ever get real excited when somebody left your custody and ran off?
Of course.
Okay. So you're aware that's what happens. Your adrenaline starts pumping. Is that right?
Colloquially, sure.
Okay. And you had that police officers patrol for about 5 years, give or take. And during the 5 years, you never was a trainer. You were a trainee except in computer training, correct?
I taught report writing to officers, the policies that we used. I got a number of different training.
You answered the question. And just answer my question, okay?
I'm sorry, I guess I don't understand your question.
I guess you don't. Okay, so during the time you were a police officer, you never was a trainer for use of force, for shooting a gun, or any kind of conflict with a citizen, correct? You weren't a trainer.
No, I earned a number of instructor certifications, including several in use of force disciplines.
You were a trainer for the officers back there in 2001, 2005. You trained other officers on the use of force. Are you testifying to that today?
No, I'm testifying that I earned several instructor certifications.
Did you hear my question? Did you ever train any officers back there when you were a patrol officer, did you ever train any officers on the use of force? At the police department you were in?
At the police department, no, I was not what we consider to be a defensive tactics instructor.
And you were actually a trainee, correct?
At the beginning of my career, sure.
And as far as, do you remember what a spear drill is?
A spear, as in Tony Blauer's spear system?
I don't know, but in your records you didn't choose to participate in a spear drill. You remember that?
No, I don't. If that's the spear system drill, no,
Do you remember not participating in it?
I remember.
I can refresh your memory if you want.
Sure. I remember at one point getting a fever in the middle of defensive tactics training and getting pulled out.
Thank you.
And I'm going to object, Your Honor, on relevance grounds.
The objection is overruled.
Read it to yourself.
Sure.
Sure what?
I've read it.
Okay. And what, does it refresh your memory?
Looks like my entire squad at the time is listed.
I asked you if it refreshes your memory or not. That's a yes or no, sir.
Not of this particular. I suppose it refreshes my memory as to what?
As to whether or not you wouldn't participate in the spear drill.
No, not particularly.
Remember? It did happen though, didn't it?
I don't know. I don't remember.
Okay. Too long ago? Is that right? Is it too long ago to remember?
Perhaps some combination of too long ago and simply not memorable.
Then you probably don't remember a lot of things that you did as a patrol officer, is that right?
Oh, I'm sure there are all kinds of things that I've forgotten.
15 years ago?
Sure.
And when you were approached to work in this case, you signed the contract, correct?
Yes.
And the contract calls for, what was the hourly rate?
I believe it was $2.90 an hour with 10 hours on days of expected testimony.
Okay, and up till now, you've billed them about $10,000, would that be fair?
Something in that range, about 35 hours worth.
And since November, let's strike that. The cap on your contract is $50,000, correct?
I don't remember.
Oh, I'll show it to you.
Union approach.
Yes, thank you. I'm sorry. Actually, totally, I believe it might be $95,000. Take a read on that paragraph and see what you can figure out.
Oh, I'm sorry. I've misstated my rate. It's $2.95, not $2.90.
What else does that say?
It says quite a bit. What are you referring to?
The cap. How much is the cap?
The cap, I suppose if that's the total obligation clause, it will not exceed $95,000.
Thank you.
Yes. Mr. Perry, did you remember to ask your questions at the podium for the benefit of the court reporter?
Now,
Was that spear drill late June?
I'm sorry I didn't ask you a question. The stop on this case last April 11th, you looked at that. That was illegal, wasn't it?
The traffic stop itself? Yes.
And the arrest was legal, correct?
Yes, officers had probable cause to arrest for the bench warrant.
Well, besides the bench warrant, you knew that Wright did not have a license, correct? You learned that from this case, did you not?
Yes.
You learned that he didn't have car insurance, correct?
Yes, that's correct.
And you learned that the registration of the tabs on the car were old, outdated. You remember?
Expired, yes.
Yes. And you learned that there was a lady in the car also, and when they pulled up his record, he had a temporary restraining order in order for protection for some lady, correct?
Yes.
And the officers did not know at that time who the lady was in the car, correct?
Yes, that's correct.
And then when they went up to arrest Mr. Wright, they had a special awareness, did they not, based on what you read, about a firearm being in that car, correct?
No, there were no specific and articulable facts that there was a firearm in the car.
Okay. But you as a patrol officer 15 years now, from 15 years ago, you would agree with me that there are many more weapons and firearms and cars and on person than there were 15 years ago. Do you agree with that?
I don't think there's any valid statistical evidence to support that.
And you as a patrol officer, now, 15 years later, it would not bother you a bit about a weapon and being in that car or being on his person, knowing that he had a weapons warrant against him. That wouldn't raise your suspicions or concern at all when you went back up to that car. Is that right?
That's not my testimony.
Well, would it raise your concern when you went back up to the car to arrest Mr. Wright that he had a weapons warrant outstanding, a bench warrant? He didn't show up. A judge ordered it. Would that raise your concerns about a weapon being in the car?
There is always...
That calls for a yes or no, by the way. Yes, it would raise my concerns, or no, it wouldn't.
I can't fairly answer the question with a yes or no.
Okay, well then don't answer it. So you can't answer that question because you don't know?
No, sir. I can't fairly answer the question with a yes or no.
All right. And the arrest of Mr. Wright at the car, when they got him out of the car, they said, "You're under arrest." All three said it, correct?
I know at least two of them said it.
Two said it, and Officer Lucky was trying to handcuff him, correct?
Yes.
And before Mr. Wright broke away from Officer Lucky, everything was according to protocol. They did everything correct, the officers. Am I right on that?
I would not describe it as the best tactical approach, no.
Okay. But there wasn't any unreasonable force involved, was there?
No, not at that point.
And you wouldn't describe it that way, but you haven't been a police officer for 15 years, have you?
That's about correct, yes.
Yes. So the arrest, the handcuffing of him was legal, correct? The attempt to handcuff him?
Yes.
Okay. And Wright's break away from that handcuffing, trying to get back in his car and actually getting back in it, that would be illegal, correct?
Yes.
The objection is overruled. The answer will stand.
And only as a result of what Mr. Wright did by doing that was what happened, and was chaos after that, correct? Would you agree chaos as far as the video that you saw?
I don't think it was only because of that, but certainly that was a predicate factor.
Well, Mr. Wright, he's the one that started it, correct? Nothing would have happened except for the fact that he broke away once he learned there was a warrant. Is that a fair statement?
Sure.
Okay. And do you agree that the video of the incident showed chaos, that it was very fast acting? I think it lasted, I can't remember here, let's see, 5:19. About 30 seconds total from when he got out of the car. Is that correct?
The objection is overruled. You may answer.
So, do you remember that? Or I'll ask you specifically. When Wright stepped out of the vehicle, it was 5 seconds between that time and the time he was told he was under arrest. Do you remember that?
That sounds about right.
And once he was told under arrest, 14 seconds later, and you remember in the video, that's when Officer Lucky was attempting to handcuff him. 14 seconds later, Wright pulled away and gets back in the driver's seat. Is that accurate about?
That sounds about right, yes.
And then 3 seconds after that, and if he tried to get back in the driver's seat, was trying to, 3 seconds after that, if you remember the video, Ms. Potter went around to the left side and said, "I'll tase you." Remember that?
Yes.
And let me ask you a question. When somebody says, "I'll tase you," that's a warning to the person being arrested to stop or you'll get tased. Is that a fair statement?
Yes, the purpose of the warning is to generate compliance.
Yes. And in addition to that, when two officers, Johnson and Lucky, are wrestling with the guy, that's telling the Mr. Wright.
Sure. My name is Timothy, Timothy, Patrick, Patrick, Gannon, Gannon.
All right, a couple things to keep in mind when you're testifying. The court reporter is taking down everything, so you have to answer with a yes or a no instead of shaking your head or saying uh-huh or uh-uh. If you don't understand a question, please ask for clarification. If an objection is made, stop talking immediately. Don't answer unless I tell you to. And please don't talk over each other. Wait until the question's finished before you answer. Okay?
Thank you.
Counsel?
We know your name is Timothy Gannon, correct?
Yes,
How old are you, Mr. Gannon?
I am 53.
And I'm going to trace your history. Where did you go to school, high school?
High school, I went to Fridley High School.
And after Fridley, where did you go to school?
I did.
Where did you go to?
I initially enrolled in North Hennepin Community College in Brooklyn Park.
And how long were you there?
I was there about 3 years.
And what did you major in at that school?
Originally, my major was criminal justice or law enforcement.
And after 3 years, what did you do, if anything?
Well, within that 3 years, I had a break. So after my first year of college, I figured I was a 2-year track, so I could become a police officer, but I was nowhere mature enough or able to become a police officer. So I thought I would do something different. So I did enlist in the Marine Corps. And in between my college, I was a Marine Corps military policeman.
And I suspect that was a little different than going to college?
It was a lot different, yes.
So how long were you in the military, in the Marine Corps? The first time?
My original duty time was just during training, so the boot camp and also the MP school, and then I served out the rest of my time. It was supposed to be the rest of my time in reserve duty back here in Minnesota.
And did you get called back to duty, though? Active duty?
In 1990 and 91, I was called to active duty for the Gulf War, the first Gulf War.
And did you see combat in that war?
I did.
And how long were you there again? I'm sorry.
We were activated for approximately 6 months of duty.
Did you then return home?
I did.
And did you start school again?
Yes, I had then transferred down to Mankato State University, and I was in direction of getting my 4-year college degree, again in law enforcement and criminal justice.
And how long did it take you down at Mankato to get your degree?
It took me a little bit longer because of those interruptions and also because of the active duty. So I graduated in 1993.
After you graduated in 1993, I take it you went and looked for a job?
I did.
And was that in police enforcement, law enforcement?
Yes, I chose to be in law enforcement, correct.
And that was your major?
It was.
Did you, after applying for jobs, did you get a job at the Brooklyn Center Police Department?
I did in 1994.
And was Kimberly Potter there already, or was that after you came?
She came after I was already there, so I believe in 1995.
All right. And so once she arrived there, you met her and worked with her on occasion?
I did.
Was she on the same shift at you once she started there?
No, we had basically gone to different shifts. I would see her in some of the shift work that we would do, but we were not on the same rotation or shifts.
Okay. Let's talk about your career there for a while. After you started there, you were a patrol officer, correct?
Correct.
And tell the jury about your rise up to the top.
Sure. I think my track was basically, my career track was similar to a lot of officers when they first start. I wanted to be exposed to everything. I wanted to be a trainer. I wanted to be a firearms instructor, a use of force instructor, a field training officer. And of course, as most people want to do, they want to be on a SWAT team. I was on the emergency operations team. So I basically soaked in everything that I could early on in my career in Brooklyn Center, and I was given the opportunity to do so.
All right. And you have to slow down a little bit because the court reporter's looking at me in a strange way. Okay. So how about your promotions at the Brooklyn Center Police Department? Why don't you tell the jury about those?
Sure. So my rise within the Brooklyn Center Police Department, the rank structure is you can become a sergeant or a detective, and then above that rank you can become, at that time, a lieutenant, which later would be called a commander. So my rise basically through the ranks was, in about 2004, I was promoted to a sergeant position, and I was a sergeant for a very, very short period of time, about a year, a little bit over a year, and then a commander position or a lieutenant position became available, and I tested for that, applied for that, and I was able to get that position, and I was a commander for quite a long time within the police department.
And when you say you tested for it, it was a written test, is that right?
No, it was an application process, and you had to have prerequisites such as a 4-year degree.
All right. So now you're a commander. And what year was that?
2005.
As a commander, I believe we heard in this case that there's 3 commanders and 1 chief, and the commanders answer to the chief. Is that right?
Yes,
And below the commanders are the sergeants. Is that?
correct.
So what division were you a commander in?
Sure. So within the police department, there's 3 different divisions. There's the investigative division, the patrol division, and also the community engagement or community services, which is the kind of the outreach department within the agency. I was able to rotate through all those positions. In each position, I was there for 2 to 3 years. I did serve a little bit longer as a patrol commander, and I went through that rotation twice.
And Kimberly Potter was in the patrol division. Is that right?
Yes.
And how long were you the commander in the patrol division?
Sure. I think my first tenure within the patrol was a lengthy time. It was either 5 to 6 years, and then when I rotated through, it was shorter. But it was the first one was 5 to 6 years. The second one was probably 2 to 3 years. So a total of 8 years as a commander.
And Kimberly Potter worked under you during that time? She was a patrol officer?
Correct.
And what kind of a police officer was she, based on how she worked with you?
She was a fine officer. She
Okay, the objection is overruled, but the state's objection is noted.
Go ahead. I believe you were interrupted when you said she was a fine officer.
She was a fine officer, and there's certain things within the department that you get known for. Are you handling your calls? Are you professional when you talk with people? Are you doing good police reports? She was known for doing all those things.
What about her volunteer work? Are you familiar with that?
I am familiar with that. Early on in her career, she did volunteer and began working for LIMA.
What's that?
LIMA is a Law Enforcement Memorial Association.
Slow down just a little bit.
Sure. It's a law enforcement memorial association, and basically what they do is they lend support to fallen officers and their families. They are at funerals. They also very extensively help the families go through this process, which can be very traumatic and tragic.
And that would be law enforcement that was killed on duty, correct?
In the line of duty, yes.
In the line of duty. Was she also on a DART committee?
Sure. DART is our domestic abuse response team. So one of the things one of the initiatives that I had brought forward with the help of my command staff was a follow-up for we'd have domestic abuse survivors, and a lot of times they wouldn't get all the resources they need at the original time of call. And what the DART team would do is they'd follow up afterwards, even the next day, to make sure that that survivor has all the benefits that they need, that they're talking to an advocate, that if they have any questions about the upcoming trial, they supply them with that. So a select group of officers would do that.
And she was one of them.
She was one of the original members.
Also, was she an FTO when you worked there?
She was a field training officer for a long time. One of the things related to that is we don't get very many senior officers to do the field training officer program because they're basically they've had a lot. They've done a lot over their careers, and they leave that up to other officers. We have a few senior officers that still do that, and she was one of them.
And did you continue to be the chief of Brooklyn Center Police Department up until April of this year?
I was promoted to the chief position in September of 2015, and I served in that position until April of this year.
Yeah, and what happened in April of this year?
Officer Potter, or Kim Potter, was involved in the shooting incident, and the aftermath of that related to the political pressures within the city. I was no longer allowed to stay as the chief of police.
And was that because you would not terminate her until she had a due process hearing?
Objection, meeting?
The objection is overruled on that ground. You may answer.
I believe one of the reasons that I was required or requested to leave the agency was because I would not immediately fire Kim Potter.
Did Kim Potter leave voluntarily after that? Quit her job?
She did resign her position to me while I was still the chief.
Okay. Let's go to April 11th of this year. You were still chief at that time?
I was.
And that was the day that a critical incident happened, is that correct?
Correct.
Did you weren't at the critical incident at any time, were you?
I was off duty at the time.
And however, you did look at BWC body-worn cameras afterwards, is that correct?
I did.
The objection is overruled.
I'm trying to lead you into that, sir. Did you observe body-worn cameras after the incident?
Yes, I did.
And what body-worn cameras, if any, did you observe?
So on the night of the incident, I had been called in, and I was at the police station, triaging the situation, working through the incident. I was advised by a BCA agent to take a look at the body-worn camera footage from Kim Potter's camera, and that's what I did.
Later on, at some time later, did you look at more body-worn camera?
I looked at one other camera angle much later, and that was the squad cameras. So within the police department, our officers carry it and have on their person a body-worn camera, but also early on in the process, we had mounted squad cameras that can watch and can monitor outside of the car directly.
So you're able to see inside the car before the stop, is that right?
Yes.
And you saw the stop, and you saw the arrest, and you saw the aftermath, correct?
I did.
And after viewing all of those incidents and the body-worn cameras, did you see anything based on your knowledge and experience that her conduct was consistent with her training at the Brooklyn Center Police Department?
When I viewed both camera angles and had all the data in front of me, I saw no violation.
No violation of what?
Of policy, procedure, or law.
And the policy and procedure at Brooklyn Center Police Department, to your knowledge, since you're the chief, followed the law of use of force, is that right?
Yes, it does.
Now, in a critical incident, there are there's shooting, sometimes violence, chaos. In your experience, going back your years of being a law enforcement officer, had you in the past, before April 11th, been involved in critical incidents?
Yes, I have.
Was there one that stands up in your mind as memorable?
Yes.
Was that a critical incident where you were almost dragged in a car, or you were actually dragged for a while?
That is correct.
Your Honor, leading relevance.
Trying to get to the issue, Your Honor.
Notice.
The objection is overruled. You may answer, or I'll let the answer stand. Officer, could you please remember to pause a little bit and stop talking when there's an objection, okay?
Yes, Your Honor.
The objection was overruled, so you can answer my question.
I was involved in a situation where I was dragged by a car.
And what went through your mind when you were dragged by that car?
Sheer terror, trying to recall my training, what I had been exposed to before that, and simply trying to survive.
That one incident, after you were dragged by that car, I take it you lived, but did you remember the aftermath of that, what happened immediately after you were dragged?
Objection, Your Honor. Relevance.
We need
It
to
goes to her
sidebar.
testimony, Your Honor.
Counsel, we need to sidebar.
Okay.
Okay, the objection is sustained on relevance.
Now let's back up to what you viewed in the body-worn camera and the squad camera. You viewed that after Officer Lucky stopped, my hair is all messed up because of that thing. I'm told that Officer Lucky, he stopped the vehicle. He was the trainee at the time, is that right?
Yes.
And did you notice anything about his procedure in doing that was an error?
Yes.
What was that?
I think when he made the decision to make a custodial arrest, I think at that time when he got Mr. Wright out of the vehicle, what training tells us to do is to move him to the rear of the car, away from the open door, or close the door behind him.
Okay.
That would be something that you would learn later that you would do as a procedural issue as far as a
And an
traffic arrest.
FTO, unless it was some type of an emergency situation, would not interfere at the time he was performing the arrest to correct that. Is that a fair statement?
Objection, leading.
I'll let you answer. You may answer.
As a field training officer, I would not have corrected that action until afterwards during a debrief.
After Mr. Wright was asked to come out of the car and he was being handcuffed, he broke away, correct?
Yes, it appeared that way on the video.
Anything about what Officer Lucky did, or Officer Potter did, or in fact what Sergeant Johnson did and the chaos that happened after that, any violation of policy that you saw in that?
I did not.
In your opinion, could a taser be used to stop him from fleeing?
Objection, Your Honor. Calls for a legal conclusion.
The objection is overruled. You may answer.
Could a taser be used in that situation?
A taser could have been used in that situation.
And also, as a result of the Officer Johnson being partway in the car and Officer Lucky standing by the other side of the car and both car doors open, they could have been seriously injured if the car would have went in reverse. Is that right?
Yes,
And that would be a great bodily harm. Is that correct?
correct.
So, is it your opinion that not only could a taser be used in this chaotic situation, but also a gun? Is that right?
That is correct.
And that's based on your viewing of the videos, correct?
Yes.
And your experience. How many years are you experienced as a law enforcement officer?
Just about 27 years.
And you know you're under oath.
Yes, I am.
And you're not doing any favors for Miss Potter, are you?
Objection, leading.
Well, are you doing any favors for her by saying this?
I am not.
And that's your opinion based on your experience as a law enforcement officer
Yes.
and an ex-chief. Is that correct?
Yes, sir.
Are you presently employed?
I am.
And what is your job?
I'm a business agent for Law Enforcement Labor Services, or LELS.
And Law Enforcement Labor Services negotiates contracts for various police departments?
Yes.
And you negotiate contracts?
I've just started doing that, yes.
Okay, and you have no more connection with being a law enforcement officer. Is that right?
Correct.
Thank you, sir. That's all I have.
Dean Cross.
Thank you, Your Honor. Good afternoon, Mr. Gannon. Thank you for coming in. Your entire law enforcement career, well, I was going to say was at Brooklyn Center, but you also worked as a military police officer in the Marines, correct?
Correct.
But outside of the Marines, it was entirely with Brooklyn Center, correct?
Yes, sir.
And total of 27 years on that job.
Just about 27 years, yes, sir.
And it's a difficult job, isn't it?
Yes,
Rewarding job,
certainly.
but it's a dangerous job sometimes, correct?
Yes,
And when you're out there, you have to rely on the other officers around you to help keep you safe,
yes,
and you have to rely on other officers rely on you to keep them safe.
correct.
Common to back up other officers on even just traffic stops.
Yes,
And it builds sort of a camaraderie, doesn't it, among officers?
yes, it does.
And
Your water's over here. My water. I didn't mean to interrupt you, you know that. I lost my mask.
not my data, keep track of
I need a new mask.
COVID has affected us in many ways, hasn't it? Sorry about the interruption. And Kim Potter became a part of that camaraderie aspect of your life, your professional life.
Yes.
And did you know her personally at all, in personal context?
Yes.
And what kinds of stuff did you do outside of work?
Social gatherings, friends getting together, different anniversaries, things that would come up, but there'd be time to time that we would get together on a personal basis with her family.
So also personal friends.
Yes.
And you actually did work shifts with her?
Yes, we did.
And that matter that she did for, well, I call it the honor guard, but I think you had a different term for it, the Lima maybe?
I'm sorry?
Okay, I've been referring to it as the honor guard. Is that the same thing that you were talking about?
Yes. Honor Guard is, I guess, a subset of Lima. Yeah.
And that's really kind of an important support service for law enforcement families, isn't it?
I'd agree with that.
You really admired her for doing that.
I did.
And when she was working for the DART program, she was no longer really out on the street every day doing patrol, right?
No, that's incorrect.
Okay, tell me.
So the DART team was basically an offshoot of the patrol. So basically you'd still be in patrol operations and be a patrol officer, but you would make time in your shift to go back and do the follow-up with the survivor and make sure that they have the services. So they do both duties.
Got it, thank you. And then on April 11th of this year, when you learned about this incident, you learned about it that night, correct?
Basically early in the afternoon, yes.
Okay. And at some point, did you learn that it was Miss Potter who had fired a gun and caused the death of that young man?
Yes.
Did that surprise you?
Yes, it did.
And at that point that evening, you watched her body cam video, correct?
Yes, I did.
And I was a little unclear. You said at some point you watched the squad camera, sometime after that, but I wasn't sure about when after that you also watched the dashboard cam.
Within the last 2 to 3 weeks, I've watched the dash cam. I have not had access to that camera footage other than the initial camera that I saw, which was her body cam, after I resigned.
And so at the time, on April 11th, you only watched that dashboard, or I'm sorry, Officer Potter's body cam.
Correct.
And at the time, when you watched that, you concluded that she did not mean to fire her firearm.
Correct.
And you decided that night to release the video to the public, to show the public that.
Yes, I did.
And it's your understanding that because you refused to fire her, you were not going to be allowed to stay as the chief of police.
I believe there were multiple situations or reasons that I was given. That was one of them. I believe the other reason was my handling of the riots that occurred that night and the next night in front of the police department. Those were things that were pointed out to me that that was in conflict with the elected body.
And you disagreed with those reasons,
Yes, I did.
and particularly with what the shall we say, suggestion to fire her, the request to fire her.
Yes, I would agree with that.
And that's because you thought she should be entitled to some due process, right, before she were to be fired.
We have a policy in place to do administrative investigations, and they entail being thorough, being impartial, and being fair. And I don't think I could have done any one of those three things if I were to make that decision that day.
And so you essentially felt that you were being forced out of the job.
Correct.
And but instead you resigned, right?
Resigned in lieu of termination.
And were allowed then to keep all the benefits, that retirement benefits that come with the job.
Correct.
Now you work for the agency, the Law Enforcement Legal Services, that also provides legal services to officers for on-duty incidents.
Yes, I was unemployed for about 6 months, and I've just recently been employed.
Your agency, well, shouldn't call it that, should I? Where you previously worked at Brooklyn Center, had a policy about officer-involved shooting incidents.
Correct.
And the policy required that the investigation of that kind of incident be referred to an outside agency.
Yes, sir.
And that day even, April 11th, you made the decision to authorize the BCA to do the investigation.
Correct.
And the purpose of that is to avoid any potential bias in the investigation, correct?
That is the intent.
It's also to provide some transparency so that people see that that bias is not going to play, the potential bias is going to play a part in the decision, correct?
Correct.
But today you think you have none of that bias in order to offer the opinions that Mr. Gray asked you to offer.
With the video evidence that I've seen today, or within the last 6 months, I believe I can make that decision.
You did an interview with the media on November 14th of 2021. Do you recall that?
Yes, I do.
And that was really about the aspect of how you lost your job there at Brooklyn Center.
It was about the inner workings of working with the political ramifications of decision making. Yes.
And in that interview, you refused to discuss the actual killing of Mr. Wright because you thought you might be a witness in the case.
Correct.
What made you think on November 14th that you might be a witness in the case?
I had the belief that either the prosecution or the defense would call me as a witness in some capacity. I was a police chief.
And had the defense contacted you at that point?
I believe at that point they had contacted me.
So at that point in time when you were contacted by the defense, you had only reviewed Ms. Potter's body-worn camera, correct?
Correct.
And so the only aspect of the case that you had at the time was from Ms. Potter's body-worn camera, correct?
Yes.
And at that time, you did not see any danger for the other officers that would have justified the use of deadly force, as you've said today.
I did see some danger on the driver's side in case the vehicle went in reverse, but I did not see the situation of Michael Johnson on the other side of the car.
So you've been involved in a lot of traffic stops, I assume?
Yes, sir.
Have you had some people flee from you at a traffic stop?
Yes, I have.
Did any of them drive in reverse to the squad car when they fled from you?
No, they have not.
Does it make any sense for somebody to put it in reverse when there are two squad cars behind them to flee?
No.
Prior to that media interview, you had actually had sat down and talked with the defense attorneys on November 8th, correct?
Yes.
And in that interview at that time, you were of the opinion that Sergeant Johnson was leaning into the passenger side of the car when Mr. Wright tried to drive away, correct?
Correct.
So that's something you felt you knew at that time to offer an opinion on, correct?
I need to stand corrected because I have to remember exactly when I saw the video that was reflected on the squad camera. Once I saw the squad camera angle, I believe that Mr. Johnson was hanging inside the car at the time of the incident.
Well, hanging inside the car was not the word you used in the interview with the defense attorneys, is it?
I don't recall.
Would it help to refresh your recollection if I showed it to you?
Yes.
All right. May I approach, Your Honor?
Yes, you may.
Yes.
Where's the quote? That's not a quote, that's a report. For the record, Your Honor, that wasn't a quote. It was a report that,
Okay, council member, no speaking objections. Oh, my God.
that's what I apologize.
All right.
This one,
Is there an objection?
maybe you heard on.
Yes. Objection is sustained.
At the time of the interview in November 8th of 2021, you believed is simply that Mr. Johnson, Sergeant Johnson, I'm sorry, was leaning into the car, correct?
Was in the car, yes, leaning in the car.
All right. And the second time then you met with defense counsel was December 6th of this year, correct?
Correct.
So after the trial had begun.
Yes.
And you were then, from them, shown these other videos, correct?
The two videos,
Yeah, I think earlier you referenced the dash camera from Officer Lecky's squad. And then what else did you review?
the body-worn camera footage from Officer Potter at the time.
Right. But that you watched day one, right?
Yes.
And then, so the only other video you've watched since then has been Officer Lucky's dash camera?
Correct.
Okay. And that is what you did when you met with counsel on December 6th?
Yes.
So it was only upon looking at that that you've arrived at this opinion about deadly force?
Correct.
Have you watched Sergeant Johnson's body cam?
I have not.
Have you interviewed any of the witnesses?
I have not.
Have you ever in your career offered an opinion on whether an officer's conduct was reasonable for a use of force evaluation?
I have reviewed, for IAs as a police chief, I've had to review a lot of internal affairs investigations, and I've had to make determinations based on the evidence that was presented to me.
And in making that determination, what you're determining, you're determining whether their conduct was consistent with what you said today, right? The policies and practices of the department.
Of the department, yes.
Because an officer could be disciplined by the department.
Correct.
You were not, in those situations, making a legal determination about the reasonable use of force.
I was not.
And your opinion today is solely that Officer Potter's conduct at the time was consistent with policies and practices of your department.
Correct.
Well, make sure I got my numbers right. You became a commander in 2005, correct?
2005.
And a commander position is one that is largely administrative,
Yes, it's a variety of roles, but yes, administrative.
in the office, day hours.
Correct.
And have you carried a taser every day on your job since 2005?
I have not.
You have offered that Mr. Wright should not have been allowed to leave the scene, correct?
Correct.
And that's because there was a warrant for his arrest.
Correct.
And would officers, well, it's true, isn't it, that in making that arrest, officers still have to use reasonable force?
Correct.
You're not saying that anytime somebody tries to get in their vehicle and drive off during an arrest, an officer can shoot them?
That is correct. Not every time somebody gets in their car is an officer have the ability to shoot them. No.
From the dashboard camera, you were still able to determine that Sergeant Johnson's feet were planted on the ground during the incident, correct?
I believe he was still grounded, but a large portion of his body was inside the car.
But that's from the perspective of the dashboard camera.
That is correct.
Did not watch Sergeant Johnson's body-worn camera to get his first-person perspective, did you?
I have not.
Did you, well, so then you also don't know whether Sergeant Johnson was able to prevent Mr. Wright from driving off by holding onto the shift knob.
I am not aware of that.
And you also do not know that Sergeant Johnson was able to prevent, whether Sergeant Johnson was able to prevent Mr. Wright from driving off by grabbing a hold of his right arm and pulling it towards the passenger door.
I do.
object to that in the statement of testimony.
All right, members of the jury, you rely on your own memory as to what the evidence showed. Okay? You may continue.
Before deploying a taser, officers should consider the surroundings of the person they intend to tase, correct?
Correct.
As the police chief, as a fellow police officer, you would not want an officer shooting their taser in the direction of other officers or civilians.
Correct.
And in the space, well, strike that. So then you would agree, wouldn't you, that Officer Potter's decision to try to use a taser put the passenger of the vehicle and Officer Johnson at risk of being struck by the taser?
I would not agree with that.
Why not?
At that distance that she was within Mr. Wright, the prongs and the distance that they travel apart is very concise and very close. So I think her target that she was looking at doing would have been center mass at the chest and area. I don't think those prongs would have had enough time because they have to travel farther to get the distance apart. So I don't think that was in any way a danger to the passenger or to Michael Johnson because the prongs would have been very close to a tight group.
In watching Officer Potter's body-worn camera, you saw that Mr. Wright was moving around a bit as he was trying to leave.
Correct.
So it was a moving target.
Correct.
Judge, I object to that, as argumentative, and also a misstatement of what the body camera showed.
All right. Again, members of the jury, rely on your own memory, okay?
Incidentally, are you certified to carry a taser?
I am certified to carry a taser.
So you go through the training every year as well?
I do.
And you understand the need to get a good probe spread to get a good neuromuscular incapacitation.
If at all possible, yes.
And that the more distance you have, the better off, the more likely you are to get that.
Correct.
You're familiar with the type of taser cartridges that your department started using with the Taser 7 this year?
I'm somewhat familiar with it. I did go through the taser qualification, but I've not handled them since I resigned. It's been quite a while, and we did intro them into the department this year.
Your Honor, I'd like to put Exhibit 246 on the stand, please.
You may.
246.
246.
Do you see that in front of you then?
Yes.
Sometimes I know we get kind of a glare on that screen if you need to move it. Do you recognize what this is?
Yes.
And this is Ms. Potter's certification for the Taser 7 transition, correct?
Yes.
Below the 4 check marks in blue, there are 2 boxes, and one has an X in it, correct?
Yes.
And so this is indicating that, at least for this certification, the close quarters cartridge had not been used?
Correct.
When you saw the video from Ms. Potter's body cam, she was quite upset, correct?
Yes, she was.
Did you feel bad for her at the time?
I did.
Still feel bad for her?
I do.
So the manner in which Officer Lucky brought Mr. Wright out of the car, you thought it would have been better for Officer Lucky to bring him back behind the car, correct?
One thing I hate to do as a police chief is Monday morning quarterback somebody's actions, but I do stand by what I said. It would have been preferable for him to move him back away from that open door frame, but again, I'm looking at it from a perspective many months later.
But not concerning enough for you to believe that an FTO at the time should have corrected that right at the time?
No, from what I watched, it looked as if Mr. Wright was going to cooperate. He initially got out of the vehicle, and sometimes that does put officers off, and they think that there's going to be a compliant individual, and then things change very drastically and quickly. I think it would have been a coaching moment for Kim Potter to have with her probationary after the call.
You testified that a taser could have been used in that situation, and you agreed with that.
Yes.
And that situation is basically what you saw on the dash cam and her body-worn camera.
Correct.
So when you offer the jury this opinion about using your taser was consistent with policy and practice in Brooklyn Center, it's because you believe that Mr. Wright was not in control of his vehicle when he was shot, so it was an acceptable decision to use the taser.
From the video images I saw, he was not in control of his vehicle at the time that she would be deploying the taser, if that's what the tool that she used.
And that's what you said, is that he wasn't, and you didn't see him in control of the vehicle, so it would be okay for her to use the taser.
Yes,
Because if he was in control of the vehicle, it would not have been a good idea to use the taser, correct?
correct.
Because he could have been incapacitated and the vehicle could have moved.
Yes,
If he was not in control of the motor vehicle at that time, as you believed, then there also was at that same time no threat of harm to Sergeant Johnson, correct?
oh, I disagree with that.
Is it consistent with policy and practice for an officer, a police officer, to not know they have their gun in their hand when they shoot somebody?
Could you rephrase the question or repeat it, please?
Sure. Is it consistent, in your opinion, with policy and practice for an officer to not know they have their firearm in their hand when they shoot it?
You are correct.
I'm sorry?
You are correct.
I have nothing further, Your Honor. Thank you.
Is there redirect, Mr. Gray?
Ex-Police Chief Gannon,
Yes, sir.
would you lie under oath to help a friend out?
Sir, there's a reason why I'm an ex-chief. Nobody gets me to say something or do something that I don't believe in. I wouldn't lie for anyone.
Thank you.
Anything further?
Just briefly, Your Honor. You're offering today your opinions.
That is correct.
Thank you, Your Honor.
Is there any further redirect? No? Is there any further redirect? Okay. Thank you. You may step down. All right. Okay, the defense may call its next witness.
You call Colleen.
Okay. Please stand behind the witness chair and then raise your right hand. Do you swear under penalty of perjury that you will truthfully testify?
I do.
Please have a seat. Remove your mask, please, and state your full name and spell it.
Colleen, Colleen. Michael, Mychal. Fricke, Frizke.
The court reporter is taking down everything that's being said. Please answer with a yes or a no instead of shaking your head.
And don't say uh-huh and only one person can talk at a time. Wait until the question's finished before you answer. If you don't understand a question, let the lawyer know. And finally, if an objection is made, please stop talking immediately and don't answer the question unless I tell you to. Okay. Counsel?
Thank you, Your Honor. Officer Fricke, you're employed by which police department?
The City of Brooklyn Park Police Department,
How long have you been employed there?
since May of 2021.
How old are you?
40 years old.
A little slower.
40 years old.
Okay. Give us your educational background, please.
I have a bachelor's degree in criminal justice and public administration and a master's degree in criminal justice.
What institutions did you graduate from?
St. Cloud State University.
For both.
Correct.
Were you formerly employed with another police department before your current employment?
I was previously employed with the Brooklyn Center Police Department
When did you start there?
in March of 2008.
What were your initial roles and duties there?
I was hired as a patrol officer.
And did you stay in that capacity throughout your work there?
I had different assignments. I filled a role as a juvenile officer for a few years. I was a sergeant for 3 years.
While you worked there, did you come to know former Officer Potter?
I did.
How did you come to know her?
We worked on the same shift together for several years.
Did she become for you a mentor and friend?
Yes.
And did you spend quite a bit of time with her?
Yes, I did.
Did you have a chance to observe her working in the community?
Yes, I did.
Did you have a chance to observe her with suspects of crime, for example?
Yes,
Did you find her to be patient?
I did.
Polite?
Your Honor, prior court ruling.
Yes, counsel, the objection is sustained.
Was she I'm sorry about that. Was she a good police officer?
Yes, she was.
Was she an FTO?
Yes.
Did you work on the DART program with her?
I did.
What is DART again?
It's a domestic abuse response team.
What was your role in that?
I led the team, supervised the team.
And what did you do with respect to Officer Potter in terms of the DART team?
She was a member of the team, so I would assign cases to her and follow up with her to, check in on the work that she was doing with the victims and families.
And you've supervised her work, did you not?
Yes.
Were you aware of whether or not during your employment at Brooklyn Center that Officer Potter had fired her weapon?
No.
Were you aware that she had ever fired a taser?
No.
As a matter of policy, are you familiar with the policies of Brooklyn Center Police Department?
Yes.
As a matter of policy, would an officer be allowed to ignore a bench warrant for a gun charge and let an individual leave the scene instead of making an arrest?
No, that wouldn't be typical.
You would have to make the arrest.
Yes.
You were summoned to the scene on April 11th, were you not?
I was.
And you were assigned to Officer Potter to be with her. Am I right about that?
Yes.
And stayed with her from the scene and into the Brooklyn Park Police Department. Is that right?
Brooklyn Center Police
Brooklyn
Department.
Center, I'm sorry. I know there is a distinction. Did you have a chance to observe Officer Potter while she was at the Brooklyn Center Police Department in a room by herself?
I did.
What did you observe in that regard?
I saw her curled up in the corner of the room.
What room was she in?
She was. It was a meeting room. I don't know a name for it.
Was she by herself?
Yes.
Crying?
Yes.
In all the years of working with her in Brooklyn Center, do you have an opinion as to her reputation for peacefulness?
I think she's a remarkable.
Objection, Your Honor. Article rule.
Well, excuse me, I'll let you finish your answer.
I think she was a remarkable police officer because she was a remarkable person. And
Okay, the objection is sustained at that
I
point.
wanted to ask you,
The jury will disregard that last statement, okay?
I wanted to ask you to focus on her reputation for being peaceful in the community. Do you have an opinion as to whether or not she has a reputation for being peaceful?
yeah, I think she has a positive reputation.
And do you have a reputation? Do you have an opinion as to her reputation in the community for being law-abiding?
Yeah,
What's your opinion?
that she is law-abiding.
I have no further questions.
Is there any cross?
Officer Fricke, you began your law enforcement career in 2008,
Correct.
and you remained with Brooklyn Center through April of 2021.
Through May of 2021.
May.
Yes.
Okay. And during your entire career, the defendant was a coworker up until obviously April 11th.
Correct.
And you worked alongside her as a patrol officer,
Correct.
shift after shift, year after year.
Not from the day I was hired until the day I left there.
Okay. In addition to those years, though, that you did work with patrol and in the DART program, you developed a relationship with her beyond a professional relationship.
Yes.
You talked on the phone.
Yes.
You texted with each other.
Yes.
You got together a few times a year outside of work.
Yes.
You were friends.
Yes.
Right. You'd say that you and the defendant communicated a lot during your career, both inside and outside of work.
Primarily inside of work, yes.
Yep. And you were contacted by the defense to provide a statement on November 8th of this year?
Yes.
Okay. And you've talked to the defendant herself on the phone after this incident multiple times, correct?
I wouldn't say multiple.
Do you remember saying multiple times back on November 5th of 2021?
I don't remember the verbiage that I used then.
Okay. Now, I do want to talk about your actions on April 11th. On that day, you were working a patrol shift, 6 a.m. to 6 p.m. That's the same shift that Officer Potter was working at that day?
Correct.
And as part of your duties, you paid attention to the radio communications?
Correct.
And around 2 p.m., you knew that Officer Potter and Officer Lucky had initiated a traffic stop, correct?
Yes.
And you were at the police station at that time?
Correct.
You heard a further report about a crash and then a report of shots fired, correct?
Correct.
And you drove to the scene?
Yes.
And you knew that a shots fired call is perhaps the most serious call you could respond to as a police officer, correct?
It's serious.
Yep. But even at that time, you did not know who was shot, why they were shot, where they were shot.
Correct.
But nonetheless, use of a firearm could seriously injure and kill someone, correct?
The objection is sustained.
I'd like to talk to you about the response that you had to the scene, which was discussed on direct examination.
Also be honest.
Sidebar here.
The objection is still sustained.
Eventually, Officer Fricky, you did function on November 11th as Officer Potter's escort officer, am I correct?
On April 11th, yes.
You encountered her at the scene and then you went back to the police station with her.
Yes.
You arrived with her at the same time?
Yes.
Do you recall when you walked into the police station, Officer Potter walking away from you?
Yes, she's walking in front of me.
And then she entered a conference room and closed the door.
I don't recall if she closed the door before I got in there behind her.
Sure, but you were actually only outside of her presence for several seconds and then you entered the room, correct?
I don't recall the sequence.
Okay. How long did you leave her alone as her escort officer on November 11th?
I wouldn't say I left her alone.
Okay, so she was just on the other side of the doorway and you walked in just as you entered the police station, correct?
The room that she went into, the entire front of the room is glass. So if I was on the outside of that room, I would have still been able to see her.
Yeah. In other words, she wasn't in the room alone for a long period of time prior to you encountering her, correct?
Correct.
All right. And when you encountered her, you asked if you could sit with her, and she said no.
I don't recall specifically.
Do you recall when she asked you to take your body-worn camera off?
I recall a similar conversation.
Okay. And you did, at her request, take your body-worn camera off, correct?
I removed it from my clip and placed it on a table.
And then she did not want you to be her escort officer anymore, is that correct?
That's correct.
Okay. And you stopped being her escort officer. Someone else was assigned to that role?
Somebody else assisted me in that role, yes.
Okay. Now, you agree you weren't present at the scene when the defendant shot Mr. Wright?
It is beyond the scope. The objection is sustained.
Sure. You testified that the defendant had a reputation for having a law-abiding character.
Yes.
Prior to April 11th, the defendant was a law enforcement officer, correct?
Yes.
All right. In terms of following the law, though, generally speaking, you'd agree that following the law on one day does not absolve you from accountability the next day, correct?
Okay. The objection is sustained.
You testified that the defendant had a character for peacefulness.
Yes.
You'd agree that as a police officer, though, she was specifically trained in how to use force, correct?
Yes.
And the weapons that would use force, including firearms and tasers?
It is beyond the scope. The objection is sustained.
No further questions, right?
Okay. Is there a redirect? Okay. All right. You may step down.
Judge, can we have a sidebar here?
Yes.
Okay, please come forward. And would you stand behind the witness chair? Okay. Raise your right hand. Do you swear under penalty of perjury that you will truthfully testify in connection with this cause?
Yes.
Please take the witness. Okay, please remove your mask. And would you please spell your full name, state and spell your full name?
Thomas Loren Hall, ThomasLorenHall.
All right, the court reporter is taking down everything that's being said. So only one person can talk at a time. Wait until the question's finished before you answer. Answer yes or no instead of shaking your head or saying uh-huh or uh-uh. If an objection is made, stop talking immediately and don't answer the question unless I tell you to. You can ask for clarification if you don't understand a question. Okay? Counsel?
Thank you. Mr. Hall, how old a fellow are you?
23.
And where are you from?
Champlin, Minnesota.
Where'd you go to high school?
Champlin Park.
Do you have an occasion to know Kim Potter?
Yes.
How did you meet her?
I met her actually at my neighbor's house for the first time, probably about 11 years ago.
And did you become acquainted with her children as well?
Yes.
Are you friends with them?
Yes, I am.
How much time did you spend over the last 10 years with Ms. Potter, Kim Potter, former Officer Potter?
Just about every weekend.
Have you ever been in the military?
Yes, I was.
Which branch did you enroll in?
I was in the Army.
And what was your position in the Army?
I was a 25 uniform, which is a signal system support specialist.
Did you have what is called a security clearance in the Army?
Yes, I did.
What is that?
It pretty much gave me opportunity to be able to listen or tap into a lot of different things because I had a top secret security clearance, so I could be able to be briefed on different situations or scenarios that a lot of people aren't.
Okay. Were you eventually honorably discharged from the Army?
Yes, I was.
And what are you training to do right now?
I am training actually to be a diesel technician at the moment.
And when do you think you'll be done?
I will be done this upcoming August.
And you have employment lined up, it sounds like.
Yes.
Okay. Well, during the time that you've spent with, I also wanted to ask you one thing. You wanted me to ask you, are you an Eagle Scout?
Yes, I am.
Okay. During the 10 years or so that you've known Officer Potter and her family, have you been able to obtain an opinion as to her reputation in the community for being law-abiding?
Yes, I have.
And what is that opinion?
Kim always looked at it as just because I'm an officer doesn't give me an opportunity to not have to abide the laws that I have to enforce. Everybody in this world is expected to obey the laws that are enforced by herself and anybody else.
Similarly, do you have an opinion, based upon your 10 years or more of knowing her, for her reputation in the community for being peaceful?
She has always been an extremely peaceful person, and no matter what was going on or what happened, she was always there to help you or help de-escalate the situation to make it so both sides could understand where they were coming from. And she was always willing to help you out if you had a question on something regarding a situation you were in. She was a very peaceful person.
Kind of a second mother for you.
Yes.
No further questions.
Okay, is there any cross?
Afternoon, Mr. Hall. Just to clarify, your opinion is based on her reputation in the community, and that community would be Champlin, your block, your relationships with her children. Am I correct?
Yes.
All right. Not on the streets of Brooklyn Center?
No.
Thank you. No further questions.
Anything further?
Very much. You may step down. Does the defense have any further witnesses? Okay. Hello, sir. Would you please come forward and stand right next to me behind the chair, the witness chair? Raise your right hand. Do you swear under penalty of perjury that you will truthfully testify in connection with this matter?
Yes, Your Honor.
Please sit down. Remove your mask. State your full name and spell it.
Frank, F-R-A-N-K, Roth, R-O-T-H.
All right, a couple things. The court reporter is taking down everything that's being said. Therefore, you have to answer orally instead of shaking your head or saying uh-huh and uh-uh. Don't do that. If you don't understand a question, ask for clarification. If an objection is made, you got to stop talking immediately and don't answer the question unless I tell you to. And the final thing is, two people can't be talking at the same time, so you have to wait until the question is finished before you answer. Okay?
Very good.
All right, counsel.
Thank you, Your Honor. Mr. Roth, I understand you've had a career in law enforcement.
Yes, sir, I have.
Would you tell us where you first worked and then the department you ended your career in?
I started as a Robbinsdale police officer in December of 1982. I worked there for a little over 8 years, and then I was employed with the City of Brooklyn Center as a police officer from January of 1991 through August of 2015.
What rank did you achieve at the Brooklyn Center Police Department?
I achieved the rank of sergeant.
Do you know, in that capacity, former officer Kim Potter?
Yes, I do.
Were you her direct supervisor?
I was.
For how long?
Well, I met Kim when she first started in 2004, I believe, and I was an indirect supervisor for a number of years, and then I was her direct supervisor for approximately 10 years.
Do you have an estimate of how many hours you were her direct supervisor over those 10 years?
I do.
And what would that be?
Well, it was a normal work year is 2,080, and it was about 1,800 hours a year for 10 years, so about 18,000 hours.
And during that time, you got to know her pretty well.
I did.
You consider her a friend of yours.
I do.
Was she also involved in the DART program?
She was.
The Honor Guard?
She was a member of the Lima Honor Guard.
And the hostage negotiations team?
Yes, that's a unit that I supervised.
Volunteered for all of those?
Absolutely.
You had a chance to observe her in the community for all those 10 years and have an understanding of what her reputation is in the community?
Yes, I did. We worked very close in Brooklyn Center. We're not a big agency by any means, so quite often the sergeants integrate with the officers many, many times during the course of a day on calls, the community type relations things, community outreach. I saw Kim in all those aspects.
So you work closely with her?
Very closely.
Well, I wanted to ask your opinion as to her reputation in the community.
I'm sorry, could you go again, please?
Given how long you worked with her, I wanted to ask you your opinion as to her reputation in the community for being law-abiding.
It was sterling.
I wanted to also ask you, do you have a personal opinion as to whether she was law-abiding?
Yes, I do.
Same opinion?
It's the expectation that we have as being police officers. She was very good.
Do you have an opinion as to her reputation in the community for being peaceful?
Yes.
What is that opinion?
Kim was extremely peaceful. Through our through a lot of the stuff we did with the crisis negotiation, hostage negotiation unit, that was our goal, was peaceful ends to tragic situations. And given the opportunity, Kim got peaceful resolutions.
And that's your personal opinion as well.
That's my personal and trained opinion as her supervisor.
Thank you very much.
All right. Is there cross, Mr. Larson?
Mr. Roth, could you identify the year you retired? I didn't catch that.
2015.
2015. And I apologize if I said Mr. Roth. It's Sergeant Roth, correct?
You can call me Frank.
But during your career with Brooklyn Center, obviously Officer Potter was a coworker, a fellow police officer, and she worked for you.
Yes, I was her direct supervisor.
And but in addition to that, though, you became friends.
Yes.
And you've been a strong supporter of her.
I do support Kim.
And you've been a strong supporter after this incident on April 11th, 2021.
Yes.
Indeed, do you recall when the defendant sat down for an interview this fall with Star Tribune reporter Rochelle Olson, she had you right with her?
I was with her.
Yep. You were a witness to that interview.
Beyond the scope.
The objection is sustained. It's beyond the scope.
She is someone that wanted you seated next to her for that interview.
Beyond the scope.
It is beyond the scope.
No further questions.
Okay. All right. Thank you. You may step down.
Thank you, Your Honor.
Okay. Does the state have any further witnesses?
One more.
All right, sir, please come forward. Stand behind the witness chair and raise your right hand. Do you swear under penalty of perjury that you will truthfully respond to questions related to this?
I do.
All right, please have a seat.
And would you please remove your mask? State your full name and spell it.
Samuel, Samuel, Ellsworth, Ellsworth, Smith, Smith, the second Roman numeral 2.
Seated in front of you is the court reporter. She's taking down everything that's being said in the courtroom. So we have to make a clear record. So answer questions with a yes or a no instead of shaking your head or saying uh-huh or uh-uh.
Yes, sir.
Only one person can talk at a time. Wait until the question's finished before you start answering. If an objection is made, stop talking immediately. Do not answer the question unless I tell you to. And if you don't understand a question, please ask for clarification.
Yes.
All right. Counsel?
Officer Smith, you're in uniform today?
No, I'm not. I'm civilian clothes.
Is that a tie, I thought? No?
Yeah. Yes.
Okay, sorry. All right. You're originally from Burnsville, Minnesota?
Correct.
I want to ask you about your law enforcement career. Did you start out in a city south of here?
Yes, sir. I started in Kansas City, Missouri in 2005.
And about what year was that?
2005.
What were your initial duties and obligations down in Kansas City?
Patrol.
Was it for the city or a suburb down there?
No, for the city.
How long did you work in Kansas City?
I was sworn officer from 2006 till September of 2014.
And at that time, did you decide to make a move geographically in your life?
Yes.
And where did you move to?
First, we moved to Brooklyn Center and lived there for 1 year, and then we moved to outside suburb.
Did you find employment in Brooklyn Center?
Yes.
And when did you start with the Brooklyn Center Police Department?
September 1st of 2014.
Are you there right now?
Yes.
What were your initial duties with Brooklyn Center Police?
Patrol.
In the course of your employment with the Brooklyn Center Police Department, have you come in contact with former officer Kim Potter?
Yes.
And tell us about that.
When I started there, like I said, September 1st of 14, she was working, she was patrol, and I was actually starting my field training with other officers, and just got to know her through patrol and working different shifts.
You did basic police work with her during these shifts, arrests, transport,
Yes.
talk to her, interviews, all those things?
Yes.
Okay. And during the course of the 6 years or so, a little bit more than that you worked for her, did you gain an opinion as to her reputation in the community?
Yes.
Do you have an opinion as to what her reputation in the community is for the trait of being peaceful?
She is well respected and very peaceful, and she was very professional from when I worked with her.
Is that your personal opinion as well?
Yes.
Do you have an opinion as to her reputation in the community for being law-abiding?
Yes.
What is that?
And she's very law abiding.
Is that your personal opinion?
Yes.
Why?
Because she, in my time working with her, there are times where I was maybe upset with something, and she would counsel me or coach me that, policy says this, or, basically calm me down and instruct me that this is how policy is, So she was a calming force, with a lot of new officers.
No further questions. Thank you.
Mr. Larson?
Officer Smith, you mentioned that, in your opinion, Officer Fricke has a reputation for being peaceful and law-abiding. That's the law enforcement community?
I think you meant to say Officer Potter.
Officer Potter, you mean the reputation you're discussing is the reputation she had in the law enforcement community?
Can you restate the question?
You've testified that she had a reputation for being law-abiding and peaceful in the community. You're talking about the law enforcement community.
The law enforcement community and the city of Brooklyn Center.
Okay. Now, you worked patrol with her for 7 years?
I had been employed there for 7 years.
For 7 years, and you had worked on patrol with Officer Potter?
Directly and indirectly. I worked for the first few years. I worked from 6 p.m. to 6 a.m.
Okay.
I also worked what we refer to as power shift, 2 p.m. to 2 a.m. or 4 p.m. to 4 a.m. and early power cars from 8 a.m. to 8 p.m.
Did you have any other professional interaction with Officer Potter?
Just working, going on calls, and helping, assisting when she was primary on calls.
Did you have any interaction with her with any other leadership roles that she had within the Brooklyn Center Police Department?
It is beyond the scope. The objection is sustained.
No further questions.
Okay. Thank you. You may step down. Oh, could we get the headsets on? Okay, members of the jury, we're going to stop right now. We're almost done, okay? So we're going to have, the defense will have 2 witnesses on tomorrow. So I'm going to let you go tonight, and we will start up at 9 o'clock, all right? Have a good night.
please be seated. Okay, Mr. Eng, you wanted to make a record.
Thank you, Your Honor. We would move for admission as a court exhibit the video of Colleen Fricke that you've, in your discretion, not allowed us to put it in, but I would like to, we object to your ruling, and I would like to make that a court exhibit, and I'll have Ms. Montgomery give it to your clerk. I assume without objection, just for the court's record.
Yes, we'll make it a court exhibit. Do you have a number? Okay. We do have it.
Oh, yeah. Okay. Well, then the second reason I wanted to take a moment of your time is that yesterday we had extensive discussions about the parameters of Rule 703, and the court ruled that we could not cross-examine Seth Stoughton on his opinion that Mr. Wright would be peacefully arrested in a short order. I'm paraphrasing, but that's the way I heard it anyway. And the court declined our effort to cross-examine him on specific instances where Mr. Wright failed to appear or would run away or escape and be difficult to find. And at the time, I asked to leave the court to make an offer of proof so the record is complete as to what we would have asked him about had we been able to do that. And we do object to your ruling in all due respect. But I do want to make an offer of proof. The offer of proof is that Mr. Wright has repeatedly failed to appear in court, therefore he was difficult to find. There have been bench warrants for his arrest in a number of cases for failing to appear. The cases are 27 CR 19, 20 754. The next case is 27 CR 19 22959. Next case is 27 CR 19-23184. Another one is 27 CR 19-23818. Another one is 27 CR 19-24205. The primary case that we're relying on is that only a month before his death, Mr. Wright was charged with a complaint of carrying a pistol without a permit. And the incident happened on June 30th of 2020 at 16:04 hours, according to the police reports. The police responded to, I'll just quote it, responded to a person with a gun call near 51st and Bryant Avenue North, Minneapolis, Hennepin County. The caller indicated that a light, complexed 17-year-old black male wearing black shirt and shorts and white shoes was waving a black handgun. The male then got into a white Toyota Camry occupied by 4 people, with the driver wearing a red shirt. Officers located the car nearby with a person defendant herein, Dante Demetrius Wright, matching the person with the gun's description, sitting in the back seat. Once out of the vehicle, defendant took off running with officers in pursuit and managed to evade officers. Officers at the scene positively identified defendant from prior interactions. A loaded Ruger .45 caliber handgun matching the caller's description was found on the floor of the vehicle where the defendant had been sitting. Another occupant of the vehicle verified it was defendant's gun. Defendant does not have a permit to carry the firearm. This evidence would have been used in cross-examination to refute the expert's opinion that Mr. Wright would have been easily captured or found when his behavior in this instance was to run away. We have other instances of crimes of violence from him that would rebut Mr. Stoughton's thought that he was going to be peacefully arrested. He was charged, Mr. Wright was, with aggravated robbery in the first degree on December 4th, 2019. The case number is 27 CR 19-29850. That case was pending when he was stopped by Officer Lucky. And that again shows that he had a motive to flee to avoid arrest on that particular charge. The facts of that case are rather gruesome, and that is the one where he stayed overnight at a young woman's house and robbed her at gunpoint in the morning after that. This is recounted in my defendant's response to the state's memorandum in opposition to its pretrial motions. I incorporate by reference my brief, which outlines all the instances that I've referenced here. We also have instances of violence for Mr. Wright in that he's been charged in 2 civil complaints, one in 27 CV 216193, where he shot an individual in the leg and assaulted that individual's face and robbed him. And then there was another complaint where he shot someone in the head, and I believe that complaint is 27 CV 217390. And the reason we wanted this evidence in is that we needed to rebut the inference that Mr. Wright has been a peaceful individual, and we appreciate the loss of him by his family and the loss of anybody. But the image of him as being somehow law-abiding and in all ways terrific is undercut by some of his criminal behavior. And so to give the jury a fair image of him and a picture of the facts as we know them today, we would have cross-examined Mr. Stoughton on all of these, and he would have either admitted that he never saw any of it, and he should have, or if he saw it, it never got in his report. So that is the offer of proof, and again, we respectfully disagree with your ruling. I'm not here to grandstand, but I do want to make the record, and I have.
Okay. And you have made the record, and I stand by my original ruling. Any bad acts by Mr. Wright that Officer Potter was aware of, I allowed in, but she was not aware of all these other matters. The issue in this case is Officer Potter's mens rea, or state of mind, when she approached Dante Wright at that stop. And logically, anything she knew about him would inform her decisions on how to approach him. These things were not within her knowledge. Okay. All right. Is there anything else we need to put on the record? Oh, one other thing. I'm going to finalize the jury instructions this afternoon, and when I get them done, I'll have Zach email them to you tonight. Okay, I should probably take about an hour. I do want you to know, just so you're thinking ahead, that I believe a definition of reasonable force that incorporates the definitions that the experts have acknowledged are controlling a reasonable officer, given the totality of the circumstances, something to that effect. I'll send it to you, and we can debate it tomorrow. I also want to alert you that I have thought about Mr. Ng's request for an additional instruction on authorized use of force, in addition to the authorized use of deadly force that both parties submitted. And I am going to allow an instruction to that effect because there's been so much discussion about this taser. Had the state not disputed Officer Potter's intended use of the taser, this wouldn't be a problem. But the state's expert was of the opinion that even a taser was not appropriate or reasonable under the circumstances. Obviously, the reasonable use of force instruction would only relate to the taser, not the gun. So it won't constitute a complete defense to the charge, because here a person was killed by a gun. So I just want to alert that issue, and if anybody has any comments about that now, I can hear them, or I can hear more detailed argument after you get the draft.
Draft, Your Honor.
Okay. All right. Is there anything else we need to put on the record? All right. Thank you.